Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. This is just going to be a quick intro. I've done a compilation video. I went through all of Sarah's divorce paperwork in Boone v. Boone, part one, two, and three. Some of you are new, don't have the time or the inclination to go through all three of those. There's a whole playlist now, Boone v. Boone, the war between Brian and Sarah. I wanted to give you just the letters. What it ends up being is the letters and a couple of the motions just for context. Now, these letters are what Sarah wrote to Judge Dean, Michael Dean, not this judge, Judge Jackson, who came on in January. But just so you get a little bit of an idea of the unhingedness, and I think we have more insight now post text messages, like behind the scenes, all of the nasty messages that she was sending Brian on the tablet and her son, unfortunately. So, yeah, enjoy. Oh, wait, let me run the intro and then enjoy. Give me 1 second. Thank you to everyone for watching. Thank you to the members for your support. Thank you to everyone who buys me a coffee. I try my best to respond either with a text or a video. This week has been a little wonky, so if you haven't gotten a thank you, know that I'm grateful for you. Today is the 16th of May. I will definitely respond to you individually. It's just been a little much for me this week, but I am grateful for you, as Sarah would say, nonetheless. Brian, I believe at this point has had enough. He's ready to set up some boundaries. He's tired of whatever little Miss Sarah has going on in her head. And he is like, listen, I'm about to take some names and kick some booty, as my mother would say. So here we have this. This was on May 1. So it looks like, so she wrote it on May 1. It was filed with the clerk on the 16th. What it looks like to me is that once this new attorney, the Martell law firm, signed in for Brian, they filed a paper. They want to modify the parenting plan. They want to modify the payment plans, right? So they sent Sarah a note and she writes back to the marriage division of Orange County Courthouse regarding the marriage of Brian C. Boone, Sarah K. Boone. She's still going by Boone, even though in her, what was it? The settlement agreement, she was going to change her name. Okay. Dear Sir, Madam, I am writing in regards to a summons I received for 2222 stating a lawsuit has been filed against me in the aforementioned matter. As instructed, let me make sure, am I sharing the right one? Oh my God. Okay. As instructed, this letter will serve as my personal, individual written response to the supplemental petition, joint stipulation, and notice of appearance included. I am in the process of trying to obtain a representation for this and diligently working day by day, doing the best I can, and am literally able with the little to non-existent resources I have available. Please know, with great emphasis, that I am doing everything possible to defend and protect myself as a person and a mother foremost while incarcerated temporarily. I have nothing and no one to help me as both my parents, grandparents, aunt, and uncle are deceased. I have an older brother who is unable to be located. Have you looked in prison, Sarah? And a younger brother who is currently deployed in Africa for the Marines. Now, mind you, this younger brother has a wife and I believe at least one child. So they're not close anyway. Do you know? I also have no counsel of any kind. I remember in my hometown, I would go by my oldest brother's girlfriend's house. during lunch from school, and she would make me lunch every day. I didn't need my brother to be there. She would just like make me up, fry up something, and I'd be like, anyway. So that just tells me even if unless they're all deployed in Africa, I'll be fair to Miss Sarah. Maybe the whole family went to Africa with the brother. I also have no counsel of any kind. Per the summons packet, I have tried to contact a referral service and legal aid via phone with no success due to the numbers being unauthorized in accordance to the rules of OCCD. Why does she think the judge cares about that? Like, is that for sympathy? Is that for stupidity? Is that just to be saying things? Because the judge doesn't control how the phone numbers work at the correctional place. I just remembered one of you guys works at OCCD and reached out, and then I suggested a time and I didn't even check. So if you responded, I'm sorry. I'll get back on my email. It's been a little crazy. I am working expeditiously to find an alternative way to contact and figure out some type of facilitator in the meantime. You see what I mean? She took all the time to write all of that. Like, make yourself a note and then just do it. You don't need to tell them. It just makes it, I don't know. Have you tried writing them a letter? Like you're writing this letter. Write a letter to them and say, hey, I'm incarcerated. Who do I talk to about representation? There's got to be some kind of system. You can't be the first person incarcerated who needs an attorney. Your patience is greatly appreciated. As said, I am doing all I can to stress my dedication as well as seriousness to this matter as a concerned parent, and how it is of the utmost importance to be rightfully conveyed and understood as the very competent, caring, loving, hardworking, determined person that I am, and whose mental ability to co-parent. I don't know why she put that in quotations. It's two words, right? Mental ability. She's not saying mental ability. I think this is a space in here. To co-parent is undeniably obvious and without any doubt should be included in the ongoing nurturing of our son. What? Okay. Undeniably, her mental ability. Is it undeniably obvious? Girl, you were drunk. I mean, I wasn't there, but what I'm hearing of the two witnesses, you being one, Brian being the other, I'm hearing you might have had a little bit of a drinking problem when you were co-parenting, despite the parenting plan that says not to drink around him. Okay, my decisions, ideas, opinions, feedback, rules matter. To who, Sarah? Who do your opinions matter to? To be excluded in any way just because of my current temporary circumstances. Temporary in jail, permanently locked up, ma'am. My temporary circumstances and location is wrong, unfair, and unacceptable. It makes absolutely no difference where I am. Jail, space, Australia. I am not and will never be useless, especially to our son. I'm pretty sure space, it's going to be hard. Australia is going to be hard. Just the time difference, like where in space are you going to be? And what's the time difference? Like if there's an emergency, are we contacting you? Australia, there's the whole accent thing, also a time difference. I kind of feel like location matters just a smidge. I am not and will never be useless, especially to our son. I am still his one and only mother who loves, cares, and adores him beyond measure. Now remember this, adores him beyond measure, and make his safety, mental, emotional, physical, and spiritual well-being my priority and will for the rest of my life. Now, this is the same woman who was leaving the son at school. His pickup time was 3:00 and he was still waiting at 3:45 with no sign of you. That used to be my pet peeve of being picked up last. And then that was also my daughter's pet peeve of not being picked up last. So I don't feel like that is emotionally scarring. Okay, I will never stop being his mother and using my God-given talent and rights as his mother to remain so. God gave you talent to be his mother? Because I'm going to say that that's not where your talents lie, ma'am. One obscure, unfortunate incident does not define me as a person or my entire existence. I am 1,000% sure if you kill someone in a suitcase and then pretend like it was an accident, that is an existence defining. Maybe not your entire existence, but like you're always going to be known as the suitcase killer. I want my son to know and show him I am always willing to exceed any limitations placed upon me, except for things like the law and like not assaulting people and confining them against their will, placed upon me that would hinder my relationship with him as his mother and being included in every aspect of his life, then, now, and future. So you're saying you were thinking about your son on the 23rd of February in 2020 when you were drunk off your ass, locked your boyfriend in a suitcase, and berated him and recorded him taking his last breaths. You were doing that, every aspect of that. You didn't like see that how it would hinder your relationship with your son. I just want to make sure I'm understanding you, Sarah. Who is former husband to assume and think his sole decisions are the best, fairest, and most successful for our son? Now, I don't know where she got that from. That's a lot. I just don't see Brian writing that I think my sole decisions are the best, fairest, and most successful. Like, do all decisions have to be successful? Oh, I skipped this part. He is my life. All that's underscored. I have God, my giving heart, functioning well above average brain, and bold voice. Oh, wait. Is it a bold voice or is it a bold voice? To be my son's best advocate as well as my own. I matter. If needed, our son should be included and asked his thoughts of his father attempting to remove my right in being his mother. So that would violate the parenting plan, and only ever able to ask about his video games and what he had for dinner. Nothing of moral value or life defining. To be fair, I don't know about you guys, but I don't have like every phone call I have with my mother is not life defining. Or of moral value. Sometimes I just want to know how she's doing, see what she's up to. Um, Anyway, I am not the worthless, mindless, heartless, unproductive, non contributing, poor, and pitiful footstool he would like me to be and tries to make me out as to others. It makes no difference where I am, it's who I am. Son's mother, now and always. And again, one incident does not define me or my entire existence. I have so much to offer in so many ways, and it would be extremely detrimental as well as a great loss to not be able to continue in this shaping of our son and his very extraordinary life. Is for me husband is oh my god, I did that again. Is former husband able, I don't know why she just doesn't say ex-husband. Is former husband able to handle the consequences, burden, and heartache should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success of our son? And inhibit the absolute success our son could have been or had. Now she's laying a guilt trip down for a decision Brian hasn't even made. So futuristically, as she likes to say, she's predicting that some decision that Brian made will jeopardize or harm an outcome for their son or inhibit the absolute success that he could have been or had. We're not responsible for our children's success, just like we're not responsible for their failures. Like, we teach them the best that we can with what we have, give them the tools to then make good decisions for themselves. How will this sole great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same? How could the judge answer that? How could the judge possibly know about Brian's mental ability in the future? Is there a predictor for that? Is there a test for that? In all instances, scenarios, and situations, his mental ability. How will that sole great responsibility affect his mental ability? Well, we hope he'll seek counseling if he's struggling, right? Because your mental ability says that we can't vouch for that. I think the only reason why you've had so much access to your son is because Brian is quite generous and caring and willing to kind of, pick you up, enable you to some degree. But it sounds like he's not having it anymore. That is why there is, which I think she means are, two parents, both to broaden all horizons, outlooks, and futures for their children. And in which I am so desperately fighting now to continue to do for mine, and all for the right reasons. I don't know what is happening in jail that's going to help you broaden his horizons. Because I think of broadening horizons as taking my kids on trips and traveling, and even like museums, like culturally broaden their horizons. Jail's not a place I would send them. Or someone who's currently in jail is not someone I would send them to for lifelong guidance. I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only minute life resources out of bitterness, greed, and spiteful opportunity. At my weakest, broken, most vulnerable moment, he is attempting to take full advantage of such with this unwarranted, vicious attack, thinking, hoping, and assuming I will wave a white flag, which I do not own. Especially when it comes to my son. He is wrong in doing so, knowing fully the playing field is not and has never been even. All odds are against me due to my monetary restrictions and lack of a support system. It is illogical and futile to try and have a conversation or discussion that is real, rational, or legitimate with former husband about anything. Then, during our marriage, and now. Oh, I see what she's saying then. I got it. Okay. His superiority complex and ongoing dishonesty have made it very difficult and sometimes impossible to work with him. This in turn has compelled me now to bring to attention some of my concerns in this egregious decisions he has made prior and during my incarceration, as well as from my son personally stating Dad's laziness, empty promises, and disappointments. Son knows without any hesitation or doubt I will do anything, anytime, anywhere, all within reason, to help him, which is why I, his mother, have been his go-to person in many ways for many things throughout his life, including while being incarcerated. Former husband is penalizing me because I care nonstop and have regular ongoing concerns, questions as our son continues to grow that are important, needing to be discussed. That grosses me out. Like, is she calling for her 15 minutes at a time on the collect call jail thingy and like wanting to have meaningful, deep conversations about the rearing of their son in between begging for food and whatnot? And she thinks that Brian is bitter, has greed, and spiteful. This is his opportunity. How is he being greedy? By holding on to the money that he makes so that it can be spent on the son instead of sending $1,000 of alimony. And he definitely shouldn't be sending any child support since he's the one supporting the child. Do you know? Like, what is wrong with this woman? At my weakest, broken, most vulnerable moment, he is attempting to take full advantage. Never mind, she murdered someone, and that's why she's perceiving herself as at her weakest point. That has nothing to do with Brian. Brian should make concessions with the raising of his child because the mom committed a felony. Like, no. No, and you should get a white flag. You should surrender all things because your brain has surrendered. So let your body follow. Oh my God. And she's saying he has a superiority complex, but she can do no wrong. This in turn has compelled me now to bring it to, oh, I read that part. As well as for my son, Dad's laziness. He knows, including while being incarcerated. Former husband is penalizing me because I care nonstop and have regular, oh, Yeah, I wrote that too. Our son can and will grow better, stronger, brighter, with my decisions included, also, as they have been since I brought him into this world. Now she's pulling out the coochie card or C-section card, however he got here, since she brought him into the world. You didn't do it by yourself, ma'am. It takes two. It takes two to make a thing go right. Former husband and I did this together, and I may be obsolete to him, but I am not to my son, nor will I ever be. So stop trying. I feel like she should have said, know that, nor will I ever be. Know that. She's switching it up though. So stop trying. When trying to speak to or with former husband and have an opinion, idea, belief, feedback, etc., that is not in line with his or his parents, I have been laughed at, completely ignored and disregarded, given the silent treatment, berated and made to cry or hung up on. Most every time in front of our son. So if they're on the phone, how does she know the son is there when that part is happening? Number one. Number two, I feel like she's bulking these up. Completely ignored and disregarded given the silent treatment. Those three, I feel like that's one thing. They just didn't answer her call. So therefore, they ignored her. They didn't answer her call. So therefore, they disregarded her. They didn't answer her call. So given the silent treatment. I know she's not expecting her former in-laws to be writing letters to her. So yeah, they just didn't take your call, ma'am. And then when they did pick it up, they berated you and made you cry, or they hung up on you. So maybe stop calling them. That's just me. Look out for your mental health, sis. This to me is setting a poor example of how a man, husband, should treat a woman, wife, on top of being a bully. So I don't think it is any sort of example if they're just not answering your call. If they're berating you, fair enough. That's an issue. I don't know what they're doing to make you cry, and it's hard for me to feel sorry for you because you made George cry. So maybe you're getting a taste of your own medicine. He hears me being told. Wait, this is. Sorry. Son sees how former husband, his father, treats, degrades, and judges me, his mother. And now she's gone back to capitalizing mother, but lowercase f is what she's doing for father. This is extremely confusing and sad to our son, as he knows I only discuss, or try to, anything that pertains to him. So I think all of these pronouns are in reference to the son. So the son knows that she only discusses anything that pertains to the son, or tries to. But she's going to contradict herself, because in a couple of letters, she's going to be like, oh, I asked him for a hot meal, or he read some mail for me, or none of that is things that are directly pertaining to him. Whether she gets a hot meal or not ain't got nothing to do with her son. He hears me being told indirectly, I am unimportant. This is unacceptable, damaging, and mean. Also, having lasting effects. An inherited trait led by example of his father, and serves no purpose, quality, or value. A bad decision. So the trait is not a genetic trait. It's a trait of, I guess, what do they say? Nurture versus nurture. This would be nurture by example. But I'm not sure what the trait is. Ignoring her? Anyway, a bad decision. What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out. Says the woman who put her boyfriend in his suitcase and zipped him up and refused to let him out. She is complaining that her husband is trying to sweep her in a dark, bleak corner and keep her there, hoping she finds no way out. Projection? The relief he is seeking means to remove any additional work, trouble, effort, concern, responsibilities, etc., which would make former husband be the reliable, caring, consistent, honest person he should be. Now, especially to our son, and who I always wanted and needed him to be when we were married, possibly altering the current situation for everyone. So now she's blaming Brian for her being a murderer of her boyfriend. If only he had done whatever it is to her son that she needed him to do when they were married. Reliable, caring, consistent, honest person. He seems like he was the reliable, caring, consistent one in your son's life prior to your arrest. So I'm going to say he's not responsible for you murdering someone, ma'am. If I have no authority, power, or control, there are no discussions or interactions of concerns, ideas, plans, future our son does and will need involving both parents, me, the other parent included. You know how I know she doesn't care about this? She would have taken that deal. She would have taken that plea offer. She would at least get to see him before he hits 30. You don't care, ma'am. You just want the control. Not only am I continuously disrespected, I am verbally threatened with some form of this looming lawsuit in former husband's original verbal threat made sometime last year, early 2021, to take away my parental rights and funds necessary for my quote-unquote livelihood while incarcerated. Ma'am, he's not responsible for providing you the lifestyle to which you have become accustomed in the free world. He's not responsible for helping you get that while you're incarcerated. After my sincere, heartfelt begging while sobbing to him while on the phone in the middle of my dorm and my desperation asked why he was doing this to me, fully and completely knowing I have nothing or no one and how meaningful it is to me to be called son's mother. His response was simply, "It will make you say yes now. If you keep doing as you have been, everything will be fine." I don't know what that means, guys. But I know she's in there acting a fool, begging in the dorm for money. I have been saying yes, as I've had no choice if I'm even asked anything to be able to answer. I am unclear, as usual, when dealing with former husband of his behavior with these new revised threats and demands that I have not already submitted to previously seen or even knew existed until now being served. She's unclear as usual when dealing with anyone. I'm sorry, it's not just the former husband. So if it's either everybody or it's you, Sarah. I will not be erased or downgraded to nothing because former husband is bored and bitter. Totally unfair, and the cruel ego trip is disgusting and nothing to be proud of. What is the point? There's nothing left other than my dignity, which he'll never have. Girl, you don't have it either. You over here begging in the dormitory. What would occur? What would our son say? How would he feel knowing the truth? Now, see, that right there is a passive aggressive, thinly veiled threat. How would he feel knowing the truth? Well, how would he know this quote unquote truth? It's your truth, Sarah. How would he know that unless you told him? And you would be in direct violation of the parenting order. And what would you be telling him exactly? That dad wants to have rights so they're not tied to you anymore? Please know I still have numerous other legitimate concerns needing to be addressed in the petition and personally, and should be by any decent parent slash respondent. This is not a one-sided attack, and await the opportunity to clarify my specifics if slash when needed. I, the mother to our son, believe said concerns are very important. We've gone over into the margins here. I don't know what's happening. I realize also this lawsuit may be my only opportunity due to my restricted resources to have them handled and hopefully remedied professionally, positively, and fairly. I am praying I can be heard, seen, and included by this letter in the ongoing proceedings, meetings, discussions, etc. Futuristically, I am hoping also to have some type of representation to amicably bring this matter to a concrete conclusion, being beneficial to everyone. A copy of this letter is also being sent to legal aid for review and assistance. In the meantime, I am still mom with my mom rights, quote, end quote. The level of this lawsuit is unfair, unnecessary, and uncalled for. This lawsuit is also from one monotone side of former husband. I, the former wife, capital F, capital W, have a side also, intellectual, willful, and valuable, deserving to be heard. I am also, so her side is intellectual, willful, and valuable. His side is what? Unfair, unnecessary, and uncalled for. I am also fully dedicated and devoted to my son, and his rights, his uninfluenced feedback should be included, and it is only fair to him to know the extent of the situation and the cruel attempts of his father to his mother. So you think he can step in, Sarah? You think the son, who's what, in 2022, oh my God, what was he? 12? So you think the 12-year-old should weigh in and determine if what his dad is doing is unfair? That it's cruel, according to you? That's what you want to tell your son and have him weigh in on it? No one can tell the future or assume to. I was unaware former husband had a crystal ball. I have faith and will always. This being something no one can take from me, even. No, oh, ever. No one either is better than anyone in this or ever. And money can't buy everything, especially love, grace, understanding, and goodness. She has no money. She has no love, grace, understanding, and goodness. What happens here? What happened? If former husband is willing to have a rational, reasonable discussion, however mediated, I am more than willing and welcome. If there is anything else I can do to show my very good intentions, other than writing this letter expressing my desperation to continue to be included in my son's life, my understanding of the emergent need of counsel, and sheer hope of a resolution, I'm also willing to submit to a competency test or any kind of test to show my capabilities mentally and full ability to co parent. I am not the ridiculous one. I think she means ridiculous, but she spelled it RED. Ruthless, degenerate felon, former husband slanderously assumes I am. Well, now you're a felon, ma'am. But I know it hasn't come yet. We're still in 2022. Enjoy it while you can. I love my son immeasurable and have a limitless abundance of positive, meaningful, solid, contributing life characteristics to share. Name one, Sarah. One positive, meaningful, solid, contributing life characteristic. Just one. I can't even think of anything you've been positive about. You lord everything over everyone. You're vengeful. You hold things that you've done for people against them like they owe you. To share and have my son inherit from me, which is priceless. If he's going to inherit them, he already has, ma'am. Unless, you're talking about epigenetics and how they're going to present based on your external influences. Whatever it is, it's already happened though, which is priceless. I can co-parent. I want to co-parent, especially if former husband is going to positively participate and understand rather than pillage and point fingers. A mother is her son's first love, in which I very much and with every fiber of my being want to still be. First love is always your first love. Like, people can't take that away from you. So if you were his first love, you'll always be his first love, just like you can't lose your virginity twice. Well, per location. Thank you for your time and reviewing my formal written response in part to the petition. I'm grateful for your understanding and hearing my side also, which is only fair and right to do. This is between both parents. I await your response and instruction. Please do not hesitate to let me know if anything further in my ongoing, unreserved cooperation is needed. I am still in this, still a person whom former husband was married to for 13 years and has known me for more than 20. Most of all, I am still the mother of our son and still important in anything / everything pertaining to him, come what may. Sincerely, Sarah Boone. That was sent in May of 2020. We're going to go to July 17th of 2022. Sorry, I think I said 2020. You guys know what I mean. July 17th, 2022. It didn't arrive to the clerk until August 29th. Judge Michael Dean. regarding Brian Boone, Sarah Boone. Judge Dean, after coming back from an outside medical appointment for my cancer and surgery, I really wanted to call my son to hear his voice and brighten my long, arduous day. In doing so, he was checking the mail, telling me I had a letter from you and wanted to be helpful and read for me. Who believes that? He wanted to be helpful, or you were like, oh, honey, I need that. It'll take forever for them to send it to me. Can you just open it for me and read it? The document was an order to dispense mediation, stating 1, the order was granted by you. 2, parties can move forward, meaning former husband and his attorney says, I'm just told what to do and have no representation. The case is set for trial. When? And number 3, the court remains over jurisdiction in this instant case. What does that mean? So for us, that means that even though that it can go straight to trial, there's not going to be a mediation. He's given permission to set the trial date, and this court will remain over jurisdiction. Will oversee. You guys remember Darrell Brooks, although he said subject matter jurisdiction, subject matter jurisdiction on the record. Whatever he said. Anyway, so they would deem that court would still have, and the instant case is the one that we're talking about at this instant. When my 11-year-old was finished reading, his response was, I'm sorry. I don't know what Dad's trying to do now. I'm sorry. I don't believe that. Why does he think that something is wrong from reading this? To dispense mediation and proceed. Why would the child feel like that was something negative unless mom said something? I think her baseline is so warped that she can't even, like, she tells on herself without realizing it's a bad thing because it's just like that's her normal. Do you know? Like her brain is like, oh yeah, that's normal. Have my son be involved in my marital business and court dealings. I myself am trying, and then she has I don't know what Dad's doing. Like this, even the son feels sad for her when he shouldn't even be involved in it. Okay. I myself am trying to figure out what new underhanded terror he's attempting. So I decided to call him directly and ask. Or is it 1? I don't know what that is. It looks like she has like a wet tip pen in this one, so it has all those dots, and I think she's writing on both sides. Oh no, the margin is I don't know. Anyway, why was this sent to him and not me, the other party? So now she's telling herself, why was it sent to him? Because before she said it was sent to her, but to their address, right? Let's just go back. In doing so, he was checking the mail, telling me I had a letter from you and wanted to be helpful and read for me. Now, over here, she's claiming, why was this sent to him and not me, the other party? Well, allegedly, they're sending your mail to him. Or did you have your son open up his dad's mail, breaking federal laws? What else am I not receiving or being informed about regarding this matter? 2, why did he not communicate anything to me or with me during any of the multitudinous phone calls we've had since this order was granted or prior to even being generated so this could be avoided? Because he is an attorney, ma'am. So your multitudinous phone calls to the house are not about this legal matter. He doesn't have to discuss any of it with you. I call almost every day to speak to my son, then call former husband during the day while my son is at school to try and attempt having reasonable conversations / discussions about personal matters such as this. You don't have any personal matters, ma'am. This is a legal matter and you need an attorney. Like, you can't just call him up and talk about this case anytime that you want to. And isn't he working during the day? Anyway, I am trying to alleviate any additional difficulties and am constantly coming up with solutions in everything to work with former husband to complete this process in a positive, fair, and accurate manner. How can this be done now the mediation has been dispensed? Both parties could have figured something out instead of just canceling completely. Former husband could have explained his intentions to help understand my circumstances better in being unable to choose a date for mediation 4 months in advance on top of my cancer, on top of my trial. I simply asked for help from former husband and his attorney and yourself, Your Honor, to provide information so I could choose even if the date had to be changed. I, the other party, was bypassed and ignored completely with no explanation from anyone. I wasn't even able to respond in a more timely manner because I never received the order or knew was granted until my son happened to check the mail that day and read it to me. This mediation is all I have to be rightfully heard and utilize my rights as a mother and human being to be seen in a clearer light, not as the one sided, ugly, unfair, slanderous everything said by former husband. I attempted to be professional and correspond with everyone. I explained my situation and simply asked for some important documents to be better prepared, as this would probably be my only opportunity to make myself count in all of this. I asked how to set up a video and asked if face to face was an option. Girl, they're not coming to the jail. My requests and questions were all in an attempt to choose a date and schedule this much needed, very important mediation. So they dismissed with the mediation, which Brian had asked for, and I think I skipped one. We're out of order, but it's okay. They sent her a note requesting what her schedule was, and she hemmed and hawed about it, and so they petitioned the judge or requested, they put in a motion to dispense with the mediation, and the judge granted that. Like, girl, we don't have time to play with you. She didn't want to give them a date. She had a bunch of questions and basically was saying she couldn't do that until she had her questions asked. My requests and questions were all in an attempt to choose a date and schedule this much needed, very important mediation. I included you, also Judge Dean, after being instructed by former husband's attorney to correspond to him so you would know my attempt, request, and willingness to cooperate, as well as my eagerness to complete. I simply asked for paperwork. She's now throwing the rock, hiding the hand. She's threw this thing. I need this, this, and this, and this, and this, or I'm not going to answer. And then when they were like, okay, fine, we just won't even do that. And then she's like, I was just asking for a few things. I don't understand why we've just gone around me completely. I'm simply asked for paperwork to review as I do not have any, and I am being accused by former husband of being difficult and uncooperative by not signing documents I've never seen or knew existed until being served with the summons notifying me of his means to take all I have left other than the marrow from my bone. Really? Bone marrow? Marrow? He's taking your bone marrow, ma'am? Please understand, I never said no or that I was not going to schedule, but you didn't say yes and you didn't schedule. I want to be at my best possible with all the information for my review beforehand, as would former husband be and his attorney, but not myself unless I requested. Why am I being penalized for wanting to be prepared? Why was no explanation or reason given or discussed for canceling the mediation? Why was no attempt made to make sure I, the other party, and the other parent was included, along with everyone else, to have the same understanding of what was happening? She feels deeply inadequate, and like people are marching around her, so that's why she's just striking out with all of this stuff. Not realizing, I mean, she realizes to some extent she was withholding and then they moved around her, so she didn't like that, so now she's begging. But clearly she expected to stall proceedings. She was going to ask questions and drag her feet. Otherwise she could have given a date and then all her other questions could have been answered timely. Do you know, there's no reason to keep delaying the scheduling of it. To have the same understanding, why was my copy of the order not sent to me at my current location, instead to former husband, who already knew since he was the one who generated the plan? How would I have known any of this if not found and read by my son? Completely unfair and wrong. I am being penalized for doing everything I am supposed to be doing, and for my attempts to show my heartfelt desire and determination to be a part of this, to rightfully be the other party. If I have to go through this too on top of everything else, I will and am. It should not be held against me to correspond, make my basic requests, and ask questions, to choose the correct armor of choice for this mediation and ongoing battle. That is already why nobody wants to have a mediation with you. It's you don't need an armor. There's no battle in mediation. That's why you're having a mediation. You're just gonna have a nice, friendly conversation, negotiate some things. Girl, take your armor off, so I can confidently explain myself and fight for my rights and to be the mother I am and will always be. I asked for nothing out of the ordinary. Only any caring, competent mother slash human being would not themselves ask for in a situation as mine. It's hard to say, Sarah, how many people are in jail waiting trial at this time for putting their boyfriend in a suitcase and murdering him while taunting him and filming it. It's hard to say if someone else were in that situation, would they be behaving like this if their ex-spouse wanted full rights to their son because she's incarcerated. Also, in the letter to me from former husband's attorney providing me mediation dates to choose from, 7/5/22, have you seen? It specifically states, please respond to this correspondence within 20 days of receipt with your preferred date and attendance method. Otherwise, we will unilaterally schedule the conference and send you the details. I did. And I did with my request to help give me a better understanding. So she never responded, to be clear, with the date, um, preferred date and attendance method. And then she expected them to unilaterally do that, and I guess they didn't. So why wasn't this unilaterally scheduled as stated? It was canceled. Would it have been better on my part to have just not corresponded at all so this mediation could have been unilaterally scheduled? Because you didn't in your note say, please unilaterally schedule it. You responded with all these questions and stalling. Like, I feel like that's pretty clear. I feel if I had not made my willing and eager attempt to abide by everyone's rules and played the part of the terrible lowlife inmate former husband and what seems to be everyone else wants me to be, I would be preparing, reviewing, and working around this unilaterally scheduled mediation. I do not understand, and no one has made any attempt to help me to. You don't understand because you don't want to understand. The world does not revolve around you. That's all the basic thing that you need to know. You just don't want to understand that. Right? So nobody was going to play your stall tactic games. They gave you clear directions, respond with the date and time, or if you don't respond, it will unilaterally. Well, you didn't do either one of those. You sent a snotty response without answering the question, and so they didn't want to deal with you. Surprise, surprise, surprise. Do I still have that in my this is a good time for that if I still have it over here. Oh my god. Cuz I need me some surprise, 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 surprise. Surprise, surprise, surprise. I don't think it made the sound, but anyway, it's okay. It still gave me the same effect. um, so honorable Honorable Dean, please understand this mediation is everything and can help ease the ongoing pain of whatever former husband's daily terror is he chooses to inflict. Makes me beg pitifully for pictures, which I still have not received. Has me call every week to ask for commissary funds so I can purchase necessities and sugar for my glucose concerns. Then says no, refuses the occasional hot meal on a Sunday. I was made to cry over a cheeseburger when explaining to him the amount of weight I am continuously losing weekly due to being sick. Girl, we out here cannot see it. I know the camera adds 10 pounds, but ma'am, you looking bigger than when you went in. I'm not trying to body shame. I'm just saying you're okay. You're not losing weight. And thought this would help me gain by eating. I was still told no. He just said no, you don't keep asking. As far as I am aware, the dissolution of marriage agreement regarding alimony, which I did sign, is still and has been in effect, meaning I have funds available to purchase the aforementioned and had been doing previously with no problem, conflict, or difficulty. Everything was non-confrontational and smooth running until former husband implemented or tried to these inaccurate, unnecessary modifications. The relief he is seeking could have been avoided until he decided to involve our son and my maternal rights. Again, one obscure, unfortunate incident does not or will not ever define me. The incident she's talking about is the murder of her boyfriend. I don't know how that's, I mean, it's definitely unfortunate for him, but it is, you're going to be held accountable for it, man. Who am I? And it makes no difference where I am for a former husband to think I am unable to make meaningful, moralistic decisions involving our son. The moralistic is kind of questionable, even before the murder. I mean, the drinking, the no job thing, not really, upstanding citizen, productive, contributing member of society. It's not giving that kind of vibe, ma'am. Regardless of my circumstances, this mediation will allow a just and fair opportunity for both parties to be equally heard. I can make everyone aware I am someone and worthy, most of all, for and to my son. Please, Your Honor, please allow the mediation to be scheduled. Please take into consideration everything I have graciously said and explained. Are you supposed to say that what you are doing is you've done it graciously? Don't you normally say, and so graciously let me stay at their flat while I was, in London or whatever. I don't think you're supposed to say that you did something. Anyway, um everything I still want to say and have a right to. Please, or provide another suggestions with some kind of facilitator to give a neutral opinion. I'm pretty sure the judge is also a neutral opinion option, and assistance to both parties to work together. They tried to work with you, ma'am. Two parties, two sides, two voices. How else can I be heard, seen, or accounted for? I too have defining points for discussion, and my understanding was this was part of the reason for mediation, to aid in a fair, reasonable outcome for both parties, for compromises to be made, not controlling demands. Specific details need to be discussed regarding all of the agreements, as some I have not even seen. The supplemental petition for modification of final judgment and joint stipulation for modification, the most recent. What is their pre-modifications for all? I don't know what that means. This being why I requested these documents. What is their pre-modifications for all? Petition for modifications. I don't know. I know he wants to modify the parenting plan and the payment arrangements, which it says in the documents that can be done, that is appropriate as circumstances change. In summary, so because I have nothing and no one, former husband having an attorney, multiple monetary resources, a familial support system, also with unlimited resources in every way, I am to just accept defeat unfairly and be okay with everything. I am to just accept defeat unfairly and be okay with everything. I just said that. I am saddened how the justice system is so unjust and unable to help people as myself who were once advocates for. I voted in jail and raised to believe in the safety, indivisibility, goodness, and truth of, and what honor is supposed to be, and where it can always be found. At this point in my life, I am severely disappointed. What do I have to say? Anything to say different or show for? What do I have to say? Anything to say different or show for? I don't understand. Where is my testimony? It really is just. I've communicated with everyone, tried to explain everything, i.e., I have tried to manipulate everyone, and I am desperate. It's not working. All of my normal tools and tricks are not working now. I have no access to a computer to check my status in this or documents being filed, no access to make viable phone calls to worthwhile agencies asking for any assistance due to unauthorized numbers per OCCD rules. I can't even contact former husband's attorney to ask my questions and voice my concerns directly. You shouldn't be talking to him directly, ma'am. You need to get an attorney. He can't give you legal advice. I've written so many letters. I've lost count. I've tried everything, still trying in every way. What else can I do, Judge Jean? Please allow the mediation. Please help me in however you can. Please don't show me where to sign former husband's unfair, incorrect paperwork. Any act of kindness, no matter how small, is ever wasted. Aesop. Is that like Aesop's fables? Anyway. Thank you for your time, review, and understanding. For future reference and correspondence, please make sure to use my address as follows. Why would Judge Dean be writing to you, Miss Boone? Why? Please be fair and see my point of view and determination. I tried desperately every day to come up with solutions for and in everything. Girl, for 4 years, were you in there trying to come up with a story that made sense? Because that did not happen. Anyway, you're only at 2 years at the writing of this. The reason I'm again contacting you directly, hoping and praying you are able to use your right, proper, and unprejudiced judgment and authority to help someone as myself finally have testimony to the struggle. The struggle is real, Judge Dean, which I am and have been long overdue for. I patiently await again. I am grateful. Thank you. Sincerely, Sarah Boone. And then this is the last page. They just scanned it in there. Okay, I have gotten something out of order then, because there was another letter. Let me see. That went to Sarah. Did I read the dissolution? I knew I should have made a little check mark, a little checklist. I have them all open in order, but give me 1 second. So that was the marriage thing they sent her on May 1. Then on July 17th, she wrote that one. Oh, what is the date on this? This is July 26th. So this was filed on 8/11. I should have put them in that order. These other letters that she wrote, even though she wrote them on July 17th, they didn't get logged until August. One was, they're both 8/29. So we're going to skip this and go here, and we'll go back. Sorry about that, guys. I meant to do this one before that last letter. So order on motion. Actually, hold on, because now I remember what I wanted to do. Okay, I think I found it. I realized there's 2 that were dated the 17th of July in 2022. So this is the letter that she wrote to the attorney, right? They sent her the notice. We don't have that notice, but saying, hey, we'd like to set up some mediation with you. Give us some dates, some times, starting the week of yada, yada. And, we can get this thing on and popping. So she came back on the 17th. Mr. Martell, I am in receipt of your letter. Let me make sure you guys can see this. Yes. Okay. I am in receipt of your letter requesting a date to be set for former husband's petition to modify, but have a few concerns and questions before doing so. First, I would like to make it known I've been diagnosed with cancer and I'm awaiting outside professional medical consult and treatment options. Second sentence of the first time ever meeting Mr. Martell, but I'm sure Brian warned him. I'm sure. So he's not shocked. He probably had a little chuckle with Brian about it later. And I'm wondering if Brian knows that she has it as well. She's looking for sympathy. I mean, I know she's probably sensitive because her mom died of metastatic breast cancer. So I'm sure she's heightened. I don't want to make light of that. But I feel like for Sarah, it's another tool for her to garner pity, right? Like, oh, here's something else that's going wrong with me? Feel sorry for me. So she's been diagnosed. I do not know the level of severity, duration of time, or outcome for any of this, nor the effect it will have on my case, which I am currently incarcerated for, or the case at hand with former husband. So she's newly diagnosed, right? If she doesn't know the severity, duration of time, or outcome, so they haven't even given her a guesstimate. Like I know my mom went through cancer in 2020, and so they gave us, after they said that she had it, then we had to figure out like what level it was, what type of treatment she was going to have. What did they think? They were super aggressive with her. She's fine now, by the way. They were super aggressive with her, and so yeah, but you don't know those things until after, they do another biopsy or part of that biopsy, and then they come up with the treatment plan. And obviously it has to be flexible depending on how your body responds. So, like my mom did chemo, but she didn't do what's the other one? I can't remember. She just had the IV. It was actually up here. Radiation. She didn't have radiation. Where I've had friends who were their spouses have had only radiation and not chemo. So long story long, sorry, instead of long story short, she's early in there. And we saw that in her behavior notes as she was going out. She eventually had surgery. Remember when she got the 2 pillows for surgery that she then stapled together long after she was meant to have it? Anyway, I will link that in the iCards, the bad behavior reports. It's the long one, but I'll link it for you. And then she says she doesn't know how it will affect her current case. Like, does she think they're going to let her out on hospice if she's deemed terminally ill, so there's no trial? Like, no, ma'am. It's going to happen as it's supposed to. There's going to be a trial if you don't take a deal, and if you don't win, you're going to prison. It's almost like she's mentioning her current case, also for sympathy, right? She doesn't know what's going to happen with it. Like, I've got so much to worry about. Ma'am, you murdered someone. Knock it off. Okay, as said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from, which you have proposed. Just pick a date, ma'am. Like any of us, where we would just pick a date. If something happens and we can't make it, we reschedule, but you pick a date. You're refusing to pick one of the dates because no one has a crystal ball. That's what I got from this. With that being said, my concerns slash questions are as follows. One, what are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? Please provide documentation so I can understand the practices, procedures, and protocols for this area of family law and can abide accordingly. I can also have a general timeline of what to expect, if possible, other than a letter from your firm telling me what I have to do. So, loud and wrong. Here she is asking for a favor, right? Basically, she's asking him to provide receipts for her to understand the letter that he sent her. She can Google requirements under Florida law. He's not required to provide her the law or to tell her the law. One would argue it would be a conflict of interest since he's representing her former husband. That would be a conflict of interest for that attorney to be providing medical advice. Or not medical, but legal advice. I was thinking of her cancer, to her. And procedures and protocols, like that's not his job. You're asking for a favor and you're being nasty about it. I wouldn't even respond. I can also have a general timeline of what to expect if possible. So what kind of timeline, ma'am? Like he can't create the timeline. You guys would partner together or counsel would partner together. Like, yeah, we should be able to get in front of a judge by this day, meaning you have all your ducks in a row. Number 2, please provide copies of all documents to be discussed. This is the copyingest woman. Copies are not free. Please provide copies of all documents to be discussed, which includes original marriage paperwork pre-mod to see and compare specifically what is being requested to be modified. Girl, that's something you got to get on your own. The clerk is always open and is happy to provide copies for you. At this point, you can go online. You don't even have to, like, one of your friends can mail it to you, basically. Please send contact information, location, and credentials of the selected mediator, Karen Middlecoff, Esquire. What is her affiliation with the Martell firm and how was she selected? So we're on the third thing, and she's not trying to pick a date. She's like dictating what they need to do for her. What have you done for me lately, girl? Mr. Martell is not your man. Will former husband be in attendance? Who all will be included in and during this meeting? Like, why do you need to know all that to get to the meeting, ma'am? Who is the judge overseeing this case and receiving copies of all correspondence, signing, approving paperwork / approving? Judge Dean, ma'am. Is there going to be an agenda for discussion during the meeting to be received in advance for preparation and review? You're going to be discussing the modifications that he is requesting. Do you have a copy of the modifications? That's what's going to be discussed. If you have some argument about why the modification shouldn't happen, write it down so you're prepared to talk, but make it factual, legal, and not emotional. No one cares about your feelings. Well, I'm sure someone cares about your feelings, but not as it pertains to modifying this paperwork related to your divorce and parenting agreement. Is there going to be an agenda? Okay, wait. What if selected dates have to be changed due to unforeseen complications or circumstances? Will I be penalized, rescheduled? Well, definitely you'll have to be rescheduled if you can't make the meeting, man, because legally you have to be there. I don't know what they would be penalizing you for, like contempt of court. I think if you told them what happened and you had some proof, not just your word, you'd be all right. I mean, what's the worst they're going to do? Put you in jail? Is the point of this mediation to try to force me into signing and agreeing to the only terms available presented by former husband? Or are my modifications going to be allowed for discussion also in order for both parties to be included in the final agreements for and with the best possible outcome? What is the best possible outcome of a modified dissolution of marriage? Like, oh my God. What if I do not agree? Question mark. Number 10, how is video conference scheduled? Will this be a private _ meeting? Is face-to-face an option? Why do you think people want to go to the jail to talk to you face-to-face? Why? Why would they want to do that? You're incarcerated. Suck it up. As I said, I do not know what date is best for me considering my current situation and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. So I'm not going to answer anything. I cannot make a decision. I need these things to be given to me to assist me in my decision making. But I can't pick a best date. And I feel like she's being super pedantic. You know, it's like when people say, have a great day. What if you're like, I don't want to have a great day. I'm just going to have a good day. Like, best. Just pick a date, ma'am, that works for you at this moment, right? Agreeing none of us have a crystal ball based on everything you know. Pick a date that you are available. If it changes, if and when, we will deal with it. We will cross that bridge when we get to it. But we're not going to stay still and not move at all because we don't know if a bridge might pop up and if we have the toll. We have the toll. When the bridge pops up, we'll deal with it. We can't just be stuck. We can't refuse to do anything until we know everything. Okay, let me go on. By answering and explaining further. Okay, we read that. Your expedited response is greatly appreciated, as well as providing all requested documents and information. So she's like, chop, chop. Your expedited response is great. Not just your response, your expedited response is appreciated. Hint. Thank you in advance for your assistance, patience, and cooperation. I'm continuing my pursuit of seeking representation and still doing everything I can with the minute amount of resources I have available. Hint, hint, because your client's not paying my alimony. Not so subtle. Hint, hint. I am not giving up in any way. So again, thank you and all who are involved for your patience. I look forward to your response. Sincerely, Sarah Boone. And she copied the courthouse, which is why we have a copy of it, and that's what went there. Okay, so that is what she sent, and then they put in the order to dispense of mediation. After she sent that letter, they were like, okay, boo, cool, bet. So August 11th, this matter having come before the court on the petitioner's motion to dispense of mediation filed on July 26, 2022, and the court having reviewed the file and being otherwise fully advised in the premises, it is hereby ordered and adjudged. The motion is granted. Either party may move forward noticing the case for trial. So that's Brian Boone or Sarah Boone can notice for trial. Since they're not going to do mediation, they're just going to go to trial. He's not going to waste his time and money on mediation. This court retains jurisdiction over the parties and subject matter of this instant case. So that's what she had quoted in her other letter to the court, right? And so then she begs for the mediation to still happen. So then we get on August 26th, this order directing Orange County Corrections to transport defendant for a Monday, September 19th case management conference at 3:30. So Judge Jean was like, okay, well, we all, let's come together and talk and see what's going on with your case. But then she writes on September, so that was September 22nd, they were going to have the meeting. So September, they had the meeting. September the 23rd, she writes this letter. It doesn't get filed until the next month, October 4th, 2022. But let's see. Let me make sure you guys can see this. Yes. Actually, could be a little bit bigger, huh? Yeah. Okay. Come on, fingers. There we go. I think that should do it. Yeah. Dear Judge Jean, I wanted to take a moment to thank you for allowing me to be in attendance during the case management meeting last Monday, 9/19. It has been such a long time since something good and real has happened to me, since being incarcerated for ongoing 3 years almost. I thank you profusely for helping me, listening to me, and having an open heart and mind to see me as a human being, a mother also. Your invaluable time, empathy, and understanding are beyond appreciated. Thank you for seeing me. I am so impressed, and my sincerest gratitude cannot be fully expressed for your kindness and goodness. I look forward to any future meetings there may be, and am confident my hard work, determination, and effort will not return to me void or fall on deaf ears. It's almost like it's an acceptance speech for a beauty pageant for incarcerated individuals. It's so transparent. Like, she always kisses their ass when she gets something that she wants. And then the moment that she doesn't, they get the wrath of Sarah. Like, she's overly complimentary. Do you know what I mean? She just lays it on thick. I look forward to any future meetings there may be and am confident. Oh, wait, I read that. I will not creep away as I continue to be brave and fight. Wait, a victory indeed in my battles in preparation for the war on the horizon. There's no war. I will not creep away as I continue to be brave and fight on. Thank you for giving me hope more than you know. It was an honor to meet you, Your Honor. See what I did there? As sorrowful, yet always rejoicing, as poor, yet making many rich, as having nothing and possessing all things. 2 Corinthians 6:10. P.S. Thank you for seeing that crystal balls don't work at all, ever. Dust catchers. Sarah Boone. Okay, so she's happy on top of the world. That was filed October 4th. And then we go to October 16th, which was received 2 days later. I don't understand how their mail works. Like, she mailed that on the 16th, they filed it on the 18th. The other one was like 2 weeks later. Anyway, let me not turn into a Sarah. We'll go to this. So, October 16th, Honorable Judge Michael Dean regarding Brian v. Sarah Boone. Starts off with a quote. We don't owe you anything and are waiting for you to be guilty so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud, the phone is distorting so loud. Former husband, his father, came in and told him to stop being mean to me before hanging up. Honorable Dean, this is what was told to me. Again, just like no boundaries. Who starts off vetching? Not like, hey, or good afternoon, honorable judge, dean. I hope this finds you well. I had a disturbing call with my son that went something like this. Like, boundaries, boundaries. Like, you don't want to just like trauma dump, thought vomit on someone. Oh, well, unless you're Sarah Boone, of course. Honorable Dean, this is what was told to me by my 11-year-old son when I asked about his best friend and how she was doing since he hadn't mentioned her in a while. He told me she started acting strange after he told her he was moving and wouldn't see her anymore. She's upset with him. The conversation continued with me asking why he's telling his friends this, as nothing is set in stone and will be discussed when the time comes. Oh, we're leaving, and it doesn't matter what you say. We have an attorney. Eventually, it turned into the aforementioned statement, and I was laughed at, disrespected, shut down, and hung up on by my son over asking about his friend. You see, this is where I turn and ask, how is this okay, Your Honor? This is exactly how former husband treats me and has unfortunately successfully passed this disgusting trait to our son. Nonetheless, how dare both of them disregard me the way they are making me feel like I am nothing, no one, worthless, and a joke. I'm sick of being laughed at. This is her worst fear, no control and being laughed at. It is really irking her. And she really wants vengeance of like, I'm going to show you. I took it upon myself not to call back and waited until the next day to talk about with former husband. Calmly and rationally, I asked him why our son spoke to me the way he did. So the fact that she wrote calmly and rationally means the opposite is what happened. Like, that's just how Sarah Truth works. So I would say hot-headed and irrationally, I asked him, but we'll go with Sarah's version. It's her story. I'm just dramatically reading it. Where is he getting the idea you are definitely leaving/moving? He's losing good friends over it. Well, that's the plan, and I figured you should start getting used to it. 50 miles can be overruled. It means nothing. That's why I have an attorney. You don't. Who believes Brian said that? Who? Who? We're just waiting for you to be sentenced. The judge knows everything, and there's not much you can do or say about any of it. You'll see. We're leaving no matter what, regardless of the outcome. What's the point of me fighting for my life with my son when I'm treated the way I am by both of them? This is a form of mental and emotional abuse. Former husband encourages and enables it. I'm yelled at for everything. I'm afraid to call for fear I will be obliterated and brought to a new level of low, or tried to see how hard I can be made to cry, then laughed at. I'm damned if I do and damned if I don't. Why would Brian waste his time laughing at you? Like, he has a whole life. You're only important to yourself. And part of your self importance is pretending that Brian cares about if you cry or not. If I do continue in my fight, which I will and am, I'm disrespected and almost destroyed. If I don't, then I look like the uncaring, heartless, incompetent mother slash person former husband is hellbent on making me out to be. I just started speaking to my son from being screamed at with cruel lies and horrible, mean things that I will not repeat over nothing. I didn't call for 3 weeks because of the shock and pure hurt I am still in for what was said. I am made to feel like a chore, burden, a pest. I am not welcomed. Like, life is better without me. Everything is one-sided. My son never met my parents, grandparents, aunt, or uncles. Deceased. never knew my family. He only knows the Boones, who viciously slander me. His mother, behind my back, have perpetually made me the dumb black sheep and continuously plot my demise together. They've poisoned my son and pitted him against me since day one, when I was just 9 days into my incarceration. So is it day one or is it day nine, ma'am? Former husband took it upon himself to make the egregious decision to tell him I would be gone and he wouldn't see me for 25 years or longer of his little life. My son cannot be my son and is tortured by the confusion in whether he can be close to me like we've always been, or even be nice to me. So if you've always been close, this you being incarcerated is not going to change that, right? It may be close in a different way. So methinks she doth protest too much. I feel, to be honest, our son is just an innocent pawn in former husband's scheme to seek his sad, bitter, unrelenting revenge against me. Revenge for what, Sarah? What did you do to him? What one did you get over on him that he needs to get revenge for? Because he divorced you. He was always bailing you out, helping you out. Why does he need revenge? What did you do? Why was he always helping you if he's so bent on revenge? His, I don't know if that's heart, halo is broken plastic and covered in fool's gold. Yeah, his halo. He is not the angel he appears to be. He is an insensitive, callous tyrant and fully endorsed by his family. No one listens to me. I have made the active decision to not call for an undetermined length of time so I can take a break from the beratement. Girl, don't threaten them with a good time, Miss Sarah. I can only take the terrors inflicted by former husband in doses. Is that like in shots, like shots of vodka? Doses of terror inflicted? Right now, I've gotten my fill from both of them. If my son wants to speak to me, he can write or schedule a visit, which I doubt will happen from the lack of encouragement and inclusion of me to have a relationship with our son by former husband. Please understand, I can only take so much on top of everything else. I love my son. I need my son, just not this version. Not right now. So she doesn't love him unconditionally, right? She needs him to be the version that she needs. I don't think he should be needing, she should be needing her son. That's just me. But yeah, she doesn't accept him for who he is as he is. She needs him to be in a certain mold, some sort of idea that she has of her son. And now he's doing something else, speaking his own mind, defining boundaries, it sounds like. And so she doesn't like it. What can I do? What can you do? Please, this is not right. Every time I try to speak to former husband about anything, ends ugly and unsuccessful, ends up ugly and unsuccessful. He has taken it upon himself to self-diagnose my case from watching YouTube. Woo! His reliable source, and of course, Court TV telling me my trial is less than 3 weeks away, assumes I fired all of my attorneys. Remember, I am on number 6, but not by choice. And constantly tells me how wrong I'm doing everything. He keeps asking me why I keep delaying everything. He gives assumed case details about witnesses, occurrences, etc. over the phone, telling me about my case. So I wonder if Brian was like watching witness testimony, because I think most of us who covered Sarah Boone have some of the witnesses or the audio or the body cam, and so he's like watching. I bet he realized when we realized that Sarah forgot about the noise coming down the stairs, because they had 2 ear witnesses, was technically 3 if you count Vinny's girlfriend who was on the phone. So he knew about the 2 neighbors being witnesses before little Miss Sarah. Anyway, I think that's funny that Brian was keeping up with it on YouTube. He keeps asking me why I keep delaying everything. He gives assumed case details about witnesses, occurrences, etc. over the phone, telling me about my case. He is assuming everything. He thinks he knows everything about my case. This is wrong. I'm being penalized even more for wrong, empty accusations and information. This only multiplies his anger and spitefulness towards me, thinking my strategy is to do everything I can to keep him here. Ludicrous. That is why I felt the need, Judge Dean, to hesitantly include you in the ongoing struggles I'm having with my former husband and his incompetency regarding my life and case. It's never ending and only gets worse. There's that positive Sarah we all have come to know and love. I would also like it to be known I have not gotten any of my orders for a hygiene kit, deodorant that works, toothpaste, and a washcloth. So you're telling the judge you just walking around stinking? You don't have any deodorant on that works. You don't have toothpaste, so your breath is stinking, and you don't have a washcloth. Did you wipe boogers out of your eyes before you took this up? Or for a measly coffee package that I began asking for in July and after you approved on September 13th during our meeting. My ability to start receiving alimony again after former husband. I wonder, she says September 13th, but it was 19th that they had the meeting, right? I don't think they had one on the 13th. Monday was that 19th. I don't know. I feel like she didn't put the right date down. Anyway, on September 13th during our meeting, my ability to start receiving alimony again after former husband immensely diminished and tried to stop. It's the middle of October. There's always an excuse. The most recent and for the last 3 months is that his debit credit card won't work because it's a jail and people steal. He's had to use our son's allowance card just to finally get me a hot meal. I mentioned to you, which ended up coming on my birthday, 10/10, only because I told him about this letter I'm writing. I'm still waiting on the other order so I can be alert and presentable when my attorney does finally show up, who still has not since the last time I spoke to you. Please know also my bank account, which I've had for 30 years, has closed due to former husband's failure to pay alimony as instructed by our dissolution of marriage agreement. Then also by you. I cannot deposit any checks. One I have been waiting on for him to mail me since February and could use towards commissary when he wasn't giving anything. All of my subscriptions are not being renewed. Anything with auto pay cannot be approved. I cannot even deposit the alimony. Oh, so now you know how George felt when you were taking his ID from him. Is that former husband is supposed to be paying. I've had this account for 30 years. So she was like 42, 43 around this time, 44. So she got it when she was 14? And yet you didn't have any money. I've had this account for 30 years. He assumed his plan would work in not having to pay, so he withheld, causing this to happen. I have no bank account, Your Honor. Also, for all the difficulties he's supposedly encountering with his debit credit card could have been avoided, would he had been paying and abiding by the rules. My bank account would be open still. He could have used my debit credit card and I would already have the necessities. Girl, he knows what you did to George for using your debit credit card. So no, he didn't. Brian has a little more sense. He's sober. I would already have the necessities I'm needing. Former husband is his own troublemaker. He makes his life more difficult from all of his assumptions and defiant attitude. Now, he's not your child. He's a grown man. Even if I wasn't incarcerated, I'd be getting the same problems from him. He keeps tripping over his power trips and taking out on me. Oh my God. Remember when she said that about the press? The press doesn't have the right to press their nose in. Now she's tripping over power trips. Where are my orders? How can I get my bank account reopened? He gets no relief from his own doing. Everything was okay before he tried implementing all his agreements and started a second job, soothsaying. Okay, so in this part, my gut feeling is, listen, he's been paying, knowing Brian, he might have also been paying child support, but he had been paying her alimony for 2 years while she's in jail. He gave her a list and said, these are the things I would like to modify on our agreement about the money, about legal status of the child. You know, obviously she can't have him half the time because she's in jail. He wants that modified. She hemmed and hawed about it. He cut off the alimony. He was like, listen, girl, you don't even appreciate what I've been doing for you. And now you want to act a fool and you still need me to consult you about what's going on with our son. You should focus on fighting for your life. Let me focus on our son. I don't know. You guys let me know. Because I don't see him being like vengeful or wanting revenge for what? Like, what did she do to him? Do you know? Like, he just is like, wants to move on with his life. The constant assaultive, degrading remarks, fear infliction, and terrorizing threats must stop. It makes no difference how soft my approach is in trying to explain to former husband how unnecessary and harmful his actions and comments are, and being the example he is to our son, giving permission he can do the same, especially to me, his mother, and also to other women futuristically. Period. That was all one sentence in Sarah's mind. Oh my God. So I don't know what she wants the judge to do about reopening her bank account. He can't order Brian to go and open an account for her. You know, you're just kind of SOL, man. Brian knows you murdered someone too, so he's being realistic. He's just not in la la land about it. Just stop, please. Former husband tries to taunt me every opportunity he can to get a reaction from me, knowing he's got the upper hand in almost everything and can either laugh at me or hang up or both. As said before, you should just stop calling him then. Just work through the attorneys, or you get an attorney and work through them. Stop calling him. You don't need to talk to you. As said before, I am not helpless. I have God and your awareness of my situations, Judge Dean, to hopefully impose your authority in all manner available to provide any permissible relief for everyone, Judge. Aren't you the manager? Something needs to be done sooner than later, considering my child has an unknown date. I refuse to continue cooperating with former husband on any of his terms and the way they are being handled. Look at the bigger picture. Imagine telling that to the judge, to look at the bigger picture. Yeah. I don't know how much negotiating she's imagining that she has. Like, she can't say no. I demand that I have him have time. Like, the jail can't even accommodate that. You know what I mean? Like, I'm not sure, other than just to whine. In conclusion, the most painful, horrific remark made to me by former husband so far during my attempted call to talk about our son's upcoming birthday, with the conversation always turning into their exciting upcoming move, told me, when you're finally put away, this move will be the best thing to happen to us, him slash son. We can't wait to get out of Orlando and away from you. Also, where we're moving is very close to the prison. It's going to be very easy and convenient for us. He's already picked out her prison. I know a lot of you guys said she'll go to Lowell, but doesn't she have to go to the reception center, like how Charlie had to go to Adelson had to go to the reception center and they monitor you and all that? I also heard, I think in the chat for this video that I'm redoing now, not live, you guys said, I can't remember, you guys said she was going to Lowell though. Yeah. Thank you for your time and assistance, most of all, your understanding. I waited as long as I could in everything to involve you, but I don't know what to do or how much more abuse I could endure. I felt you should be included on what's happening behind the scenes when former husband and his attorney aren't sitting in front of you in the oh, here we go with this again. This was the genesis of it. And it was totally unhinged by the time she got to Cashman. Aren't sitting in front of you in the courtroom, or you're reading one of their many scheming documents plotting what he can do to me next. You and God. Thank you either way. And always, sincerely, Sarah Boone. Was that my last one from then? I got October 4. Okay, let me just check. I tried to lay these all out in order. But I think I got myself confused. Okay, so that was October. I think that is the last of 22. And then part 3 will be the 2023 documentation and 2024. So yeah, because they'll get the modification in 23 and early 23. So we'll make that a separate one. And Mr. Bankowitz comes in to try and help her with that. But yeah, Brian files for relocation and other things. I'm just looking really fast to make sure I don't leave anything out. Hello, my true crime lovelies. How are you? Oh my God, have we been having fun with part 1 and part 2 of the dissolution of the Boone marriage? This is going to be the last part. This is part 3. I will link part 1 and part 2 in the iCards. I will also put it in the description down below. Welcome or welcome back. I'm Tanika. Welcome to Tanika's 2 Cents or welcome back. We're going to cover it. I left out a few documents in part 2. I have a lot of tabs open. I didn't want to make, anyway, it doesn't matter. I'm going to cover a couple of documents for 2022 that I left out, and then we'll go right into 2023 and we'll finish up with 2024. I think I'm going to call this Brian Puts His Foot Down, or maybe Smack Down. I'm not quite sure. Oh, come here. Oh, you say hi. Say hello. Dogs are here, so you guys have a warning. If you don't like them and they make noise and it bothers you, just click out. It's okay. You don't have to tell me. I know everybody's not a dog person. Okay, let's get into this without further ado. So this was from April of 2022. And this is what Sarah was reacting to, the supplemental petition for modification of final judgment when she was on a 10. Former husband Brian C. Boone, individually and by and through his undersigned attorney, hereby files this petition for modification of final judgment of dissolution of marriage dated June 15th, 2018, and states as follows. Action for modification. This is an action for modification of the final judgment entered by this court on June 15, 2018. The final judgment incorporated the marital settle agreement and parenting plan, both executed on May 3rd, 2018. A copy of the final judgment is attached here too. So it says a copy of this. So if Sarah got a copy of this note, she should have also gotten a copy of the final judgment, in my opinion and understanding. Jurisdiction, that's not it. Substantial changes in circumstances. Since the entry of the final judgment, there have been material and substantial changes in circumstances that require a modification to the parenting plan, marital settlement agreement, and final judgment, including but not limited to the following. I'm going to try to read slower. I know some of you guys said I read too fast. You can also always in your settings change the speed, the playback speed, right? But I will try and read slower, and then that will result in slower scrolling. You can always mute me and just read it if you'd like. Okay. On February 25th, 2020, the former wife was arrested and charged with second-degree murder of her boyfriend after she locked him in a suitcase. If you're reading this and you haven't heard of it, you're like, what? The former wife was committed to the custody of the sheriff of Orange County and has been held without bail in the Orange County jail since February 25th, 2020. The parties have one minor child born in 2010. Minor child has lived exclusively with the former husband since the wife's incarceration. They're about to fight. And lived the vast majority of the time with the former husband since the party's separation on September 11th, 2017, because his mama was partying. Inasmuch as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. The former husband has voluntarily deposited money into the former wife's inmate account so that she may purchase items from the inmate commissary.
Voluntarily, not required by law.
Modification of shared parenting due to the former wife's lack of proper judgment, as described above, and because of her behaviors in front of the minor child prior to her incarceration. It is in the minor child's best interest for the former husband to be awarded sole parental responsibility, decision making, and 100% time sharing. The former wife does not have the mental or physical ability to co-parent at this time, nor can she exercise any time sharing. So he's rightfully so calling into question her judgment. And I love that they're not like the alleged crime, because she already admitted. I mean, even though she's not convicted, well, so we're watching this in 2024, post-conviction, pre-sentencing. At this time in 2022, she had not been convicted, but she had admitted it. So I like that they're not doing like the word games. She said she did it. It's recorded. She doesn't have the mental ability to do it. I don't know about physical, maybe because of her location, but she definitely can't do any time sharing. Termination of alimony. Paragraph 4 of the final judgment requires the former husband to pay durational alimony to the former wife in the sum of $1,000 per month for a period of 84 months. The former wife does not have the financial need for alimony at this time, right? Because alimony is supposed to be like a bridge or a duration until you get a job or until you get stable, or some of you guys pointed out until you get remarried. So he can't give her the lifestyle she was accustomed to in jail. Like $1,000 is not going to help. 20,000, not that he has 20,000, but you know what I mean? Which, if not earlier terminated or modified, would end with the payment due on April 1, 2025. Also, due to former wife's admitted egregious behavior, of locking her live-in boyfriend in a suitcase, which ultimately led to his death, she is not entitled to alimony.
Oh, break the law. No money. No honey, no money. Kill your honey, no money. Whatever.
The termination of the durational alimony should be retroactive to February 25th, 2020, the day of the former wife's arrest and incarceration. And the alternative, the former husband requests that the alimony be reduced or at least suspended for the period of time that the former wife is incarcerated. So he's saying, on one hand, it should be terminated because she committed this crime and she admitted to committing this crime. It should be terminated going back to the date of her arrest. If you don't want to terminate it, it should be suspended. It should be reduced or at least suspended for the period of time. Maybe reduced, maybe $100. I don't know. Termination of child support. Paragraph 6 of the final judgment requires the former husband to pay the former wife the sum of $100 per month towards the support of the minor child based on the equal sharing schedule outlined in the parenting plan. Since February 25th, 2020, the minor child has lived exclusively with the former husband, who is responsible for 100% of his financial needs. I'm going to say they gave her grace, because I would have backdated it to whatever the last time she was at the last time the son was at the home was the Tuesday before George's murder. And so I would have said, I've had the child since whatever that next day was, whatever that next Wednesday was, right? But they're being gracious. And I guess rightfully so, since she wasn't locked up. Like, she could have potentially had him, even though she did not. Okay, attorney fees and costs. Former husband attempted to come to a resolution of these issues with the former wife without the necessity of filing a contested supplemental petition for modification, and requested that the undersigned attorney prepare a joint stipulation. She wouldn't sign it, which resulted in the filing of this action. Former wife should bear the responsibility for the former husband's attorney's fees, as her actions and her failure to act necessitated the attorney's fees, right? Had she just signed it and said, you know what, you're right, I am in no position to take him and have any type of physical custody, so I'll sign that away. And you damn sure shouldn't be paying me child support, since I am not at all able to help you with the caring of the child. And that money should go to the child for the needs of the child, or even not to the child, but it should be kept in the household where the father and the child are, right? Like, girl, what do you look like taking child support and you can't even like physically touch your child? Award the sole care and custody of the minor child to the former husband, as well as 100% time sharing and decision making. I think the decision making is really what she went off on in that other letter, right? Because she wants to be involved, consulted about like moral things, is what she said, in school and extracurricular activities. I don't think she was that involved with all of that when she was out and not sober. Now that she's like, how do you say it? Dry. Now that she's a dry drunk, she imagines that she's this involved mom. Terminate the former husband's alimony obligation to the former wife, retroactive to February 25th, 2020, or in the alternative, suspend all payments during the former wife's incarceration. Terminate the former husband's child support obligation retroactive to February 25th. Order the former wife to pay the former husband's reasonable attorney's fees and costs necessitated by her actions. Take that, Ms. Boone. Then he submits this affidavit. Let me make sure y'all can see it. He's 47. He's a software developer. He is unemployed. This is filed 8/25/22. He doesn't have a job. He's looking for a job that will pay between 60 and 80, which is more than what he was making or what he reported on the other job back in 2018, which makes sense. So here, last year's income, 2021, 0. Didn't put anything for Sarah because it says if known. He doesn't know if she had a rich relative who left her an inheritance or whatever, right? So don't put 0. Like, he doesn't know. He's at the Mandy residence. And then pet expenses, remember on the stand, he said they had just gotten a pet. And then his monthly creditors that he has. So he's got 3 credit cards, Capital One, Chase, and the Citibank card that he's got to pay on. Basically living off of his savings. Let's go back because I wanted to see. The house price also, the value of the home has almost doubled, which I went over that before in a video about him selling the house. But let's see. Now I'm making myself dizzy. Hold on. So here he lent Sarah, respondent owes petitioner in excess of $20,000. They put estimate here. Real estate. So last time the house was at $280. Now it's at $453 from 2018 until 2022. He's estimating that his Prius is about $10,000. He's got $40,000 in his 401k at Merrill Lynch. So that was as of 6/30. So I'm sure because he doesn't have any other stocks or other things here listed. So they're probably living off that. And she wants him to pay. He doesn't know when he's going to get a job. And she's in jail and keeps having her trial postponed. Like balls of a burglar. $5,000 is the home furnishing is what it's valued at. He still owes $238 on the home. That's what he owes on the credit cards. So he is not in a position to take care of himself, his son, and Miss Boone in jail. Ma'am, you're a ward of the state. So child support worksheet is and will be filed. There's Sarah's address. There's his signature. Okay. So then they had case management conference on the 19th of September in 2022, held in person. So the court will take no action on the notice for trial filed by Mr. Martell. That is Brian's attorney. And then Mr. Mendoza is appearing for Mr. Martell, or appeared at this conference. So Mr. Mendoza will provide an order to the court regarding any child support being vacated temporarily. So that was agreed. Mr. Mendoza is going to write up the order. Court will sign it. This will be solely based on Miss Boone. It says incarcerated, but I think they mean her incarceration. Miss Boone completed change of address form in open court. Deputy clerk in attendance, J. Shawana J. Now we're ready to get into 2023. So many tabs open. It's a sin and a shame. Okay, January 23rd, brand new year. Judge Michael Dean. Honorable Judge Dean, hello and Happy New Year. I hope the holidays were kind to your family and many wonderful memories were made. I, too, would like to have a Happy New Year, as this will be my 3rd in OCCD. Not by choice. 2023 is going to be my year of simplification. I am going to simplify, all caps, underscore, anything and everything I can to avoid any added stress and confusion on top of the already, which I'm guessing means on top of the existing stress and confusion. This is my year of significance also. I am significant, all caps, underscore. I am not going to be demoralized and made to feel like a comedic, lame doormat by anyone any longer, especially by former husband. Are there like comedic doormats? I don't get that. Are there like joke doormats? Or is she just saying that she's being walked on? Do you know what I mean? Like how they have rubber chickens? Is there like a comedic doormat? I choose happiness no matter what, and am going to be the best that I can to my son, most of all, where I am, which is not forever, all caps underscore. Please remember this and know that I am doing everything I can to have a successful year. The purpose of my letter, Your Honor, is to please request a hearing, underscore request a hearing, to underscore cap simplify and clarify some of my ongoing legitimate concerns with former husband, so I'm able to somewhat enjoy my year for however long it may be. I'm pretty sure the year is 365 days. Unless, I don't know, do you guys remember, was January, or was 2023 a leap year? So in that case, it would be 366. But I feel like we know how long the year will be. Anyway, I still have no attorney for this matter, but believe with your authority and overseeing, I think she means oversight, I can be rightfully heard and understood as I was able in our last hearing back in September 19th, in parentheses, 2022, for the same reasons. I am contacting you again. Like, you can't win. What is that? The no good deed goes undone. So now because he helped her before, she's gonna bend his ear. I can only imagine how hectic your schedule is, and I know your time is invaluable, which is why I'm hoping everything needing to be addressed can be done quickly and only once. Because of the extended amount of time that I've been quietly underscore, possibly double underscore, or furious writing with the pen, dealing with former husband and his nonchalant, cruel attitude regarding my concerns. Also, the growing underscore mountain of lies and laughter. I feel my requested hearing is overdue and underscore most definitely needed. Simplify, all caps underscore. I kept praying things would change. Sadly, they have not. To summarize, here are my concerns, please. I would like to address one, as his mother, my role in my son's life. I matter. I have rules, health, concerns, appointments, school/grades, church. I don't know what that means. She has school or she has concerns about the school. Whoever gave her all A's, I want to talk to them. They're probably dead now, though, but I still want to talk to you. Church, friends, behavior, eating habits, computer time. And those are little asterisks over computer time. But instead of the asterisks leading you to the bottom of the page, as you would think it should be, it actually is just like parenthetically right behind it. So I think it could have just been parenthetically and saved the two asterisks. I know she's short on ink. I'm trying to help her out. Please discuss specifically the computer time, sports/group activities, and more. I want to talk about it. Should be included on and have a right to be. See, the thing is, I wouldn't disagree with her if I didn't know her traits, because being involved or what is being included, she wants to have a say. She doesn't want to be informed. So I've said it a million times. I work in corporate America. If you work there, you may have heard of a RACI chart, AICI. Have you heard of that? So R is who's responsible. It's like a chart of like who's responsible. It's kind of like roles and responsibilities, but it's in a grid form. R is responsible, A is accountable, C is consulted, I is informed. She would be I, informed, and I think she wants to be like R or A, responsible or accountable. Well, technically, legally, Brian would be the R, responsible. Yeah, I think she wants to be the R, but she can't because she's locked up. Like, she doesn't have all of her freedoms, even though she's not convicted. Obviously, she can't leave the jail whenever she wants. Anyway, most of the time, if I don't initiate, inquire about, or stay on top of, nothing happens or is cared about other than by me. Now, how does she know that? She's not in the house with them. Do you know what I like? It's just she always is overreaching. She always says a little too much, like to just stick a little fork in there. And I'm incarcerated. So nothing happens or is cared about other than by me. And I'm incarcerated. Parentheses, which makes no difference. So why mention it? I am still mom, capital mom, with mom rights. Now, she said that at the last letter that we read for 2022. Apparently, it's rummaging through her mind. I am still mom with mom rights and concerns. I make a difference in my son's life and forever will. I will never stop caring. And he knows that. Is that a threat, ma'am? Number 2, former husband and his. Oh, wait, I didn't do it right. Former husband and his family to stop talking about me as mother and about my case to son. I would like to address. Okay, so I guess it's okay. She'd like to address former husband and family. I know everything, my son, rudely and sometimes laughing, tells me about my divorce, my crazy deceased family, my brothers. So I'm guessing there are family members outside of her brother that are crazy, which would explain kind of Sarah's craziness. Why I am incarcerated and am yelled at sometimes from what only God knows former husband has said. Please note, 2 weeks into my incarceration, he decided to self-diagnose my situation, egregiously telling our, at the time, 9_year-old that he wasn't going to see me, his mother, for 25 years or more of his life, if ever again. Okay, so self-diagnose my situation? No, you can self-diagnose your own situation, ma'am. An external person cannot self is this over here, not that out there. So he just diagnosed because you're not having a medical situation, but whatever. Okay, this extremely selfish, idiotic decision has forever made my son keep his distance. Really? And he is scared to be 100% with me for fear if he gets too close. Truly. Like she wants her son to keep it 100 with her. Is that what she's saying? Truly and deeply that I'm going to be absent and out of his life. So what's the point? There's no it in there. She wrote, what's point? There's so many other detrimental comments former husband has made, and it's poisoning our son and pitting him against me. Okay, I'm going to stop saying underscore because you can see that and then it's throwing me off because I'm like, should I say it before or should I say it after? Anyway, former husband, all caps, does not think before he speaks. To simplify this request, please, Your Honor, instruct him and his family to cease and desist any further comments, opinions, assumptions, accusations, self-diagnoses, anything negative discussed with my son. Stop talking about me! All caps. You think she stomped her feet when she said it? She sounds like a 9-year-old, like an upset, pedantic 9-year-old who won the spelling bee once in their life. Number 3, private phone time with my son. Former husband is constantly in the background, interjecting his comments, answers questions I'm asking my son, laughing and telling me through my son what I can and cannot say to him. Example, asking about friends, school dances, sports, etc. So, yeah, I would monitor the conversations too, especially because you like to use your son as a messenger, a conduit, if you will, despite the parenting plan specifically stating not to do that. Also, former husband is always seen, heard during my 15-minute video visit. He's always on the log, so he might have to be there. I don't know. I'm trying to think. I've seen where the son met with her only, but the dad was on the list and just didn't check in. So I don't know. You guys let me know. Some of you guys have the answer. I'm just speculating. Okay, it's always seen hurt during my 15-minute video, impeding my valuable time with my son. In what way? I call him, not not former husband. Foremost, my son is a completely different person when not around his father. I am lovingly spoken to most of the time. Even she can't hold that lie up. And told about everything under the sun. So much is said when just me and him. There's also no pressure to be mean to me like dad is. Private phone time will be my time and made to be important and meaningful. By whom? Who's going to make it important and meaningful? Who's going to make it your time? Are you asking the judge that? Are you telling him? It will also get him off the computer, which has been a huge topic of attempted discussion with former husband with no success. So I'm interpreting attempted discussion because Sarah can talk. There's no like impediment to her thought vomiting. So I feel like they have discussed it. Brian has not agreed. So when she's saying attempted discussion, it means because she hasn't gotten her way. Brian hasn't seen it her way. Do you know? Yeah, with no success. So Brian hasn't agreed. That's the no success. Like, and rightfully so, she's not there. She can't just arbitrarily like throw into the void instructions, demands, commands, parental advice. So he wants to talk to me about should be allowed, and whatever he wants to talk to me about should be allowed. No, freely and without difficulty. I don't agree. This includes phone and video visits. 4. Moving misconceptions / assumptions. I am told on a daily basis, God bless Brian not having a job and letting her call collect every single day. That is a saint, man. I am told on a daily basis about all the hustle and bustle, repairs, contractors, etc. for the house to be sold as soon as possible so former husband can take my son and move away from me. Another reason I am withheld monetary funds to make my necessary purchases. He doesn't owe you monetary funds. Are there some different kind of funds? Play-Doh funds? Anyway, why not just say money? Another reason I'm withheld money. When trying, I would just think you would be as concise as possible, especially if you write. If you're writing it by hand, I have a disability in this hand, so I'm very careful anyway. But it just seems like, why say extra words when one will just do? She'll say 2, 3, 4. When trying to rationally discuss the topic of moving, I'm either yelled or laughed at or just told that it's happening. I want to make sure former husband abides by the 50-mile radius and all other moving rules included. So she's talking about in the dissolution of marriage agreement. He assumes he and my son are going to ride off into the sunset and leave me in the dust, knowing I have no attorney, money, or family, which he seldom reminds me of, telling me there's nothing I can do. I don't think she means seldom because I don't think seldom is noteworthy, right? That's few and far between. I feel like she means he constantly reminds. Otherwise, why is she mentioning it? I don't want to hear him talking about it all the time anymore and get it right when you do. Please, Judge Dean, clarify so he knows for definite, I think for sure, what to plan on, or definitely, and can make the necessary changes, including saving money in order to bring my currently negative jail account in the positive to make my necessary purchases. So that right there demonstrates what type of mom she is, right? Like, you want him to stop planning for a better life for your son and stability and support so that he has to stay and that money can be diverted to you instead of to the well-being of your son and his caretaker. I'm requesting also to be kept informed with any update regarding moving plans, especially since it includes taking my minor son. I don't know. See, again, now she's saying informed. If we think about the RACI chart, that means you're just told. But the fact that she wants to be informed of any updates, that means she wants to have a say, in my opinion, my 2 cents. Where are you at? So I would just, because what day they move has no consequence to her, what day the movers are coming, when the house is sold, like, she just needs to know that they're moving. Maybe they can say on this date. I don't know. She might try to call them a million times. Maybe they tell her don't call on this date because we're moving. I don't know. I have no idea. But it's all about her. 5, all caps, stop assuming my case details and progress. Former husband assumes I actively am making the decision to postpone my trial and keep them here, that I actively am making the decision to possibly be on my seventh attorney from all the withdrawals, not firings. So even if they're fired, they still have to file a motion to withdraw. The judge has to say, yes, I agree to this. That actively, I am enjoying my third year in jail, away from my son and our life together, away from everything, and want to stay in this morbid, daily, vicious cycle of depression. Stop telling me what to do, how to do it, and when, from listening to all his reliable sources, such as professional YouTubers, court TV, social media, etc. I am constantly told he knows what's going on and how it's going to end. He believes, along with so many others, all the hype and hate generated towards me from all the ignorant misunderstandings coming from everywhere. I don't even know what's going on after the nonstop debacles and insanities I've been going through, dealing with, and trying to sort out all the lies for 3 years and counting. Why don't I fire my attorney and hire former husband? I don't think this is giving what she thinks it's giving. Like, this is the man you're asking to help you, and then you're just making like smart ass derogatory comments, like page after page. Who wants to come in and read this? Alimony/monetary income agreement. Since our last hearing, former husband was ordered to continue paying alimony so I can purchase books, food, clothing, hygiene items, etc. So I was not able to find an order saying that he had to continue that. Sometimes they don't include everything in the minutes, but then usually you'll see an order that's filed in there. I don't see anything, so she may have misunderstood this or just felt like because it wasn't addressed, it's assumed. I don't know. Anyway, I couldn't find it. It could be there. To continue paying alimony so I can purchase books, food, clothing, hygiene items, etc. Often I am denied and go without what I am needing. I am still, all caps, waiting for everything, including pictures my son wants me to have and a check from my grandmother's deceased interest with a S on the end, interests. $100. He keeps telling me has been mailed. This check is almost a year old from waiting so long. 2/2/22. I don't even know if it's even able to be used at this point. I keep waiting and waiting and waiting, all caps, for this check, especially so I can put in my negative account and not ask former husband. It was my understanding I could have the aforementioned after the hearing concluded. I have not, and am repeatedly told he's
waiting to get a job. Moving expenses are more than expected. Still waiting on a big check from his parents to clear his account.
or there's some kind of glitch. There is always a problem, reason, excuse. Always is all capped and underscored. So this is the thing, like where she is making all these dramatic statements. It can't always be, right? Because he has given you some money over the 3 years. Always implies like you're harassing him, like, right? Not even low key. You're harassing him again and again and again, and he has to keep, I don't know why he just doesn't tell you no, or maybe he has told you no and you can't take no, but the hyperbole is a little, the rhetoric is a little He even openly admitted to me he lies and has, so I never know when, if the truth is being told, ever. Again, can't be true. He tells me every time it's been ordered, mailed, coming soon, or on the way. Where is it? Any of it. The lying was a great factor in our divorce also. So here she has the missing pronoun again. She doesn't say his lying. So it could have been hers. She could be telling the truth. She just says the line. Could be on both parts. I even took the effort to communicate that I feel like a dumb dog looking out the window, wagging my dumb tail, waiting for something good after he's told me there will be, and to keep looking. I don't think he told you to keep looking, ma'am. Also, I don't know, whatever I have for my dogs, I give them. I don't tease them or tell them ahead of time. Like, can you imagine showing a dog a treat and then not giving it to them or not giving them a way to get it? No. Not my dogs. Nothing, ever. Only solution, please, is to establish a payment plan with due dates. It's copied into the clerk of court's website like that. I'm not sure. I think she wrote over, I don't know. I don't know, but I'm adding to try to make sense of the words. Please, is to establish a payment plan with due dates to simplify this ongoing problem going forward. I choose not to be lied to any longer than I already have, and to keep looking out the window for nothing. It's humiliating. Number 7, communication agreement. Everything regarding my son, including health concerns, behavior, discipline, appointment results, details, grades, report cards, school reports, emails.
What emails, ma'am?
Notifications, planned trips, and vacation, not days before. See, for me, that seems overly burdensome. You guys know what it's like going on vacation, especially going on vacation by yourself with the kid, and then she wants all this additional disclosure to her. Girl, they can send you a postcard when they get there. What difference does it make? They don't have to ask your permission. Like, what is that? My mom, she said when she was little, my grandma would tell her, oh, you can catch more flies with honey than with vinegar. And she would be like, why do I want flies? But in this case, Sarah, get some honey out. It's just complaint after complaint after complaint. That's one of those people. Now I see why the neighbors said they would see her and turn the other way. Never mind the alcohol, just this whole conversation. And I'm sure it was like much worse when she was lit up all day. Okay. All general and important discussions as they arise. Lack of communication, another massive reason for our divorce. Not communicating overall, such as when our home was being foreclosed on twice during our marriage, or that my 30-year-old bank account this is the vengeance. There's no reason to mention the foreclosing of the house to the judge in regard to having you be more involved. You're just showing your pettiness. This is the opposite of helping yourself. Closed from excessive delinquency due to not receiving alimony. So she already told this to the judge, at least in 2 letters, unless I'm mixing it up because I've read all these letters now. Another reason for not receiving necessities from auto pay. Being disabled from no account and former husband's debit credit card never works. Like, she's acting like he's her active caretaker, like he's somehow responsible for her. Mine would, and for every purchase prior to closure did, but is now obsolete and unusable. Yeah, we get it. The account's closed. Of course, the card doesn't work. Communicate, all caps. It looks like a double underscore, or again, that furious pin under, like, frustration again and again and again, writing it. Communicate, update, mention, educate, make aware, notify, however, whenever, whatever. Just please communicate. Please, number 8, release documents from mortgage. I was served a summons on 9/27/22 regarding a lawsuit against me for non-payment and foreclosure of now, since 2017, former husband's house, which I signed documents on our dissolution of marriage, relinquishing my shares. So she actually signed them in 2018, but okay. Relinquishing my shares, interest, and ownership. I am still included on the mortgage and my name on all paperwork in the summons. Now, she wrote a separate letter just about this that I read previously. I don't know why she's bothering this judge about it. He has nothing to do with that. You have paperwork saying that you're not legally responsible. So you can send that paperwork, you can wait, it doesn't matter. Mortgage company to inform them I am not affiliated in any way. And I was told previously by him, it makes no difference. The house is practically sold, or it's been taken care of. Which is it? Girl, call the bank and ask them. Oh, wait, you can't because you're in prison and they don't accept collect calls. I would like to receive a formal letter stating I am removed from the mortgage company. Again, the judge has nothing to do with this. I do not need anything extra on my credit score that hasn't negatively already been done from everything during/after our marriage that was unfairly dumped on me by former husband. I feel like she might be talking about those credit cards where he gave her the $22,000 and she didn't bother to pay. And yes, you guys were right. She is in the hole because she still owes $22,000 and then she was only getting 10. So I think you guys said like she only is getting 12,000 or whatever, which is facts, like in her pocket. Please provide copies as soon as possible. She's at this point has been evicted from her apartment, so that's on her credit score. I don't know where she thinks she's going that her credit score is going to matter right now. You're not getting any new credit cards, ma'am. You're not getting a new car. You're not getting a new apartment. The state of Florida has got you. Number 9. Permanent documents, information from hearing 9/19. Please provide the permanent documents, full custody and suspension of child support. That's what he got in the other one. We read that at the top. Former husband's attorney was instructed to forward for your modifications, Your Honor, to temporary as requested after I was able to explain my circumstances with having no money or family to hire an attorney once I am released and my desperate need to be fully and completely reunited with my son ASAP. You graciously made the decision to make everything temporary. Thank you. Were these ever sent and completed? I haven't received copies of so, which I very much would like and need, please, along with any other paperwork generated since the hearing, so I can be kept updated with anything new I may need to work on.
AKA harass someone about.
I completed a change of address form during the hearing, also to make sure correct and everyone was aware, so I can be able to receive copies, letters, etc. going forward. To make sure it was correct and everyone was aware, I think is what she means. Copy of dissolution of marriage, 10. Divorce paperwork. I keep trying to receive a copy from former husband for my personal reference and information to utilize during our ongoing and current case together, but I have not yet received. I would like a copy for future review if needed, if the court is able to provide. The judge does not make copies, Sarah. I would be grateful and can possibly receive much sooner.
You needed to contact the clerk of courts, ma'am.
Please know, Your Honor, I am always coming to former husband with solutions for everything to make all that I can easier, less painful, and more productive. I.e., I'm giving him options of how he can do it my way. He has option A, option B, option C. If he has another way to do it, his way, I don't want to hear it. I ask days, sometimes weeks in advance for a reason to simplify our lives now and future. I do not ask, oh my God, Brian saw this, like our lives, future.
No, biatch. We don't have a future life.
I do not ask for anything difficult or unreasonable regarding my son or books or toothpaste. So your son is on par, your request for your son is on par with your request for books and on par with your request for toothpaste. Girl, I heard your breath was not popping when you were free. So focus on your son. Separate those things. I just keep taking the abuse, then have to say thank you and hope something might really finally happen. It does not. I'm trying to avoid predictable, one-sided arguments, even more snide, backhanded, not the queen of backhanded, pot, meat, kettle, y'all both black. Unnecessary comments and supposed, this is how it's going to be, statements. The latter, I'm hoping, comes from you, Judge Dean, in one way or another. The latter, I'm trying to avoid predictable, so that's the former. And suppose this is how it's going to be statement, so that's the latter. So how is the judge? In one way or another. Okay. We all need to be on the same page and level with the same understanding, rules, and agreement. Please help clarify and justify my concerns to keep the peace. Not justify, ma'am. That's up to you. So everyone can plan accordingly, abide correctly, and work together. I wait your response and hopeful hearing date information. Always trying and beyond grateful. Okay. And then, this got her mad. So this came in on Valentine's Day of 2023. Petitioner's verified petition to relocate comes now. The petitioner, Brian C. Boone, by and through his undersigned attorney, he's asking for, who hereby files this verified petition to relocate and in support thereof states as follows. Post-judgment action for relocation. There is one minor child subject to these proceedings. Petitioner requests to relocate with the minor child and said relocation is in the best interest of the minor child for the following reasons. Since February 2022, this should be 2020, respondent has been incarcerated and is awaiting trial for second-degree murder. The allegations include her locking her boyfriend in a suitcase until he died. The case has gone viral over the last couple of years on social media and is causing the minor child significant difficulties at school. His mom and her infamy are causing him significant difficulties at school. Yeah, because she's the butt of a joke. The minor child is being bullied at school consistently for his affiliation with the case and is seeking counseling for the bullying. or it's either seeking or probably seeing a counselor, the minor child would benefit from moving outside of the jurisdiction of his mother's case and around children that are not familiar with his link to the case. The petitioner has immediate family where he wants to go that can provide support to the minor child as he processes the situation. The respondent has had 0 overnights with the minor child for the last 3 years and is not involved in the minor child's day-to-day activities due to her incarceration. If the respondent is found guilty, she will be incarcerated for the remaining minority of the minor child. Say what? So I think whatever age he is, we all reach, well, I think it's every state. We reach the age of majority at 18, right? You can vote, you can go off to work, can't drink. Not in most states. But so if she's found guilty, they're saying, I think at this point he's maybe like, I don't know, 12 maybe. He'd reach the age of majority at 18, so that'd be 6 years. She definitely would be doing more than 6 years. So they're like, yeah, no, we should not be paying child support. She should not be having, she will not be having overnight. She should not have input on his day-to-day activities. With that said, the petitioner will work diligently to preserve the child's relationship with the respondent if said relocation is granted, right? So he's like, I want to move him for his own protection, but I will, of course, let him see his mom. Said relocation will greatly enhance the general quality of life for the minor child and the petitioner financially. It's probably cheaper there. And if he has family there, he can rely on them instead of like having to pay for a babysitter every single time or whatever. You know what I mean? Like you have family support, go over there for a dinner or whatever. Further, the minor child will have access to far greater educational opportunities. Said relocation will dramatically improve the economic circumstances of the petitioner and the minor child. The exact address is unknown at this time and is subject to the relocation being granted. There's a city here. I'm intentionally not saying it. Like someone would have to look at the screen to see it just because there could be a search find in the captions. I'm not going to say it. It'll appear on the screen. I will remove it as I've removed it where I remembered to, but I'm not going to say it. The telephone number for the petitioner will not change. Petitioner requests the relocation to be effective immediately, and requests a temporary relocation hearing to be set as soon as possible pursuant to Florida statute, given the situation of the minor child. Like, let's get him safe. The petitioner does not wish to deprive the minor child of his relationship with the respondent and would therefore propose a long-distance parenting plan as follows. And then we have one here for the footnote, and it says predicated on the respondent being released from prison and being found fit to have overnight time sharing. So this only applies if Sarah walks out of prison before he turns 18. Every other weekend, and she's found fit to have overnight. Every other weekend from Friday evening until Sunday evening between the respondent and the minor child. The petitioner and respondent would alternate winter break and Thanksgiving. The respondent would exercise time sharing with the minor child every other spring break. The petitioner will provide the necessary technology for the minor child to be able to Skype, FaceTime, or alternate video conferencing of the minor child with the respondent on a regular basis. So Teams, Zoom, whatever. He'll set that up. He'll get the computer, he'll get the technology, the internet, all the stuff that you need to have a conference call via video. A schedule of which can be solidified upon determination of the formal long-distance parenting plan. So they're not proposing a schedule right now, but, because obviously she hasn't even had a child yet. We'll cross that bridge when we get to it. The parties would be responsible for their own transportation costs. So if she doesn't live where they live, she's going to be responsible for paying for her transportation to get to her son. Also, I feel like this should be moot. Like when she comes out, let's just say in her mind, she's getting out in a year or whatever from when she writes this, right? Why would she go back to the city where she came from? Like she has no family there by her own words, right? She has no family. And then her brother, one's in Africa and one is unlocated, the one that's in prison. Yeah, just go where they are. Anyway, a response to the petition objecting to relocation, all caps, all bold, must be made in writing, filed with the court, and served on the parent or other person seeking to relocate within 20 days after service of this petition to relocate. If you fail to timely object to the relocation will be allowed, unless it is not in the best interest of the child, without further notice and without a hearing. Yeah, so they would just be like, you go ahead and go, and nobody has to send her a note, a Curry a pigeon, nothing. If the respondent files an objection to this petition to relocate, it should be served on the petitioner care of the Martell family law, right? Because he's represented. Because you'll see other notes later, or maybe we already saw them, where she's like trying to mail Brian directly about the case. The petitioner has employed the Martell firm to represent him in this matter and has agreed to pay the firm reasonable attorney fees and costs for this representation. Wherefore, petitioner Brian C. Boone respectfully requests that this court enter an order granting this petition for relocation, permitting the petitioner to relocate to the new city in Florida, granting said relocation on a temporary basis and setting an expedited hearing on said temporary request, granting this petition for relocation and ordering a long-distance parenting plan in the best interest of the minor child of the parties, granting petitioner an award of attorney's fees incurred in pursuit of this matter. Hold on, they lost me. Didn't it just say he was going to pay for it? Or was it saying that he is currently paying for it? I don't know. But they're asking the judge to award attorney's fees, which presumably is Sarah has to pay it. Like, why the state wouldn't pay for it? Granting any other relief the court deems just and proper. So he's getting that done lickety split. He's not even adding on the child support and alimony to this because he's like, let us get this done lickety split. I'm back. It's the same time to you guys, but just so you know, Sugar Bear is here. He's listening to a program, so you may hear music in the background. If that bothers you, it will not offend me for you to go do something else with your time. It's okay. Okay, all right, here we go. I don't know why now. I guess I didn't say dogs are here too, so Liberty wanted to make sure you knew. Come on. Okay, so we have Little Miss Boone. February 21st, 2023. So now it's about to be 3 years. I'm just going to say that because she went in February 25th of 2020. So it's February 21, right? So on February 25th, that will be 3 years. Orange County Clerk of Court, Judge Dean, regarding summons petition to relocate. Dear clerk, I received this summons today and I'm responding within the 20 days as stated therein. I object to the petition to relocate. Please set a status/case management hearing as I previously requested in my letter to the judge, Dean, stating my concerns prior to receiving this summons on 1/23/23, uploaded to website 1/31/23. I'm assuming she means the clerk of court website. Leave it to Sarah. There's more than one website in the world, Sarah. I also sent a follow-up letter and motion for the same on 2/13/23, but have received no response and has not been added to website to date. I did not see anything. I don't think I did for 2/13. Went back and looked. I did not see anything that is in between these two. Let me say it like that. This is February 21st that this has been logged. Oh no, it actually didn't get logged till March 1st. It was written on February 21st. Either way, it's not. I didn't see it. I did look. Okay. I am sending handwritten copies to the clerk of courts, Judge Dean, and petitioner's attorney, who can serve to former husband, his client, as I have no way to do so while incarcerated. My main focus/goal at this time is to send my response and objection to the petition to relocate to the clerk as soon as possible, as instructed in the summons. Please send copies of scheduled hearing with the date and time. I think she means like send the calendar invite. There's not a copy of a scheduled hearing if it hasn't happened. So I am aware and can prepare. I have no representation in this case and can only be kept updated by these copies. I await the court's response and information. Thank you, Sarah Boone. Please update my address which I feel like we had the last hearing where it says you updated. I could be misremembering it though, because I've been reading a lot of letters like the last 5 days. So my timing might be off. All right. So now we have this on March 8th. Honorable Judge Michael Dean. Hello. Oh, no, not hello. Judge Dean. Hello again. Per my attempted conversation today to ask former husband, FH, when he was going to schedule our son's, no, ma'am, dental appointment, and when will he really be ordering the small food package. You see how she laces those in there? She's pretending to call about the dentist, but she really is calling about this small food package. She doesn't owe you a small food package, ma'am. The state of Florida is feeding you. You don't even eat your breakfast. Like, what a nuisance. Anyway, okay. Yeah, I agree. I've now been waiting on for 10 weeks and counting. This was his abrupt, comical, question mark, demanding response. Oh my God. I think, yeah. I think it's Brian telling her she needs to. All done? Are you all done? Sorry. Okay, let's go back. Wait. And punctuation is everywhere. She has comical in the middle of the sentence. Question mark. Comical question mark. And then comma. And continues her sentence from there. But let's go back. FH, when he was going to schedule our son's dental appointment, and when will he really be ordering the small food package I've now been waiting on for 10 weeks and counting. This was his abrupt, comical, question mark, demanding response. I need to find someone to get my junk out of the garage and put in storage somewhere. However, they're finally leaving. When trying to process what he just dropped on me and talk to him about, I was told it's not his problem. I know that's right. Brian got a backbone. What? It's not. I mean, he has enough to worry about, like moving to a whole different city, worried about his son's mental health. All done? And she's so dramatic too. Like, I don't know why she has to try and process it. You don't have to process it with him on the phone. He's not in charge of Sarah brain processing. And she doesn't even get back to. So she's right off the top complained. There's something going on with the dentist that she had to have a conversation. And again, attempted means he did not either agree with her or he just brushed past it. But you had a conversation, ma'am. You didn't attempt, unless the cat got your tongue. You weren't like, oh. This is what attempted conversation means like to me. Anyway, they're finally leaving. I was told it's not his problem. I said, I'm in jail, as he likes to remind me of daily. It's not that easy, especially when I have no one, money, or resources.
Get out the tiny violin.
Which he knows, he said while laughing. Ha ha ha, I know. Still, not his problem. She has it in quotes, but this is not his instead of not mine, but you guys get it. Anything left, I should stop correcting her. I was an editor before, so like my brain is trying to like look at what was written and then try to guess what the intent is and then correct the grammar. I can't promise. Anything left behind will be put in a garage sale or donated. These belongings are some of the heirlooms from my deceased family. The only things I have of them to remember. Also, baby books, antiques, etc. All of my important, meaningful, historical belongings.
To that, I say, tough titties, ma'am. Why are they there anyway? Are you...
It sounds like, you guys let me know if you've heard something different. Like maybe Brian packed up her apartment or paid someone to pack it up and come and put it in his garage. I wouldn't have even done that. Listen, you murdered somebody, ma'am. Figure it out. Her important, meaningful, historical belongings. Take a picture, I guess. They are still leaving no matter what. It makes no difference See, you would think these bulleted things are what he was saying, but then it goes back and forth because I'm sure he didn't say baby books, antiques, etc. All of my important, meaningful historical belongings. That's her, right? But then we have another bullet. They are still leaving no matter what. Where I think she's repeating what Brian has said. It makes no difference what I say or do. Did you have an attempted conversation about it, or did you have a conversation where he told you to pounce in? I told him about the hearing scheduled on 4/13, and he laughed, saying, "Ha ha ha. It's going to happen. How can I be there when my trial starts on 4/10? Wait, what? It's something going to happen. How can I be there when my trial starts on 4/10? I keep explaining to him just because there's a date does not mean it's going to happen then. Of all people, I would know if when going to trial. Would you? You would know when not going to trial. Anyway, of all people, I would tell him first. Nonetheless, or he could just look at the docket. The docket has it faster than you do. Nonetheless, he will be part of my case and will receive information when/if the time comes so he can plan for participation. Ma'am, not by you, the assistant state attorney, notify you. Clearly, he has not thought about this and his commuting for however long it may be. And if, oh, she's saying if it may be, no, ma'am, he's leaving. Maybe this is the one and it's out of order. No, it says March 8th though. Hang on one second. It was logged March 20th. Oh no, these other ones are motion, so it hasn't been granted. But basically, it sounds like he knows it is going to be granted. Oh my God. Also, what happens if there is a change of venue? Where will that be? All seeing psychic Brian? How does this all end? Whoa. See how I'm on like a psychic head wrap and a crystal ball with that? Oh my God. Why does she think there's a change of venue? Does she have a crystal ball? I'm incredibly frustrated with his continued ignorance in trying to tell me what's happening, when, where, regarding anything for my case. I am incredibly frustrated with FH, former husband, continuously accusing me of keeping them hostage and putting off again. He knows nothing but what he sees in his crystal ball and on the internet. Stop being an all-assuming, self-righteous, bullying soothsayer. Well, how is he bullying her, though? What is he saying to her? Wow. Is that your new word? Wow. I never owe him any... You want to read with me? I never owe him any specific details about anything about my case, but will, of course, let him know when I actually, oh, it's all caps, when I actually am going to trial, if I even am. Why would you write that to a judge? Like, why wouldn't you be going to trial? They can't just leave you in the jail indefinitely, and they're damn sure ain't gonna let you out because you are delaying your trial. Anytime you have an attorney that goes all the way up until like 2 weeks before your trial date and then does a withdrawal, it's you, sis. It's you. I cannot do any more than I already am, and I cannot tell the future. No one can. He may not care about the rest of my life, clearly, in parentheses. I most definitely do, and am quite sure my son does also. My name is still on the mortgage. See prior summons I was served, and another undeniable concern of mine I am trying to address. She overuses undeniable. It's not a pressing concern though, ma'am. Your focus should be on your trial, right? Because no one is coming after you for a mortgage while you're in jail. You don't even have a job. Even if they did, you could fix it. Anyway, does FH have to have my signature to sell since my name is still on all the paperwork? Or does he actually have to remove, as I've been asking about for years and was also written in our dissolution of marriage? So just for you guys, if you haven't seen my other video, there was some clerical error. She technically was removed, but you know how like there's like copies of copies of copies? Somebody went back to the original in the file when they opened it up and they didn't go through and see the quit claim. I was an auditor once upon a time. I was a compliance auditor, so I looked at a lot of mortgage paperwork. Okay, anyway, the folders can be thick and you have to really be diligent. I'm sure when they're foreclosing on it, they're not, they're just, you want to be overly inclusive. I guess when you sue anyone, you know how they have like Jane Doe 1 through 10 or 1 through 100, depending on what's going on. And then those people will weed themselves out. But even if they like filed the judgment against her, it wouldn't be enforceable because she did sign away her rights and she was bought out. Right. So it's just like, she just likes to nag things. She's like a dog with a bone. She is going to let you have anything she can hold over you. She's going to do. In just the last 2 weeks, our son started counseling. Praise Jesus. I'm so glad to hear that. Both he and FH are completely nonchalant about it and seem to not even care about the name of the counselor, duration, or any other information concerning, oh my God, or any other information concerning the way she ends her sentences. Anyway, why is everything I am going through all of a sudden so affecting to him or FH? Oh my God. What? All of a sudden, everything you've been going through has been impacting your son since he was born, ma'am. You having him at your house when the cops show up, you drinking, too inebriated to pick him up from school. Like, did she even bother to say sober those days? You know what I mean? Like, I hope so. You had him in the car. It is reckless, I would say. It is reckless. And also, why does she need to know the name of the counselor, the duration? Like, that's not how counseling works. You don't know how long you need to go. I mean, go until you don't like the counselor anymore, really, if you're going to therapy. She's saying counseling, but I'm thinking it's like a therapist, not like a school counselor of like, hey, how are things going? Oh, here's Alex. Or he's going to, is he going to play with the cars? This woman, I mean, just like no consideration. And also, I know she's gotten the notice where it says the child is being bullied. Your case has gone viral. Everybody's making fun of him. Of course he needs therapy. I mean, even if it wasn't viral, if your mom killed her boyfriend and is pending a trial, you need therapy. Like, you can't just pretend that didn't happen. Oh my God. Okay. Let me calm myself. Also, the last letter I received regarding my case was from across the pond, from England. Moving 3 hours away isn't going to solve the problem. Oh, so she's saying he should just suck it up and suffer, even though he's being bullied. And then she put it over 120. Just the little dig, right? She needs to remind the judge it exceeds the 50-mile limit that's in their agreement. Anyway, according to her, moving is not going to solve the problem. A change of pace, new friends, closer to a strong support system, not going to solve the problem. Something FH thought of the affective. This should be with an E, right? I think she means effect. E-F-E. Anyway, has he thought of the effect it will have on our son moving in the middle of the school year? No friends, new, possibly even worse pressures. Oh my God. So now she's trying to have a crystal ball, or at least have a cloudy ball of you don't know. Be afraid of what you don't know. Look away. Don't mind the curtain. That's mommy's favorite movie, but you don't know what I'm talking about. It's okay. Culture shock altogether. I don't know what the culture shock would be. Like, he's not moving to another country. He's not even moving to another state. But don't mind me, because I uprooted my child her freshman year in high school and moved her from Cal. It's okay. Anyway, how can former husband tell if this supposed miraculous move really is in our son's best interest, especially if temporary per their petition to relocate? So there is son and dad, right? Why not just his petition or the petition? She's always taking digs. So if granted, They're moving back or again or somewhere else when my case is finalized, however, and whenever that will be. Well, it depends on how it's finalized, Sarah. They don't have to move back to anywhere once you go to, what'd you guys say, Lowell? Hopefully one of those is right. Oh my God. So if FH doesn't care about our son getting good grades or even wearing shoes, why is any of this concerning all of a sudden? It's been 3 years. You see how she turns it around and makes it about her and Brian? It's like she can't imagine for 1 second that her son might be suffering and that this actually might be in his best interest. She thinks that Brian is lying because if it were coming out of her mouth, it would be a lie. And so therefore, coming out of anybody else's mouth, it must also be a lie because of course everyone is like her, right? But it's just she's selfish. And I don't understand why what is the wearing shoes? Like maybe he had on flip-flops or something? Ma'am, you are the queen of flip-flops. What are you? So this was a hard lesson as a parent. Granted, when I had my daughter, I was young. And it's hard not to want them to get straight A's, but like what the teachers tell me, everybody's not going to be a straight A soon. There have to be A's, B's, C's, and even D's, right? Because it would be a pretty boring place if everybody was all straight A students or if everybody was all of high intelligence. We'd get bored pretty quick. You need a mix, right? I mean, listen, we live in a capitalist society, right? If you are, I don't know, high IQ, you're not going to want to take out the trash. You might want to, but in general, do you know what I'm saying? Like everybody is not going to be in. Please hold. And we're back. Okay, I want to go over this. I'm going to repeat this. Now the dogs want to act up. Okay, so 1, she's sending a laundry list of everything. Like the judge is the manager. Like she wants him to go over the mortgage or demand that Brian remove her name from the mortgage when it's a clerical error, right? Like I said, she's already signed a quit claim deed. Of course, she doesn't have any of her documents because she's in jail. This whole putting off again, like I'm just trying to figure out what does she want from, I think she's just vetching, incredibly frustrated with his continued ignorance and trying to tell me what's happening. So she's vetching about Brian saying you're going to jail, which the whole world's been saying that.
Stop being an all-assuming, self-righteous, bullying soothsayer.
So I think that's part of whatever her mental health issues are, or what do you guys call it, a disorder? Clearly, I'm not a psychiatrist. I'm not anything fancy. I'm just a girl with a computer at home and the internet. But yeah, so it's like she's annoyed because he's saying she did something wrong and it's Sarah and she can't be wrong, right? So she's, in her mind, this is my interpretation, obviously my 2 cents, is thinking, I'm going to be vindicated at this trial, right? Instead of like, oh my God, I'm really looking at serious time. I've not only admitted to locking him in the suitcase and not letting him out and going to bed, but I filmed it. And the version of what I filmed is very different than the version that I told about us having fun. Like in her mind, she's going to talk her way out of all of this. I don't know why she's talking about that particular case with this judge, unless she's trying to curry favor or gain sway. I'm not sure, because it's almost as if she's like passive aggressively also telling the judge no one can predict the future. Do you know what I mean? No one can. Now, I don't know. I'm in my 50s. My understanding is when you have all caps, at least when you're typing it, you're shouting. Is it the same when it's handwritten? Because I feel like she's shouting at the judge, and I'm not sure that's the way. Again, more flies with honey. I want to reread this part. In just the last 2 weeks, our son started counseling. Both he and former husband are completely nonchalant about it and seem to not even care about the name of the counselor, duration, or any other information concerning. Why is everything I'm going through all of a sudden so affecting to him or FH? So this thing, when she says, this sounds like she's peppered them with questions. What's the name of the counselor? How long are you seeing the counselor? Is the counselor here in wherever they are, Winter Park? Or is it at your new unapproved location, right? because I don't think it's the duration of the sessions, right? Like they're usually 50 or 55 minutes. So I think she means like, are you going to see her for months, years, which you can't really plan that. Like I said, it's until you get a new therapist. Anyway, or any other information concerning. So I think they just didn't want to give her information. She's searching. She wants to have somebody look it up. We know who Miss Sarah is. Wants to have somebody look it up, look up their qualifications, see if anything bad has been said about them. And, she's going to be nosy like how we would do if it were a counselor who was going to testify in her case. The fact that she can't understand how this would affect her son, because she's basking in all the attention, right? That's why she's telling us, I got a letter from England, I got a letter from Australia, I got a letter from all these different countries. She's basking in all the attention, mainly because she doesn't understand, like, she's the butt of the joke. Because I would not want to be getting letters from England for being in jail for accused of killing someone. You know what I mean? Anyway, of course, that's troubling to her son. And then you have all of the coverage of like the suitcase video, the interrogation, the 911 call, the first on scene people. I feel like those videos have been around for a minute, probably because they're the easiest to get with the FOIA. He's got to deal with all that. His friends have seen it. Maybe his friends' parents have seen it. I will remember, and it happens young. I remember in the 6th grade. Was it the 6th? It was the 6th. It was actually the year that MTV premiered. I'm telling all of my age. I had neighbors. So I think I said this. I went to a different school every year growing up until I got to high school. And some years I went to 2 schools. We moved all the time. So we had moved. One of the neighbors' children, I thought we were friends. We had been playing. And then randomly, it was a brother and a sister. Randomly, I didn't give the brother one of the things he asked for. It was my thing. And I don't even remember I know it belonged to me. And I said, no, boundary. And he called me the N word, like the whole word. And I went home in tears. And I was like, I couldn't understand it because I thought we were friends. And my mom was like, it's a horrible word. He probably doesn't understand the magnitude of the word. He's probably heard someone else say it flippantly. And I'm like, well, who else would be saying it? And she was like, probably his parents. And so that was hard for me. Do you know what I mean? And I'm sure and I still remember it to this day. I remember the way it made me feel. It was devastating. And so people could be saying nasty things to her son. And he's kind of trapped only because she wants him to be there. Like he could go somewhere else where they don't know about it. But she's also talking about England because she's like, wherever he goes, people know about me. I'm worldwide type energy. Do you know? She doesn't care though. Like if there's anything that can be done to save him from the bullying, let his father do that for him. It has nothing to do with you. You're not going to see him any more or any less. You're not seeing him in person anyway, right? Like you're getting the video visits or phone calls. So those video visits can happen from space, as you mentioned in your other letter, or Australia. Again, time difference. Also, Australia said they didn't want you, girl. I'm looking out for you, Aussies. And then it just is like, everything is about her. She's the center of it, but she's so fragile too. Do you know? I'm thinking of like an egg. You know how oh my God, I'm now really going way back to science class. Like the strongest points of the egg are at the top. Yeah, she's just like the little yolk in there, and you have to hold the egg like this when you're dealing with her. Because if you do it like this, all hell's going to break loose. I'm probably not making sense, but I just feel like as a mom, I just feel like she doesn't get it. Like her son is a tool. The way that she looks at him, I'm not saying any human is a tool, but it's like she doesn't have that let me protect him feeling that moms have. Do you know? FH thought of the effect, and again, anyway, it might be the right one. It will have on our son moving in the middle of the school year. No friends, new, possibly even worse pressures. So he can make friends. He's young. What could be worse than people taunting you for your mom making a snuff film, killing her boyfriend? Culture shock altogether. Again, not moving to another like country or even another state. How can FH tell if this supposed miraculous move really is in our son's best interest? So I don't know who said it was miraculous other than Miss Boone. I don't see Brian saying that it's miraculous. He needs support. He needs help. And he's been taking care of you for I don't know how many years. Like, let him be with somebody who can help him. You know what I mean? Not take care of him necessarily, but like help him. My love language is acts of service. And so I'm with you, Brian. Go where people can be of service and help you be of community and not, you against the world. Okay, especially if temporary per their petition to relocate. So I think they said, I mean, technically it is temporary because she's waiting on at this point, she was waiting on her trial. But I think they said it to placate, like, we're changing it, we can change it back. Like, cool your tits, lady.
So if granted, they're moving back or again or somewhere else when my case is finalized, however, and whenever that will be.
It will be finalized. No one has a crystal ball, though, Sarah. We'll figure it out when we get there. We're not there yet. Right now, the immediate concern is your son's mental health. Self-esteem, all of those things that are super important at that age. If FH doesn't care about our son getting good grades or even wearing shoes, why is any of this concerning all of a sudden? It's been 3 years. Well, the fact that it's been 3 years, ma'am, the fact that you're writing letters to judges like you're cuckoo for Cocoa Puffs and it's all getting news coverage, both, traditional legacy media, new media, social media. Bro, everybody knows about it. He's embarrassed. And it's not anything he can do. Do you know what I mean? It's not his fault that you gave birth to him. He just happened to be born your son. Okay. Their petition also states our son is experiencing significant difficulties at school. He is an AB student. His favorite class is musical theater. He has 7 friends, sleepovers, a girlfriend, and plays online games with the guys almost every day. But you don't even want him to have the online games. And if he does play online games, he can stay connected to his 7 friends, assuming they all play. Do you know what I mean? Like, trust me, I've moved and moved and moved, like I said before, and I have friends from my moves. Okay. Maitland Middle School is a significant problem in itself. Isn't it in and of itself? Whatever. In itself. Parentheses, see reviews / write-ups. You see what I'm saying? If they would have given her the counselor's name and any information, somebody would have been giving her reviews and write-ups because we know Ms. Boone does not have internet. So how is she seeing the reviews and write-ups? Not only for our son, but every child who attends there. If anything, he can be rezoned to another school and still have the same expected capabilities, opportunities, and closer to me. I don't know what this is. And B. I thought that was, yeah. And be closer to me. It's all comes back to her. So how is that being rezoned any different? It still creates the same problems that she mentioned up here, right? So he could still go to this new place, have no friends, new, possibly even worse pressures than being teased for your mom creating a snuff film of her killing her boyfriend. Culture shock, all of that could still happen if she's okay with rezoning. The thing is it's all about her. She feels like she's losing control. She has to keep him close. In like proximity, not in like mentally, like not a mental connection or emotional connection. It's like literal physical proximity. He needs to be close. Why? So she can stand outside in the yard and smell him at the jail? All done? I just don't get it. It doesn't make sense. I'm sure also there are plenty of other very acceptable schools within the authorized 50-mile radius. Here we go again. Has FH even looked into or contacted the supposed far greater educational opportunities stated in the petition? There are such opportunities closer, maybe even better. Who's going to look for it, though? And he also, keep like ignoring on purpose, I think. He has a support system where he's going. It's not just about the school. And sometimes greater educational opportunities are impacted because you have a support system. Like he could do a different after school program if someone can pick him up. You know what I mean? Like there are other things without his dad having to pay for someone to do that. It's all about her, and she's just sitting in her cell, like, or not her cell, she's in a dorm, in her open dorm on her bunk, just like festering. These things are festering and growing in her mind. It's like little mushrooms popping up in the crevices of her mind. There are such opportunities closer, maybe even better. Has FH rubbed his crystal ball to see? Why am I never included in anything regarding our son? Another undeniable complaint and concern of mine. See, that's where she gets herself into trouble, because never means not once. So if we go through all of it, are you saying not once have you been included in anything regarding your son? Not once. Not once since you're incarcerated, not once since ever. I see this as yet another secret delight to FH in making this heartbreaking attempted move impossible for me. The ego on you to think that he's making decisions to make things impossible for you, and not that he's making decisions for things that are in the best interest of the child. This is where, oh my God, you would need a Judge Alex Manning. It's like, it's think of the kids, think of the child, think of the child. I can't do her accent, but I love me some Judge Alex Manning. Heartbreaking attempted move impossible for me. Heartbreaking, breaking her heart attempted move. Like, and that's not an attempted move. And why is it breaking your heart? You're not losing your son. I see this as yet another secret delight to FH in making this heartbreaking attempted move impossible for me, especially if he sells my car, and a bigger disconnect with my son. Nonetheless, per the petition, I will be responsible for all my own transportation costs. Oh no, heaven forbid you have to be responsible for yourself. And he should have been sold that car. You should have asked him to sell that car so you could have this money to get your deodorant and all your Zuzus and Wham Whams. Ma'am. Rezone schools. I want to see my son. The move is all about FH. FH admitted to me his parents are selling one of their 4 homes and moving to South Carolina. He wants to be close to them, and that place is closer than Orlando. Okay. One of their 4 homes. So where are the other 3 homes? And if he wants to be closer to them, that's still a support system, because you're saying it's 3 hours away. So if he stays where he is, whatever that distance is the 3 hours plus going to the Carolinas. Please remember all. The primary reason a former husband wants to move and has blatantly laughed at me about repeatedly is because it's more convenient for him, since where they're moving is down the street from the prison. So disgusting. This very hurtful, brazen, self-proclaiming assumption is said regularly to me, and has been already sent in my previous undeniable concerns more than once. How ugly. Wrong. Well, if you want your son to come visit you when you're in prison, the way to do that is to make it easier on his father to get him there, since your son does not drive. Although 2 years he will be. Maybe, if he so desires. Also, Judge Dean, if I may, oh my God, whenever she says if I may, she's like, what is that when people say, no offense, or with all due respect, that's hers. If I may. Remember when she told Captain Giovanni, if I may, I just don't believe it. Anyway, are you aware the prison stipulations in their petition, page 2, bottom fine print? Have you reviewed the long distance parenting plan included also? Does former husband really expect me to drive? If he doesn't sell my car. Reminded of regularly also. Uber, bus, helicopter, walk back and forth to the G place between Friday and Sunday evening, and I only get to even see my son every other weekend? I do not at all agree to this or anything trying to be forced and threatened in order for me to have a relationship with my son. I will. Look at how her penmanship has changed, and it's all caps. When it's not, it's like, I don't know. The top like up here it was like soft and round, and now this just looks angry. Or am I reading in too much? You guys let me know. Forced on me. That's like when she told the police, I don't agree. I don't know what you guys want me to do. I don't know what to do. I'm not saying that. I'm not agreeing to that. It was not intentional. But if she really wanted to see her son, girl, if you had to get on the back of a pigeon. Oh, a bald eagle? If she had to get on the back of a bald eagle, she should go. Okay. You go to see your son, especially after you finally get out of prison. And if your son want to see you, girl, if you better get on a good foot. I will no matter what. And former husband, in order for me to have a relationship with my son, I mean, it's up to you. I will no matter what. And former husband will never take that away. It's not his to take. And does he not realize this is all predicted or predicated? Predicted by him and his surety. Everything will fall into place perfectly as he sees. This is all unpredicted. How can any of this be proposed on predictions? How is any of this even fair? That's like saying don't buy an umbrella until you know the day it's going to rain. That makes zero sense. We have to prepare, Sarah. We have to make plans, do risk assessments, all of that. How is any of this even fair? Why has nothing been discussed? Only him making demands. Absolutely, undeniably ludicrous and wrong. Former husband is using our son as a ploy, and I feel is selfishly seeking his own gratification and pleasure. Oh, yeah. Okay. I said before, my former husband, he can't wait for me to be found guilty and leave. He's not even waiting for that. If that even happens, please tell me when exactly everything predicted is going to happen. Anything? When? FH, former husband, knows nothing. One thing he does know is that all my concerns are without, in every way, undeniable and all true. I think she feels like if she repeats it enough, like it'll, I don't know. Is it like a Jedi mind trick, you think? Or she just wants to say it over and over, like to beat it into you? Because I'm not going to go back and count, but that's like at least 7 undeniables. And all true, nothing you say is all true. Again, it's those qualifiers, all true. She should have just said undeniable. Even that's questionable. Didn't it? Yesterday, she was like undeniable that she was a good parent or something like that. I'm like, really? Anyway, he will never admit and just keeps making his retaliations worse. What is he retaliating against you for? Why is he seeking revenge? Like, somebody let me know. What is she talking about? Like, is it one of those conspiracy theories where everybody's out to get her? I don't see it. I don't, unless there's something she did that he's saying, oh, no, that's her line though. This is for everything you've done to me. I don't know what's going on. Pot, meat kettle, y'all both black. He will never admit and just keeps making his retaliations worse because none of my concerns are made up or false, only experienced or still experiencing. And also that I make his cruel comments, laughter, and actions known to everyone. He is not who he appears, nor will ever be. Why are you bad-mouthing your father, the father of your child? Why would you need to let everybody know that? Like, what do you gain by that? What does your son gain by that? That is only going to build up animosity because one day your son will know. I mean, listen, this is all over the internet. He might know now. Okay. Judge Jean, there's so much more to be said on top of my already very legitimate concerns. There's so much more to be said. Girl, well, we're on page 5. Please get to saying it. I have already sent in hopes to be remedied. Nothing has changed. So much to be said on top of my already very legitimate concerns I've already sent in hopes to be remedied. Nothing has changed. Only gotten meaner and worse. Where did you send these legitimate concerns? Who's supposed to be remedying them? Because, like, the judge can't remedy the stuff about your mortgage. So are you sending it to the judge? Are you sending it to the appropriate people? Former husband's egotistical, backhanded schemes, assumptions, and plots are unfair and not at all funny. Now, see, this is where she gets herself in trouble because you sound unhinged, Sarah. Like, she's saying these things about the father of her child to the family court judge, like, without any sense of irony. You keep effing around, you gonna find out you can't even have unsupervised visits with your son. Because if you were my partner and writing this type of stuff, you wouldn't see my kid without a supervisor there. Even if I have to pay for it, I don't care. I don't have to worry about it being a relative of hers since she has no relatives, according to her. Who does he think he is now that I'm incarcerated? This shows / explains what kind of person he and his family really are therein. Also, therein, wherein. What is she talking about? Also, explaining many reasons contributing to where I am now. What? There's way more to it all. 2 sides. Here she goes again. So, something to do with Brian and his family is the reason why you murdered George and recorded it. Maybe you should seek therapy. And there wasn't she what she did with the finger stop pointing. She's pointing all kind of fingers everywhere. Everything must be pointing back at her. Like, seriously? See, and if I just can't imagine sending this to a family court judge. Like, the reason why I'm in prison for murdering my boyfriend with a suitcase, part of it, there are many reasons from what's his face, Brian, and his family that are contributing to where I am now. With that being said, Your Honor, I received a copy of a motion to relocate again today. Shorter, revised, no prison stipulations or holiday schedule. Stating I am only receiving because your J.A. Coffee told his attorney when trying to submit without my knowledge, as usual, I must be included. Otherwise, I would not have this. Like, I do not anything else filed from anyone, all caps. I would not have this. Like, I do not anything else filed from anyone. According to the clerk's website, multiple documents have been filed, which I have not been included on to receive copies. So whoever is looking at the court's website, ma'am, Sarah, they can print that out for you. This being a huge complaint and concern in our last status hearing back in September 2022. All of your complaints are huge, just for the record. Why am I not getting copies? The only documents I have are the original summons served on me in front of everyone and a now obsolete order setting a hearing for 13/23 that isn't going to happen apparently because of all the other orders, motions, answers filed I know nothing about and can't read or open online and haven't been sent copies. How am I supposed to prepare or respond accordingly and timely when I'm not included or part of anything other than being told what to do, how, and when, and the terrible, ridiculous person / parent I am by former husband. Unfair in every way and wrong. Unjust. I do not know when the new order setting hearing is to happen that was just filed or the order filed after on the same day. Since my original letter to you, 1/23/23, uploaded 1/31/23, 11 other documents have been filed, uploaded, none of which I can view. I only know what I've received. Summons, petition. Why am I still not receiving copies? As said before to you, Your Honor, and the court. So, Your Honor is the court. This is the only way I am able to be kept updated. I have no reliable, consistent outside resources to do anything or really provide information. I hope all the people who have been helping you read this and see this so they can stop helping you. I rely on the court for this inclusion. Please send me copies of everything being filed so I can read and review also. I don't even get a copy of any of my letters anymore, which notifies me the judge court has received as I have once before. Why not still? See, this sounds like Daryl Brooks. Remember, they did something to be nice. They didn't have to do it, and then that was the expectation. So they're not doing it. But also, copies of my letters. But you can see, you just told us, you saw it on the website. You said uploaded 13123, so clearly you have access to see that they were uploaded. You don't need a copy of the letter if you see it on the docket. Please include me, the respondent, on everything I am able to be. This is my case also. Are you making fun of me? And I am supposed to be treated equally, fairly, and properly as any party to a case should be, with or without an attorney. This is my life. This is my life with my son. There's nothing more important. So me, when it comes to attorneys, I like it all to go through them. They don't have to tell me tell me if you need something from me, but that's what I'm paying you for. You know what I mean? Like, I don't need to know every little move. I don't. I'm busy, but Sarah's not busy. I think also she wants to see it because then she thinks that she can opine on it. Like, everything that's filed doesn't need a comment from you, man. It just doesn't. I am not helpless nor giving up in any way, in anything. She's so defensive, especially regarding my son and our life together. Futuristically, former husband needs to destroy the crystal ball and don't quit his day job when he has one. Oh, no, she didn't. She hasn't had a job since when? And then she had the nerve to say when he has one, and she still has her hand out begging and dry begging for his money. I'm sure undeniably she always, like, I just don't, yeah, honey, you need honey, not vinegar. I'm sure undeniably by having one also and not relying on his parents' millions, his economic circumstances would most definitely improve in so many ways. You're sure undeniably? Well, can you focus on how your economic circumstances could be improved? Because you are leaking. Pockets are leaking. I am me and am trying relentlessly forever. Pinky promise? Are you going to be like blood sisters with what was her name? Coffee. Henrietta. Oh my God. I think I'm confusing her with the Green Mile. I believe in myself. I believe I can fly. And I'm confident in God. I'm making up stuff now. I will get through this. We all will. This is not forever either. My circumstances or remaining life. Stop trying to make it. I'm hoping for my husband can understand and cooperate as unobtrusive and cordial as possible in order for everyone's life to be successful and happy. Everyone's life to be successful? Oh, yours is going to be successful when you're forever home, ma'am. I don't know if you're going to be happy, but you're going to be real successful. Because I think the people in the lower prison, they're going to get you right as rain. This includes me also. Okay. Successful and happy. Coming right up, Sarah. Please send copies so I know when the new hearing is scheduled so I can plan accordingly. Mind you, we've seen in all of these, they send an order over to transport her. So maybe they don't contact her because she said that they kicked her in the bunk. I don't know. Listen, stay ready. You ain't got to get ready. Who said that? Was that sugar free? Please understand too, we inmates are woken up at 3 a.m., sit in 3 to 4 holding cells for 10 to 14 hours when going to court for 30 minutes of your time. So it's also a physical preparation on top of the mental. I very much would like to be ready. Please. Thank you for your time, patience, understanding, and copies. Sarah Boone. She still had to stick that last. Nobody said they were getting you copies, ma'am. You're asking. Nobody said yes. People don't have to do what you say. And then here comes the big guns. This was filed 4/5/2023. So I think they met 3/30 or 3/29, something like that. Yeah. This cause having come before the court on March 30th, 2023. Order a motion for temporary relocation filed on March 6. On the petitioner Brian C. Boone's motion for temporary relocation filed March 6, 2023, and having reviewed the file, heard testimony of the parties, listened argument from counsel and the respondent, and being advised in the premises makes these findings of fact. This court has jurisdiction of the subject matter and the parties. So subject matter has been proven on the record. There has been a substantial change in circumstances since the entry of the original judgment. Oh, sorry, I skipped it. There's a child involved. There's been substantial change in circumstances since the entry of the original final judgment. The petition to relocate, filed on February 14th, 2024, was filed properly. That was the day after George's birthday. He would have been, what, 44? 45. Was filed properly and meets all the statutory requirements. Relocation factors. After evaluation of the statutory factors, the court finds it is in the best interest of the child to grant the temporary relocation, and from an examination of the evidence presented at the preliminary hearing, there is a likelihood that upon final hearing, the court will approve the relocation of the child. Specifically, the court finds as follows. I wonder. I think they're calling it temporary. I mean, it is temporary, but I think it's just stop the arguing with her, right? 'Cause if it's temporary or permanent, there's nothing she can do. But maybe because she doesn't have an attorney, I don't know. Maybe they're going nice. Okay, so let's look at the factors. A, the nature, quality, extent of involvement, and duration of the child's relationship with the parent or other parent proposing to relocate with the child, and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in the child's life. So how disruptive, if you look at holistically, mom-dad relationship or other person, or mom and mom, dad and dad, we're equal opportunity over here. Siblings, like all the relatives, other significant persons in the child's life. The mother is currently incarcerated and has not been in the physical presence of her son for over 3 years. The mother is currently involved in a high publicity criminal case, and the child has suffered at school as a result of everyone knowing about his mother's case. Suitcase Sarah. The father is currently single and does everything for the child. Additionally, the father's sister and nephew, the child's cousin, live in this designated place where they desire to relocate. The child would have the opportunity to go to school with cousin. Oh, that's cool. Upon relocating, the mother does not have any family in the Orlando area, right? So when she comes out, she doesn't have to move there. At 89, no, I'm kidding. She's not coming out. The age and development stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. There has been bullying at school due to some of the videos regarding the mother going viral. The mother admits she gets letters from England and China, it says China, but China, due to the popularity of her case. So she was saying all this on the record, not like basically sticking her foot in her mouth, because I could hear her saying, well, everybody, the whole world knows about me, or whatever else. By relocating, the father is confident that no one will know the situation and the child can get a fresh start. The feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing. So nothing will change due to the relocation because the mother is incarcerated and they can only communicate by phone, which the child can do from anywhere. Australia, space. No, he could do it from his new location. The child's preference, taking into consideration the age and maturity of the child. No evidence presented, so he's too young. They didn't say, where do you want us to live? Whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities. And Brian listed all three. There's financial benefit, there's emotional benefit because he's not going to be bullied, educational opportunities will be improved. The father is a programmer and generally works from home and could do his job from there. The father believes that moving away from the areas would provide a fresh start to him and his son, and they could leave behind bad memories. And I'm sure, like, in that area, then suddenly Brian became super recognizable, right? Like, if I saw him, I would know him. And I don't even live there. So, like, because, again, all that body cam footage that was being shown, right, over and over. The reasons each parent or other person is seeking or opposing the relocation, see other factors. The mother didn't have an articulable reason as to why she opposed relocation. So she went in there talking about her feelings and complaining and everything, like we've seen in all the other, what was it when she did the argument about not having media there? This is it's only one hearing. I have a right to, and blah, 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 like nothing, no case law, right? And so she didn't, whatever the criteria was for the judge to consider. She did not speak that. Therefore, he said she didn't have an articulable reason. Current employment and economic circumstances. See other factors. Relocation is sought in good faith. See other factors. Mother states that the father isn't paying alimony as ordered by the court. So let's see. The parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, marital property, and marital debt. See other factors. So whenever that came up in court, she was like, he's not paying alimony. Girl. The career and other opportunities available to the objecting parent or other person if the relocation occurs. See other factors. So none, since she didn't have a career. Her opportunity is to get to trial in her forever home. A history of substance abuse or domestic violence as defined in section 741.28, of which meets the criteria of section 39.8061D by either parent, including a consideration of the severity of such conduct and the failure or success of any attempts at rehabilitation. No evidence presented.
Really? The alcohol and the domestic violence? Because it didn't say domestic violence directed toward another parent, but I'm pretty sure putting your boyfriend in a suitcase after you beat him with a bat is domestic violence. Anyway, no evidence.
The demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline, daily schedule for homework, meals, and bedtime. The only parent capable of creating a routine at this time is the mother. I think it's the only parent not capable of creating a routine, right? She can't create a routine from jail. Any other factor affecting the best interest of the child or is set forth? No other factors were considered. Oh, where are the other... Anyway, it must be a different document. Any other factor affecting the best interest of the child, no other factors were considered. It is therefore ordered and adjudged the petitioner's motion for temporary relocation is granted and the petitioner is permitted to relocate to that place in Florida pending a final determination of his petition to relocate. So the temporary is happening now, and that was the one where they asked for like an expedited hearing, right? They did it on March 6th and they're hearing this on March, 30th, 29th. So it's granted. Maybe it's like a restraining order. You know how you get the temporary one first and then you get moved to a permanent one? I don't know what has to happen, but this is happening now, the temporary. The court orders that the respondent continues the same contact she has had with the child during her ongoing incarceration. At the end, the petitioner will cooperate in facilitating this contact. This court expressly retains jurisdiction of this cause for the purpose of enforcing, construing, interpreting, or modifying the terms of this order. So don't go filing when you get to your new city. This court is going to retain jurisdiction, which I think is good because, I'm not saying Brian is a bad guy, but you know how you see sometimes children getting abused and they move them from state to state or city to city and they don't check in with, CPS or DFACS or whatever it is in each location. So I like that he's retaining jurisdiction. They got to come back through him. And so that went to Brian's attorney and to Sarah. Of course, Miss Boone has to respond. She writes on April 7th, 2023. Judge Michael Dean, Henrietta Coffey. Oh, it was Henrietta Coffey. Coffey is from Green Mile, though, right? That last name wasn't it? It's John Coffey. Judicial assistant. Motion for contempt. Is that phrased right? Motion for contempt. Anyway, Honorable Dean, Miss Coffey. Per your instructions in our last meeting, petition to relocate on 3/29/23, after stating to the court my still ongoing problem with former husband and him not paying alimony to me, you ordered to continue in the status hearing on 9/19/22. I am including my motion for contempt to obtain these payments and all missed, delinquent, or diminished payments. I'm in the process of trying to figure everything out as it comes to me. And remember, pro se, so please bear with me. Is it bear, like the grizzly bear? I guess so. I guess it wouldn't be bear. We don't want the court to get naked on us, right? No, I am doing all I can to still utilize. I wonder if that's something she said as a child or was said to her as a child. Do your best. She always says that. No, that I'm doing my. Please bear with me and know I'm doing all I can to still utilize my rights, which seem to be tested and tried to be taken regularly since I do not have money, resources, family, or an attorney. Former husband has in abundance, which was bluntly announced to everyone in the court by his attorney for whatever reason it was made to be necessary. I guess those without do without, but I'm still trying and always will. I too am still in shock of the outcome for the petition to relocate and my minor son being advantageously taken 4 times the lawful amount, 50 miles, to move away from me, the other parent. Yeah, there's an order, so he can do that. I too am still in shock. Who else do you guys think is in shock when she says I too TOO? Or does she mean I am still in shock also of the outcome? I don't know what she means. That's weird. I too. The judge wouldn't be shocked. The clerk wouldn't be shocked. Brian wouldn't be shocked. His attorney. I don't know what she means by I too. As far as I'm aware, which is rare in this case, as no one includes me on anything, I still have my rights, custody of my son, and am owed alimony. Nothing has been made permanent or signed to state otherwise legally, or has been discussed again and needs to be, where in my previous numerous attempts I have tried, but told by you I'm doing it wrong. Nonetheless, I feel like her mom said that all the time. Nonetheless, like dismissive. Oh my God, he almost deleted this. Nonetheless, you made known you do not read my letters. Your JA does. For the 919 hearing, you addressed all my concerns in the letter I wrote to initiate and schedule it. Otherwise, how would you know? How would you know to if not reading my letters? Maybe his JA told him, maybe his JA. She always she doesn't give anyone the benefit of the doubt, doesn't give anyone grace. Like she can't see how it might be true what they're saying. She just likes to poke holes and pull knives. Or maybe she's pulling the knife and poking the hole. Clearly, I don't know how to stab people, but you know what I'm saying. What am I doing differently this time? I thought my very legitimate ongoing concerns needing to be discussed and brought to your attention would be in the case management meeting that was then canceled. Why? Because I don't have an attorney? I have right, and I'm desperately wanting and trying to utilize them, but it seems only when I do it correctly, I'm able. How am I supposed to know what's correct or incorrect? It is only made correct, I guess, with money and an attorney. If so, mine will never be correct, but you most definitely still get my intentions for everything, especially to save my son and be treated fairly. Now, she wasn't worried about her son a bit more than a man in the moon in the free world. Was she involved in making decisions, or did Brian make the decisions? Like, come on now, let's keep it 100. Let's keep it a buck. Can we keep it a buck? Yes, we should keep it a buck, right? Yes, okay. Also, would I have known prior to the petition to relocate hearing it was really a trial, as I found out during? I know for sure I would have been better prepared and could represent myself even harder, but as usual, I was not included in that very important detail. What? This is what she said. Remember when it's the same thing the press wanted to be in her discovery viewing? No one told her she would have been prepared. Ask anyone, she's always prepared.
I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal.
Ma'am, you were told about the hearing in open court on Friday, August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
It wasn't a trial, it was a hearing, and you should have been prepared. You should have came with receipts, ma'am. You can't just throw things. You can't just say things into a void and expect everybody to be like, oh, whatever she said is correct. I thought I had a chance, but in my opinion, your mind was already made up no matter what I said. Again, rarely am I included or made to feel significant enough to ever have anything of mine even mentioned. I don't think it's the court. In fact, I know it's not the court's job to make you feel significant. Your level or feeling of insignificance is deeply rooted in you, ma'am. It's okay to take the abuse non-stop from former husband because I have nothing. This is unfair and wrong. I still matter and am important, especially to my son. Just because you say it over and over does not make it true. And is it nonstop abuse? Stop calling him then, because he can't call you. He's not writing you. Stop calling him and you won't get any abuse. It's like you are testing the waters, butting up against, I don't know what you're doing, banging your head against a wall. Remember also, my circumstances are temporary and no one can tell the future. But apparently, the trial before the trial happened already after being told by you it would not in the status hearing unless there will be yet another trial before the trial before the trial. This, I don't know what she's talking about. And also, if she wants them to remember her circumstances are temporary, she should remember like what Brian is asked for is temporary, legally, as she likes to say. If so, please include me prior so I know what to expect. All she had to do is say, please include me, and then go, so I know what to expect. Like every single word. I think, well, at least in business, less is more. It's more impactful to say less. You have to be very concerned and concise about what you're writing. I remember it was in my organizational behavior class, but we had to write all of our stuff up on one page. That was like my first year for my management degree. But you have to like put it in one page, so it forces you to acknowledge the economy of words, let me say it that way, and to use choice words that are effective and concise. Not that you can tell by the way that I speak, but this is not like business writing, you and I talking. And what I need to do to properly defend myself as best I can against former husband's ugliness, torture, and attorney. You need to defend yourself against why don't you just agree to stuff and stop making everything a fight? Why don't you agree to do what is in the best interest of your son because you love him and you understand the world is bigger than you? I am already being told and profusely laughed at repeatedly by him. They're never coming back. It's all going to be made permanent and I can't do anything ever about any of it. Even if he did say that, ma'am, so what? You see, Judge Dean, Henrietta, I love that because the judge said I don't read this. She's writing it to the judge and the JA. Like, it's been getting to him, ma'am. You don't need to add her. She probably is like, please leave my name out of this. How even... Oh, you know what Henrietta was? Henrietta was the cat, right? In Mr. Rogers. Wasn't that? Anyway. Oh my God, I'm all over the place. How even more terrible will I be made out by wanting to have my son close to me and is lawful after he's established friends, school, activities, favorite places to eat, then all of this is brought to you again to conclude and then be made to move again closer as included in the temporary relocation paperwork. Or how about this, Sarah? Since you don't have a job, you don't have a place to stay, you have nothing, why don't you go to where he is? Why would you make him come back to a place where you have, by your own words, by your own mouth, have no one there? That makes no sense. And you're acknowledging he'll have friends, a favorite place to eat, all that. You would be cruel to attempt that, and no judge would think that is in the best interest of the child. So you kind of answered your own question, even though you're trying to make it the judge's problem. Because it's your way or no way. Or she's just like, it's my right, it's my legal right. He has to be here. Again, a possession, not a person. That's how she treats him. Or will it automatically be awarded to them like everything else and all their wishes come true permanently because I will have nothing and no one to help me figure out all of it when the time comes, if I even do it right in my hopeful attempts like I have been already? Please tell me now so I know what to plan on, considering everyone seems to have a crystal ball but me. It's only fair, and I should be included. From everything I've experienced so far with judges, courts, laws, etc., it seems true already. Everything will not be in my favor from the truly unjust way I have been treated and am still in this case. Or as she would say it, the truly unjust way I have been treated and am still in this case. That's not quite right, but y'all know. Is this how the justice system really works? Maybe it's just me with nothing. that it does. It only makes everything harder and more disappointing. If you're a no one with nothing like me, all you get is a hard time, innumerable hoops to figure out how to jump through, and laughed at, all for nothing. Girl, you got nothing but time. Stop writing all these letters and start getting into the law library and research. Judge Dean, you stated in the relocation hearing also it's a fresh start for son and former husband to move well beyond the 50-mile radius away from me. Why would you allow them to start before knowing anything of my outcome? Why? I guess I'll never get my fresh start from everything being made so impossible and arduous before anything has even happened, and after, when and if it does. Delusion. This is like delusion, denial. How much does it cost, please, to look into someone's crystal ball? Anyone's. Anyone? Oh, wait, I have no money or attorney. Please include me. Think positive? Ms. Henrietta, if when reading this, please take notes so it can be relayed properly and correctly, if at all. If it even matters. According to former husband, none of what I do will make any difference in anything, and I shouldn't be worrying about any of it. I'm going away for a very long time. Our son will be an adult. I will probably never have to worry about it. Thank you both for your time and understanding. I matter. _ She really shouldn't be worried about it. I mean, I know it's easier said than done as a person who suffers from anxiety. She needs some meditation. I think part of that anxiousness that she has is why she drank so much, right? Like she's self-medicating, numbing herself. I mean, that's not the only reason, obviously, but like, girl, chill out. They're just going up the road. He's going to have support. He's going to get a fresh start, which he desperately needs. Like, do you not care about him at all? Or is it, this is one of the women, one of you guys wrote it too. And I, like, when you wrote, I swear I had just thought it like 15 minutes before. There's a woman, Diane, if you guys, oh God, let me not go down that rabbit hole. But there's a woman, Diane, she has a whole channel. She has a whole business because her children, 2 of her daughters, I think they're her only 2 kids, went no contact. Sarah is the kind of person, if she's your parent, you're going to have to go no contact, or you're just going to have to put up with her BS because she doesn't know boundaries. And if she doesn't get her way, if she doesn't have a conversation, it becomes an attempted conversation. And then you got to have it over and over and over again. Like, she's exhausting. That is what happened there. We have this, it's listed as page 5 is her actual motion. It was in the same envelope, so it was received on the same day, 4/11. Brian C. Boone, petitioner versus Sarah K. Boone, respondent. Comes now, Sarah K. Boone, respondent, submits her motion for contempt for non-payment of alimony. So she had experience pro se before 2024 when Judge Kranick in all his wisdom, and in which was court ordered by Judge Michael Dean to continue being paid to respondent in the last and only status hearing, 9/19/22. Since, during, and prior to respondent's incarceration, 2/20 present, petitioner has completely withheld and or diminished incredibly the promised $1,000 monthly payments, stating repeatedly the respondent is not important and not priority. Let's step back, right? Because maybe he did say that. I'm not saying it's the nicest thing to say, but he doesn't have a job. He has a child to take care of all by himself. He has no support in the town that he's living in. And she's making it about her. It would be different if she would be like, hey, can you sell my car and then send me that money? Do you know what I mean? She wants his actual cash flow to be redirected to her. I just don't understand how she can't think of her son. Like, so if he makes you a priority or makes you important, do you want your son not to eat? Do you want him to borrow money from his parents in order? You know what I mean? Like, girl. This money owed to the respondent is overdue, ordered, and needed, being the only source of income to make any/all necessary purchases. Also, petitioner agreed to, signed, and made responsible for all said payments in the active court-filed dissolution of marriage 2017. Petitioner agreed to, signed, and made responsible. That's redundant. Okay. The thing is, when she says things like petitioner has completely withheld and or diminished. Like completely is all inclusive. There's no or. Either he has completely withheld it or he hasn't. You could say frequently withheld, often withheld, but not completely, and then add an or diminished incredibly. So he sent you something then. If it's diminished from 1,000, he sent you something. He didn't have to, in my opinion. But we saw he chalked it up to the game, or he didn't chalk it up to the game. He added the $20,000 that he has loaned to her, and he's put that on him as an asset because it's outstanding. Respondent is seeking all delinquent and arrears payments and all full current payments of $1,000 going forward to be made to the designated account of her choice. Wherefore, Sarah K. Boone, respondent, respectfully requests this honorable court to please grant this motion for contempt. That's the thing. Is it called a motion for contempt? Like, how do you, if you write an order for contempt, order finding them in contempt, she'd have to type up the order. Entering its order for alimony payments, delinquent and arrears. Is delinquent not the same as arrears? Doesn't arrears mean past? To begin immediately without difficulty or confusion by Brian C. Boone, petitioner. Okay. Oh my God. So that was 411. Then we're going to go to 418. Motion to continue contempt hearing scheduled for May 11. Comes now the petitioner, Brian C. Boone, by and through his undersigned attorney, who hereby files this motion. So now we're in May. We've passed up whatever, I think it was April 23rd. She thought she was going to go to trial for the murder case. We're past that. By and through the undersigned, who hereby files this motion to continue contempt hearing scheduled for May 11. On April 11th, the respondent filed a motion for contempt, alleging that the petitioner is not paying his ongoing alimony obligation. On April 14th, the court entered an order scheduling this motion for contempt for a hearing on May 11th. The petitioner filed a motion to modify alimony on April 12th, 2022, and that petition is still pending as of the date of this motion. So he filed to modify. So he's not paying until it's modified. I don't know. I remember when the housing crashed and people were being told to not pay anything, trying to get a loan modification. Just me, old auditor. Okay. Under the current law, the petitioner is entitled to have his petition to modify his support obligation heard and resolved prior to trial court's resolution on respondent's later filed motion for contempt for failure to pay support. See Rosenblum v. Rosenblum. So she's going to have to wait. Hasn't been heard. She can't file for contempt because we're waiting for the modification hearing. Therefore, the petitioner is requesting that this hearing be canceled and rescheduled either contemporaneously with or after the final hearing on modification. Wherefore, in view of the foregoing, the petitioner, Brian C. Boone, respectfully requests that this court enter an order canceling, I think they mean this court enter an order, A-N, canceling the hearing scheduled for May 11th, 2023. That was dated April 18th. Certificate of service. They mailed it to Sarah at the jail. I don't think this is the right address for legal mail. I think it's a P.O. box, but whatever. Motion to continue. Oh, it's all the e-filing, and they sent the whole thing. Acrobat signature. Okay. So April 20th, my childhood best friend's birthday. It was filed on the 26th. Judge Michael Dean. Henrietta Coffey, judicial assistant. They both get their own line. Regarding Sarah Boone, Brian Boone. So this is interesting because he's the petitioner. He should be in the first position. Since she's the respondent, she should be in the second position, but whatever. It's Sarah. She knows better. Hello, and thank you for granting a hearing for my motion for contempt scheduled via Zoom 5/11/23 at 9 a.m. I am in the process of gathering my necessary evidence as requested, but I wanted to remind you I am incarcerated and do not have the capability of using a computer to gather statements, calling about, or going to my bank. Even if I did, due to non-payment of ordered alimony by former husband, my bank account, which I've had for 30 years, is closed from having an ongoing, growing negative balance for an extended period of time. Girl, all the more reason to sell that car. Imagine that. Like, that car has been sitting around for 4 years. It's just losing value. Please know I'm doing all I possibly can from jail with what I am able to submit. I'm confident will suffice showing Not even one agreed, ordered, signed for $1,000 payment, along with all decreased amounts chosen by former husband to give sometimes, and the everyday payments deductions on my account. Please note, in the meantime, would alimony have been being paid? What would alimony have been had he paid the alimony, girl? I would not have to contact or be degraded by former husband every week to ask. No, ma'am, that is on you. You see how the abuser is blaming the victim for their behavior? You don't have to call him every week. You could just wait. And if he doesn't send it, he doesn't send it. He knows when commissary day is and has for over 3 years I've been here. That's a shame. He shouldn't know.
My bank account would not be closed.
30 years.
I would have essentials and needed items.
Why listed here? Bring it to the court, ma'am. I would not constantly, because none of these are legal reasons, I would not constantly be lied to about phantom orders and made to ask for updates weekly. Again, that's your choice. I would have peace of mind about being able to maintain blood sugar, glucose levels from having available and needed snacks. Oh my God. I. These are all I. They're all about her. I would not have to contact him. My bank account would not be closed. I would have essentials and needed items. I would not be constantly lied to. I would have peace of mind. I would not ever have a negative balance. I don't know about ever, ma'am, because he only has to pay it through 2025. Other participants could purchase care packages for me without having to add money. So in the positive of my account, and the only way to So she's saying, I think, that because her account is in the negative, nobody can purchase care packages, or they have to clear the negative first but who are these other participants? Yeah, because she already said she has no one. She said it how many times? See, this is where you get caught in the lies. So instead of saying I have a few, she's repeatedly said, yeah, I have no one.
My medications could be paid for when processed. My temporary life of incarceration could be, to a small degree, simplified. Former husband would not have to quote unquote deal with me continuously, and I would not, all caps, have to keep contacting the court to take up the judge's time to order again, all caps, former husband to continue paying. Former husband should not have made the decision to disregard the order to pay and made up his own rules along the way. This is contempt. It was never acceptable for former husband to treat me in the very unacceptable way he has and is. Would I not be incarcerated, which makes no difference and is temporary, or is stated anywhere and agreed to in the dissolution of marriage agreement? Former husband would have his license suspended, wages garnished, or be arrested and put in jail, where he'd get the idea real quick how it quote unquote really works and understand everything I've been trying to explain to everyone for years now.
Here's the thing. We all know to some extent that jail is not a place we want to be. So we don't need you to explain it to us. It was enough of a deterrent for the rest of us to follow the law and not make snuff films of us murdering loved ones. Air quotes. How about that? Like, he's the only one taking care of her son, and she's like, if she wasn't incarcerated, which she is, he'd have his license suspended, wages garnished. He's not working, so he's not going to have any wages garnished. If he has his license suspended, who is going to take your son back and forth? Let's just assume you had never been incarcerated. You were still walking around at 9 o'clock drunk and argumentative. You want him to be put in jail? Would you want him to have his license suspended, his wages garnished? Because even then he was the only breadwinner. What am I saying, primary? Like, you don't make sense. It's all about you, even in your hypotheticals. With that being said, my main and most important reason for this letter we're on page 3. Glad we're going to get to the most important reason. Don't bury that lead, Sarah. My main and most important reason for this letter is to please request a copy of my marriage dissolution agreement to properly prepare for this hearing. I refuse to be blindsided, as I was for the last. Open paren, petition for relocate, closed paren. I've asked for my husband many times, as well as you, Judge Dean, verbally and in writing, with no success. This document is a must, all caps underscore, for this hearing, and only fair that I have also. Please send at your earliest opportunity or refer me to where I can obtain immediately underscore. I've been asking for this for over 3 years. I want the same advantage in having this document and what the entire hearing is about. Thank you for the opportunity. Sarah K. Boone. See, her address is the P.O. Box. Okay, I'm gonna go back to just saying all caps because my throat is hurting from trying to yell with the all caps. Okay, so then we have on May 2nd, notice of appearance. Comes now Frank J. Bankowitz. Well, this is attorney number 6 for those of you guys who are following the murder case. And hereby files his appearance as attorney of record for the respondent / former wife, Sarah K. Boone. And the above captioned matter, which is Brian C. Boone v. Sarah K. Boone. In the above captioned matter, and further request that copies of all future pleadings, correspondence, and all communication on behalf of the respondent, former wife Sarah K. Boone, be sent directly to the undersigned attorney. So Sarah's going to get cut out of all the communications. Now, why she would want that, I don't know. Because at this point, it's 23. She's already complained about having enough contact with Bankowitz. This is the year he's going to leave her. They were just in front of the judge in December. I think that's when he had his car accident and he came back. Anyway, I don't think she's called him a dud yet, though. Anyway, he weighs in. And then we don't have anything else until June 28th. And this part is weird to me because you see this up here. August. She sent it in June. All of July. I don't know where this letter was. Although, now that I see this, there's no address up here. She just sent it. I guess I had to figure it out. June, and you know she has 2 cases, so I'm sure Miss Tiffany Moore was like, what the what? And then somebody wrote, I think this is the number, file number. Anyway, whomever actually reads and cares, if anyone. So no more Honorable Judge Dean, no more Henrietta Coffey, whomever, if anyone cares. Why are you continuing to enable former husband, petitioner, Brian C. Boone, to break the law and lie to the court, never being reprimanded or even asked about anything? I mean, I would take it that the judge doesn't care. That's why he didn't ask him, why haven't you done it? And they've already told you that maybe she hasn't she should have gotten it by now, June 28th. He can't be held into contempt until the modification request has been heard. Rosenbaum v. Rosenbaum, or whatever that was. Rosen something. The judge, in any case, is supposed to be a teacher and guardian of the law. No, they're not. Who are they teaching, ma'am? Not the lawyers. That doesn't make any sense. Which includes, they might school somebody, but they're not going to be teaching them. The judge, in any case, is supposed to be a teacher and a guardian of the law, which includes all rights to all citizens of the United States, no matter being rich, poor, smart, stupid, without an attorney. Everyone, including me, who has avidly and diligently fought hard still, parentheses, and tried everything, all caps underscore, I can to be treated fairly, properly, correctly in my case, and from experience, still, in parentheses, am not, or have been, ongoing and repeatedly. What? I don't know what the experience has. And I don't know ongoing and repeatedly. Like she's not being treated? I don't know what that means. Something, she's complaining. I do not want to be lied to or laughed at by anyone. I don't think anybody does. I feel like that kind of goes without saying, unless, point me to the case where somebody wanted to be lied to and laughed at. The judge and court, same person, same entity, are allowing underscore former husband to do as he pleases. He has money. I rot in jail in preparation for prison, in quotes. So maybe that's what Brian told her. I have nothing. Keep losing. To make the court aware, former husband and his attorney, all caps underscore, lied to everyone and myself during the trial for his temporary petition to relocate. She has trial in quotes because it was actually a hearing and she knows it. To relocate on 3/29/23, where he was granted permission to take my minor son away, all caps underscore, temporarily, and move well beyond the 50-mile radius to that city they're going. During this trial, when asked by his attorney, former husband stated he would be renting a home temporarily. Renting is all caps underscore, a home temporarily is all caps underscore, which was understood and granted as being temporary until my case currently is settled and complete. They are buying and moving permanently, all caps underscore. I was told by my son. See, you shouldn't even be discussing the house with your son. This is where you go wrong. That is grown folks conversation. Their house is under contract and in the process of undergoing inspections to be completed next week. All caps underscore, this is not temporary. How is he allowed to keep lying? When someone buys a home, it's permanent! Exclamation point. Now she knows that's not true. He can sell it just like he sold the other one. He calls me a murderer. He doesn't care in the least what will happen when everything changes.
What will my son think? No one knows the future, and how dare anyone to assume they can. All caps underscore.
So he doesn't care in the least what will happen. I mean, he might care, but he needs to focus on what he has going on right now. He's trying to get his house sold, get all the inspections done, get a new house bought, close on that. Ma'am, he don't have time to be worried about what you worried about. Y'all have his first priority right now is the child. Your first priority is annoying people, apparently. How can you allow former husband to keep lying? Now, do you think Judge Cranick allowed you to lie while you were on the stand, or do you think that's just a thing that happens? He is held accountable for nothing, all caps underscore. I haven't even processed the fact they were even allowed to move before anything has even happened in my case, if it even will. And after I was told by the judge, nothing will because you can't have a trial before a trial. That's a lie. It's already happened once without any warning, unfairly and deceptively. Again, people are always out to get her. Only her. Everybody, it's Sarah against the world. So I'm trying to figure out the trial before the trial. Is it that he doesn't want to have the trial about the family case until they have the trial about the murder? Because the other one was clearly a hearing and not a trial. Sugar Bear's playing with Liberty. They're chasing each other. Judge Dean, what happened to my constitutional rights you stated he was and still is violating during the one and only status hearing there's been? Your constitutional law, the judge said, what constitutional law? What constitutional law? Where in the Constitution, Sarah? There has been in this case, and in which I keep trying to set another for it to just be canceled and me laughed at by everyone. My rights are being violated and approved by you. Which rights? When is former husband ever going to be held responsible for any of his innumerable lies? All caps underscore. Not paying alimony, moving temporarily, etc. 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 I don't know why she put the moving in here because that was court approved. He's explained why he's not paying alimony because he's put in a modification and he's waiting on a hearing. I don't know what she wants him to be held. Like it's the vengeance in her. She wants to punish him. He's taking care of your shared child. Why are you trying to punish him? Where are the lies? Prove that they're lies. I keep being lied to by everyone because I am incarcerated and have nothing. Take. This is not a justice system. So I don't know why she put this in quotes, and it's particularly odd because she could have just put justice system in quotes, but she put it's quote justice in quote system in quote. I don't know what that means. In any way, on any level, he lies, gets everything and approved. I tell the truth, get nothing. Sarah, stop it. Are you standing outside? Watch out for lightning, because you don't know the truth. The truth ain't in you. I can't even get a copy of my still, all caps, underscore, active, all caps, underscore, dissolution of marriage agreement to know what exactly I'm, all caps, underscore, owed lawfully. What else should you be owed besides the alimony, which we have said is on hold until the modification hearing? My former husband, because now I'm told I have to pay per page per the marriage department. I've written 2-3 times, and all caps underscore no one will supply otherwise. Well, that sounds about right, ma'am. Also, I cannot have an outside source print mail from being non-public. Please grant my motion for a case management hearing and without cancellation. So Brian C. Boone, former husband petitioner, can lie directly to the court again. When asked why he's now buying a house and why he's all caps underscore still not paying alimony after he has been ordered by the judge and court to twice. Judge and court, same people, twice. The judge has said pay, I guess. I don't know. I didn't see it in any of the orders. I did go back and look. Along with all my other all caps underscore undeniable concerns, I've been trying to have addressed for almost 4 years. So that is a lie. She's not even at 3.5. This is June 28th. 3 years was February 25th of 2023. Also, I don't understand why she thinks that all of her concerns have to be addressed. Like, I have many concerns. None of them are addressed. I have concerns like, why aren't all the subway stops ADA compliant? You know, I have a concern. Should I just start writing judges? This court is all caps underscore allowing former husband to be in contempt and to continue being in contempt while I am and have been robbed of underscore everything I need, want, and double underscore should have by law. Hopefully, also, this motion for case management, if granted, will be recorded correctly in the minutes or whatever new order may be granted to former husband, unlike the motion for temporary relocation with its numerous clerical errors and document defining mistakes. Apparently, Judge Jean, you don't read those either, and underscore should. So I don't think he's supposed to correct motions. Now, if she has an issue with the order, then that's on the judge. But the motion was written by the attorney. And why the F would you say that to somebody who you're asking a favor for? Apparently, you don't read. What? She's just balls of a burglar. Still waiting to see what justice is. Peons count 2. So I guess she's calling herself a peon. I have all caps double underscore rights. I have rights. Then she goes on to motion for case management hearing. Comes now. Sarah Boone respondent submits her request to the court for a motion to set case management hearing to be scheduled at the court's earliest opportunity for further explanation, clarification, and resolution of the undeniable concerns still pending. Okay, random thought just popped in my head. I wonder, because now that we know, based on what Dr. Warner said in her deposition, that Sarah had like clerical receptionist type jobs. Maybe she was copying stuff at work, and that's why she doesn't think about like copies cost money. Like the copies aren't free. Paper's not free. Ink's not free. Electricity's not free. But she doesn't want to pay for it. Somebody else should pay for it so she can have it. That doesn't make sense to me. For further explanation, clarification, and resolution of the undeniable concerns, undeniable all caps underscore still pending. 1, remove all caps underscore non-public status online to view / print my documents. If unable, please explain why. The non-public status makes it all caps underscore impossible to utilize any content I need from the website since no one will provide for me and cannot obtain anywhere else. Have former husband Brian C. Boone explain reasons for lying to the court regarding buying a house when stated under oath he would be renting and was part of the granting of his temporary petition to relocate. So we just read the order for approving the temporary. Nowhere in there did it say because he's renting, that he's not buying, that's why this is being approved. There's no even criteria because, right, the criteria was listed in the italics above where the court put his response. I just don't. What? And if you're going to say, so one, there's no legal basis for that, right? It's not, there's no criteria for that. Then two, why are you calling him a liar? This is the father of your child. Why not say he misled, soften it a little bit. Like she's trying to use the most inflammatory words because she's upset and she's trying to incite anger in the judge. Little does she know that's not how judges get down. So what if he buys a home? You should be focused on your case. Please supply a rightful copy of my still active all caps underscore dissolution of marriage. It may be a rightful copy, but you don't have a right to get it for free.
Have former husband Brian C. Boone explain reasons for lying to the court about paying alimony underscore to Sarah K. Boone and not all caps abiding by the all caps underscore still active dissolution of marriage or direct orders by Judge Dean.
And again, I don't see an order where he was told to resume and the other attorney, his attorney, Brian's attorney, has come back and said
He can't be held in contempt.
which is kind of like he can't be forced to do it, right? They can't hold him. You have to hear he's already said, look, I'm having this situation. I'm guessing she's saying it's still active as in it's still enforceable, the alimony part, because it's settled. In fact, he's trying to get that modified. Anyway, or direct orders by Judge Dean, he delegates what I can/cannot purchase with my owed alimony funds. Also tells me to stop relying on him and being annoying, begging all the time, then pay my monthly owed lawful alimony so I can get another account to be deposited in after letting my 30-year bank account close due to non-payment of alimony so I can stop calling every week or every other day. Not every week or every other day for commissary funds. You guys are not in a relationship. She should call to talk to her son, and that's all, right? And not involve your son, not make him a messenger for your hot meal, which I have had to do ongoing for years, to be added to my jail account and not have to talk to former husband. You don't have to talk to him now unless regarding my son. He makes me have to call and be annoying for all caps underscore everything for nothing. So just to ask for everything and she gets nothing, I think is what she's saying. Just pay like you were supposed to. Like you're supposed to be, and make everyone's life easier and less stressful. I do not want to be in regular, unnecessary, all caps underscore, contact with him unless necessary. That is redundant. I don't want to be in regular, unnecessary contact unless necessary. If it's necessary, then it's not regular, unnecessary contact. Have former husband Brian C. Boone explain why I can't or could have been asking since last case management hearing on 9/19/2022, stored my car, oh my God, all caps underscore, my last ultimate resource on a paid lot. Wait, what? What does that have to do with Brian? Why would he care? I'm looking at this again. This part doesn't make any sense. Have number 5, have former husband Brian C. Boone explain why I can't or could have. I think she means could not have. And then put been asking. She's been asking since last case management. So, which was September of the prior year. So it sounds like she lost her car, but how can that be from non-payment? Well, she says non-payment of owed alimony, but her Kia Sorento was a 2011. Oh, but you know what? I guess I'm assuming that she bought it new. Anyway, her last ultimate resource, I don't know what her other resources are, on a paid lot. I cannot see my son all the way in that city go anywhere to get my life back in order when, not if, the time comes. I have been forced by former husband and the court to lose my car from non-payment of owed alimony and his permissible contempt. I don't think the court had anything to do with that, man. And I don't know, like, you can't expect your ex to be doing all these things for you. Like, let him move on with his life. The only thing you guys should be talking about is your son. And I'm talking just in general. You shouldn't be giving any orders. Just be curious and listen. Number 6, explain how former husband Brian C. Boone can purchase numerous frivolous items such as a bidet plus or minus $1,200, virtual reality video games, controls, headgear plus or minus 1K, alcoholic beverages, in parentheses, rum. So wouldn't that be an alcoholic beverage? Because, well, maybe she's counting all the bottles of rum. I don't know. 2 to 3 times a week. How does she know that? Unless she is bothering her son, how could she possibly know that? Packs, plural, of cigarettes every day. So he's buying at least 2 packs every day, ma'am. Eat out, order in food every day. But he, all caps underscore, but he cannot or will not provide my alimony payments so I can purchase what I need, double underscore. It was a question mark. Not provided by, will not provide my alimony payments so I can purchase what I need. I never, and never is double underscored, all caps, have what I need and still do not. And how is that Brian's problem? You know, it's interesting too when she's saying that she needs this car to get everywhere because, honey, you had the car before and you didn't have a job. And I don't know, when you say get your life back in order, when was it in order? I don't think the Kia Sorrento can get you there. You need that DeLorean. Go back to the future. Come on, Doc. She's so strange. Like her processing is so odd. It's consistent though, so it's not like there are times where she knows better, you know? I believe her when she says she's doing her best. It's not good enough, but she's doing it. Okay, number 7. Solidify verbally and in writing why the court is permitting former husband Brian C. Boone to continue being in contempt in not paying my alimony here when it is not, double underscore on the not, stipulated or included anywhere in the still active dissolution of marriage regarding incarceration for either party. This is my only source of income for everything. That is not his problem. That is not the court's problem. Also, it's June. Where is Bankowitz? Why is she writing directly to, who was it, Henrietta and Judge Michael Dean? Number 8, have former husband Brian C. Boone explain why he lies, all caps underscore, about ordering anything for me when he, all caps underscore, does not and says he does. I have received reprimands from arguing with vendors and officers over the phantom orders that were never placed by him. Why? Is it funny? For almost 4 years, I cannot purchase what I need or want because he withholds alimony. There's a star or an asterisk. I can have someone else order whatever for me whenever and know it's done and on the way. No lies, no problem, no abuse. Former husband just needs to pay so I can without him. Again, he makes me rely on him just to lie and abuse and laugh at. Number 9, have former, are these things numbered right? Was the other one 8? Oh, yeah, it was. Okay. Wait. Have former husband Brian C. Boone explain why he lies, all caps underscore, about him sending anything from my son. Why would he be sending things from your son? February 14th, 2023. Valentine's Day card. Former husband collaborated with my 12-year-old son to lie to me after making me a card about making me a card. Both said they went to craft store and bought supplies. My gift to son had son sit down Sunday afternoon and make, then mailed the completed card the next day. I was told my son wrote me a letter and drew something nice for me. I was really going to like it. It was all a lie. It looks like she's writing faster. It was all a lie. They never went or did any of it. What an awful, unnecessary lie for no reason. Nonetheless, former husband had my son part of the awful lie. How disgusting and hurtful. No card ever. May 14th, 2023. Mother's Day card. Former husband has told me 3 times now my son has mailed my created card. Nothing has come. Another despicable lie. Why? So hurtful. And son included. Now, how is the son included? Because she said the husband, the ex, told her 3 times. It doesn't say anything about it. The son may not even know if this was even ever said. Present date. Pictures. Lies every time. He has sent them over and over and over and over with nothing received. The pictures are ordered from a professional website. Other inmates receive pictures regularly, weekly. I even had the solution, see that handwriting, to have him send anything, everything in my friend's name. Nothing, ever. And keeps lying, 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 lying. So she probably suggested that because he kept saying he didn't want to use his card in the jail. So then she was going to have him send it to the friend. He don't want to send it, girl. Stop asking him. This is abuse, mental and emotional torture. I don't know why it's torture. I don't know why it's emotional. Is it abuse? I mean, is lying abusive? Because if so, honey, you are the queen abuser. Oh, the dogs died. Oh my God, I didn't see that before. I have pictures too of my now deceased dogs. I need for a visit explaining the importance to former husband, waiting ongoing now for 2 months with nothing. And I need these exclamation points. See, so she's engaging the judge as the manager, like, tell him to do this, tell him to do that. But I mean, I guess he could get contempt, but he doesn't have to send you pictures. Like, why him? Of all the people on the planet, why does he have to send you anything? But pictures, there's no court order about the pictures. You see how she kind of rants on? It's all like about what she needs, what she wants. There's no legal basis for that. She doesn't even say what she needs it for. I'm sorry that the dogs died though. I've already, did they both die together? Did they go to the pound? I'm really interested in, what was it, Tess, and what was the other one? I think Tess is the deaf one, was the deaf one. Oh, I'm bummed about that. But they're probably in a better place. They probably miss George. They want to hang out with him. I've already been unprepared for one attempted meeting, which was rescheduled from not having the pictures and still waiting to receive in time for the next. This is all going to be caps and underscore. Need is double underscore. These pictures. This is important. Important is double underscore. I need these pictures. This is important. Do you think like the double underscore is she's like stamping her foot? Why is it some are double and some are single? There's some sort of emphasis. It just sounds like a lunatic is writing this. Though. Can you imagine like if you are, what was her name? Henrietta reading this? Like you would, I don't know. I would call the jail and tell them they need to get her into a padded room. And what example is former husband Brian C. Boone setting for my son by all his lies all the time? Well, it can't be any worse than the example you were setting for your son. That it's okay to treat women this way. Nonetheless, his mother, my son is constantly conflicted with how he is supposed to treat me and act towards me because of what has been said to him about me and my family and is afraid dad. Now why is it quotations for dad, Sarah? Do we need to get a paternity test? Is Maury, let me call him, is afraid dad will be mad because he's not being mean enough to me. Can you guys, that doesn't even make sense. Like Brian would sit there and be like, be mean to her.
Be mean, be mean. I'm gonna be mad at you if you're not meaner.
My son continuously puts me on mute, all caps. Also, that I don't hear. Does she mean also that I don't hear? Like ALL? Oh my God. That I don't hear what dad is saying while on the phone with me. I think so I don't hear what dad is saying to him while he's on the phone with me. There, she could have used some extra words. My son is a different person, not double underscore around him. Number 10. Her former husband, Brian C. Boone, explained to the court why slash how he believes it is right, oh my God, and appropriate to call me a murderer. Why would the judge need to say anything like that? Oh my God. To ask why he believes it. I mean, you are, well, now you are a convicted murderer, and keep slandering me, speaking ill of to my son, laughing at and mocking. You know what? We all should laugh at ourselves every now and again. We really should. So join in the laughter so he can laugh with you and not at you, Sarah. Have former husband Brian C. Boone explain why he never communicates anything to me, especially regarding my son, which will avoid any additional confusion and hurt. It's not your hurt, your butt hurt. It's not Brian's job to make you not be butt hurt. I don't know what you're confused about. Everything has been given to you in writing. Although I'm wondering if you got the letter from the judge. Was it the judge? It was Brian's attorney that they need to have the hearing on the modification before he is required to keep paying you, or before he can be held accountable, penalized for not paying you. The fact that she wants him to send her $1,000 and he doesn't have a job and he has her son, to me, is like utterly ridiculous. Because he got a bidet, he shouldn't have a bidet. So you who committed a crime can have snacks? Girl, let them get them the little booty squeaky clean. I just I mean, even if he was a millionaire, which we know he's not, he's unemployed. And she's like, "Where's my money? Where's my money?" We're calling every other day. Like, he's not stressed out already about looking for a job, packing up house, getting up. You know what I mean? He's got a lot going on. Plus, his son is not doing great. He's worried about his son being bullied and everything. I mean, there's a lot already going on outside of your drama, Sarah Boone. And why he feels it appropriate to decide don't matter underscore in my son's life. Nothing I say or do is important, and only former husband's decisions, reasons are the best. When did he say that? Is it in a call? Because all your calls are recorded. Like, when did he say you don't matter? Then she goes on to say, I am not double underscore convicted and still have all double underscore my rights intact double underscore 12. Have former husband Brian C. Boone explain, girl, can you imagine? Have you guys ever gone into a court and the judge is like, okay, sit down. Now I'm going to ask you this, just explain. And then what is he going to do with the answer? The answer is solely for Sarah, because if he calls you a murderer, that has nothing to do with your family law case, unless he's saying it in front of your son, which you don't know because you're not on, well, I guess you have video visits. You're not on FaceTime on the phone though. I don't know. Just like, girl, worry about something else. I don't know. Do something related to your case. Have former husband. I wonder if this is the time, yeah, when she was ratcheting up on Banquet. She wanted things to move faster. I don't know if she thought she was going to be acquitted if it went faster, but I feel like she was like trying to get a trial date on there, at least to be like, judge, don't let them leave until after the trial starts, or something, if she really thought it was going to be in 2023. But we know it will be 3 attorneys later before she got to trial. He thinks and assumes he knows all there is regarding being incarcerated, more than me. Is that a flex? I don't think it's a flex you think it is, Sarah, that you probably know more than him, but he's assuming he knows more than you and you're insulted because you've been in jail so long? He thinks and assumes, oh God, wait, I just realized this. You see this? She's underlining ASS. You remember what? I don't know what grade it was. Don't assume, it makes an ass out of you and me. And so is that the first time she did it? Yeah, she did that on purpose. Assumes he knows, and then he thinks and assumes, she underlines it again, ass out of you and me. Except she's doing it with the S. I always heard it, you'll make an ass out of you and me, not an ass out of you and me's. But anyway, it's Sarah. He knows all there is regarding being incarcerated more than me. He thinks and assumes he knows how it all works. The letters I write, how much commissary costs, and the constant price raises. Raised prices or price increases, Sarah? The regularity and cost of my medical expenses that I am charged every day to be here in OCCD. One of you guys put that in the notes. I thought that was so interesting that they charge the inmates to be there. Rules, regulations, etc. He knows nothing about anything, all caps underscore. I tell him I have printed documents showing all costs incurred since being incarcerated so he understands, and in which I have prepared as my evidence, all caps, also have recorded phone calls. So did you record the phone calls or you have access to them? For my contempt hearing, which has been postponed, allowing former husband to, all caps, continue contempt and stop being so simple minded regarding my case. Wait, what? Which has been postponed. Is she telling the judge to stop being simple minded, or is she saying, oh my God, have him explain is the first sentence? So maybe this is about, no, he can't explain to stop being so simple minded. I don't know. I mean, girl, your case is open and closed, unfortunately for George. Stop being another ignorant. And so I'm not going to say that word, but it starts with an R and it is a slur for people with mental disabilities. Follower of all the other ignorant R words, slanderous, or just inappropriate, rude, inappropriate. Followers. Oh, do you guys see that? I'm going to make it a little bit larger. Oh, shh. Stop. This shush is all caps. I feel like it was in that recording. It was all caps, right? Shh. Like a threat almost. Which is like, shush is something you tell a baby on their way to sleep. And only Sarah could turn it into a threat. Undeniable orders by Judge Michael Dean to Brian C. Boone, former husband petitioner, have not been upheld or abided by and are in violation as ordered. So it's not undeniable, though, Sarah, because he requested a modification hearing. They continue to multiply in severity and duration of time and destruction, being unlawful, extremely inappropriate, and altogether wrong. Former husband is in contempt, stealing and lying to the court judge, myself. Respondent. Oh, so court and judge are the same, lying to Your Honor and myself, respondent. Wherefore, Sarah K. Boone, respondent, respectfully requests that this honorable court, now see, there she gets it. Honorable is the judge and the judge is the court. I don't know. Please grant this motion and enter its order to set and keep a case management hearing. So he's going to give himself an order, Sarah, regarding all undeniable. Maybe she means like uncontroverted, because what's stopping people from denying it? Do you know? Like, because she says it, they can't deny it? Okay. Regarding all undeniable aforementioned legitimate overdue concerns and owed explanation. Honey, he doesn't owe you anything. The sooner you get that down, the better off we'll all be. Owed explanations regarding and from former husband and petitioner Brian C. Boone. So owed explanations regarding and from former. If he owes you explanations regarding him and from, girl, what? He doesn't owe you anything. Let's full stop. Sarah K. Boone, respondent, has attempted private resolution, cooperation, and discussion with petitioner numerous times over the past almost 4 years. Not even 3.5 right now. While incarcerated, being unsuccessful in every aspect due to the fact, foremost, former husband, Brian C. Boone has the understanding from the court. His behavior, degrading / inappropriate comments, and ongoing lies are approved and able to continue. He has that understanding. Did he tell you that? Did he say the judge is not going to hold me accountable? She's, oof, infers a lot. Let me say that. Clarification, remedy, and solidification are requested. Are we making jello? Solidification of what? Are requested for all undeniable concerns for all parties included in this case to avoid further confusion, difficulty, all caps, double underscore, lies, and abuse going forward, especially for respondent Sarah K. Boone from petitioner. You guys are the only two parties. It's literally him versus you. What are you talking about? Who's confused? You make it difficult. I don't know. This is like, it's telling you someone you're going to do something and you don't do it. If that's abuse, I'm sure you've abused your son, because I feel like you have probably promised him some things that you still owe him. Did I ever tell you guys when I was 8 years old, for my 8th birthday, my auntie was going to take me to IHOP because I was a fool for the chocolate chip pancakes, and I had a coupon and everything, and she said she was going to do it, and then she didn't come, and she was like, oh, I'll do it later, and she kept saying that, and then I think my mom felt bad, and she was like, let me see the coupon, babe. And I showed her to her. She was like, the coupon is expired, so it doesn't matter because you're not going to be able to get that special, so maybe don't bother her, And I was so confused about how the coupon wouldn't come back in. I mean, yeah, like I said, I was 8. I just thought like the years returned, just like the months did. You have January, you have February, every 12, 13 months. I just thought like the years were that way. Anyway, is that abuse? Because I'm sure Sarah's done something similar where she said she was going to do something with her son and then it never came to be. Okay. This other one, that was June 29th, but remember it wasn't logged until 8/1. Like, as a reasonable well, what am I saying? She's not reasonable. As a mom, like, don't you care at all about your kids? That $100 will be doing a lot more for your son than for you. I don't know. My mom used to tell me there's two kind of women: the ones that will make sure that their kids eat, and the others will make sure that their man eats and their kids got to fend for themselves. This one, she's gonna make sure she eats. Everybody else be damned. Okay, here we go. 10/6. So this is almost a month later because this is dated September 5th. Did I get my papers out of order? Good Lord. No, okay. September 5th. Judge Michael Dean, regarding Sarah Boone / Brian Boone. She's got him reversed again. Motion to read letter from respondent and schedule case management hearing. All caps. Judge Michael Dean, in all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from former husband. What cruelty? What hate? What degradation? Nothing has been improved, made better, corrected, relieved in any way for myself, the respondent, from former husband, the court, or judge. I have tried everything. I have made innumerable requests and sent many letters asking for aid from all, with no success or assistance. Listening. Oh my God, it's her in the serial comma. With no success or assistance, listening, or care by anyone other than myself, trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. Sarah says, you sound bitter. You sound angry. You doing wrong because you should not be sending this letter to the judge. I don't know what he's done that's inappropriate. Oh, calling you a murderer. I don't know if the judge can make him stop saying that. You did admit to murdering him. Please see list below of my letters sent to you and court per the Records Management Division of the Clerk of Courts. When for the third time tried getting a copy of my active, all caps, dissolution of marriage agreement, all caps, I cannot have because they are wanting payment in order to receive. And I am in jail. I also have no bank account after the one, oh my God, I had was closed after having for 30 years due to non-payment of alimony from former husband and stated in prior letters. So I went back and looked. The 2021 letters are only from the court to her about the address mix up. And then for 2023, this 420 letter, although I did say my childhood best friends earlier, I didn't count it, but now that I'm saying it, I did say that that was Ishlatia's birthday, so whatever. For sure, these on the 21st were just inquiries, or not inquiries, I guess announcements from the court to Sarah, like, hey, if you want your money, we need a good address for you. It is appalling how uninterested, uncaring, and nonchalant you and the quote justice in quote system, oh, system lost its own quotations, are about my side in any of this and will not listen without the right paperwork and attorney, knowing I am actively being taken advantage of and wrongfully. I wonder if she was writing Bankowitz at this time and we didn't see it because she didn't copy the judge. I'm just trying to figure out, why is she still writing the judge while she has an attorney? Actively being taken advantage of and wrongfully mistreated by former husband, Brian C. Boone. You have continuously enabled him. Now she's attacking the judge and given him a self-appointed right. If the judge gave him the right, it's not self-appointed. If Brian gave it to himself, it's self-appointed. You mean something else. And understanding to keep doing, saying, and taking everything wrongfully and illegally from me, including and especially the love and respect for my son. It is not okay. Quote, you're a killer. That's why I'm not, parentheses, doing anything, end quote. Former husband said in front of son on phone. Prove it. You are not important to anyone. Former husband, numerous dates. You are not priority. Former husband, numerous dates. Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. See, this is exactly what the parenting plan said not to do. He shouldn't be a messenger. Why would you be asking him to ask his dad if he ordered a book? Ask the man. Or better yet, wait and see if the book comes. So this, for those of you guys in the know, help me out. Hot meal. So I know you guys said that's like a treat that they get, but then where is it kept? Like, do they go to the kitchen or the whatever cafeteria and give them extra money for this hot meal and then it gets heated up? Is it in a vending machine? Like, help me out because I'm having a hard time visualizing that. I also wonder if they eat on their bunks or is there like a proper place for everybody to go and sit? You know, like when she says, or when the note says she refused her breakfast tray, is so they came and offered it to her at her bunk and then she sent it away. I'm curious about that. Okay, I lie to you because I can. Dad does it all the time. Son, you make no difference in our lives. Former husband, numerous dates, 9/4/23 recent. So does she think the court is going to get those phone calls pulled? Because they're not. That's okay with you and acceptable, Judge Dean? Is that why you are giving him permission for and to keep doing and in front of my son? Why won't you stop any of his abuse, verbal, mental, and emotional? Why aren't you, as my judge, doing anything to hear, understand both sides? What else needs to be done to me by former husband in order for you to help me? What else can I do I have not done already for any relief on my side? Stop enabling. Judicially, you must know this is wrong in how I am being treated. I am told every time when trying to reduce any anguish or mistreatment from former husbands and cooperate trying to help. What? What are you told? I am told every time. You are told what every time? The judge doesn't care what you write, my son says. My son now says the same when I correct him on how he is being mean and rude to me. So, how did the judge come up? When you were telling him he's being mean and rude, did you say, I'm going to write the judge and complain? Like, what? Why is your son even aware that there's a judge in your life on the regular? He's never going to do anything for you until your trial is over. And even then, it will still all be in my favor. So that's weird. He's going to do anything. So it sounds like she's talking to someone else and not just the judge. So he's not going to do anything till the trial is over. And even then, it will still all be in my favor. My other document is ready to go, so I can take the rest. I have an attorney. You deserve nothing. You mean nothing. That's her worst nightmare. I don't believe he said that, but I think that's her biggest fear, is to be alone and be insignificant. Then former husband gets his precious attorney to file another answer denying allegations. Because I'm telling the truth all the time about his awful lies, and I am right. One of my mentors said, don't be right, be effective. Sarah only wants to be right. Judge Dean. So I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate until my trial, if when it happens. No, girl, it's going to happen. However long that will be now, considering my attorney has withdrawn from my case and no date of trial is known or will be for an undetermined amount of time. Okay, so he's already off. There, I think September is when is it Wops? No, not Watson. Hobson came on. How much more hate and disrespect will former husband encourage my son to keep lying and overall being mean to me, his mother? Are we back to the capitalized mother? First letter capitalized. Former husband is teaching and reflecting a terrible example of how women can and should be treated. Nonetheless, the mother of his child. This is egregious and wrong. Please read my prior motion for case management hearing I sent 6/28/23 with no response today. You're not pen pals. I'm requesting again, please, to schedule. It is fair. And there are too many topics to be discussed, including my attorney, to write. And I only have one pen. Necessary, lawful, active, important topics. All of those were all caps. Oh my God. What is the certified notice of delinquent support filed on 8/3/23? Please grant my motion and schedule my imperative overdue owed meeting. Everyone needs and must have the same understanding now and future. It is fair. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated rightfully, properly, ethically correct in order to finally receive your judicial assistance? How I am and have been and will be treated by former husband, Brian C. Boone, is unfair, malicious, and wrong, and should not be any way allowed to continue. Stop. Please see. Please listen. Please help. Judge Jean, what was the reason for your comment made in your courtroom about former husband violating my constitutional rights? If you're not going to help or uphold said rights and lawfully allow me to use, what's the point? Why do I even have? Oh my God, why does she butcher these sentences? You know I do in order for you to remark and see they are being violated. 9/19. Please schedule. It is my right. It is fair. Sincerely, Sarah Boone. Please send a copy of this letter so I know it was received and will serve as my receipt. And then she has this. I'm not going to get into that. Okay. It is 1:13. I have all the lights off because Sugar Bear is sleeping, but I'm going to pause. It'll all be the same time when you guys get there, but I just want to mark it for posterity's sake. I will talk to you guys tomorrow. Ta-da! It's almost a week later, but it's okay. It's the same to you. I realize I think I skipped over Bankowitz withdrawal, so we're going to start there. But let's get into when Bankowitz withdrew from Sarah's case. Now, Bankowitz, you'll remember, he also represented little Miss Sarah for her criminal case. She did such things as call him a buffoon, some other disparaging things, said he didn't meet with clients, called up, all of the nice things that little Miss Sarah is known for. Yeah, she did it. So comes now Frank J. Bankowitz, Esquire, counsel for the defendant in the above styled cause, and hereby request that this court enter an order. So you guys get it. On or about July 11th, Bankowitz was appointed to represent her in her criminal case, July 11th of 2022. And then on or about May 2nd of 2023, undersigned filed his notice of appearance in this case. This was done on a pro bono basis. So while he is getting paid, and now you and I know he didn't get paid until 2024, but he did get paid. Whereas for the family court case, it was pro bono. So maybe he was trying to help her out. I'm not sure. He was definitely doing her a favor for she's not deserving of any favors, in my opinion, the way that she regarded him. Like the level of entitlement, somebody's doing something for you for free and you're still complaining. You get what you pay for. Okay, so on he filed a motion, August 22nd, 2023. He filed a motion to withdraw from the criminal case. And then on September 8th, the Honorable Judge Wayne Wooten granted that order. Remember Wooten? There's a place and a time for everything. He was in the place of waiting, and Judge Tanika is in the place of let's get it done. On the 20th day of September 2023, he's asking to be removed from this family court case. Yeah, and he lasted with her, I guess, 11 months or so, from July 11th until August. Oh, so 11 months until August 22nd. God, learn to count, Tanika. So August 22nd, he withdrew. And then the next month, he was approved for that withdrawal on September 8th. And now here on September 20th, he is like, I'm so over Miss Sarah. Then the Judge Dean ordered and a judge that there will be a case management conference on October 16th. So last correspondence was September 20th. Now we're October 16th. There's going to be a case management conference. Then we get to, did I share that one? I did not. Okay, here we go. So on October 10th, we get an order setting the hearing. Judge Michael Dean has set a case management conference for October 16th, 2023 at 10 a.m. At that point, Brian sends in a letter. He wants to be able to attend via telephonically or via video, like a Zoom type of situation. And then they have on October 16th at 10:03, the court opened in no location. I don't know what that means. Maybe they're all attended via Zoom. Court opened in no location. Okay. You have Frank Bankowitz came, Brian, Sarah, and Joshua Martell. There was no court reporter, court deputy from the Orange County Sheriff's Office. Oh, but it does say hearing held in person. I don't know, Charles. Why is that in no location? Court ruling. The court will take no action on the case management conference. Motion to withdraw is granted. Mr. Bankowitz will prepare the order. Court recessed at 10:21, so it was less than 20 minutes that they had this meeting, and that was all there was. So I was a little confused, so I had to read it twice, but because it sounded like there was no case management conference whatsoever because Bankowitz was withdrawing, but it seems like they got some stuff agreed. So the Judge Dean finds and orders as follows. Both parties appeared for the case management conference, which included a motion to withdraw by the respondent's counsel, Frank Bankowitz. There were no objections to the withdrawal of respondent's counsel. Frank Bankowitz is hereby removed as counsel for the respondent. I hope somebody sent him something like, I don't know, a cake, a bottle of bourbon. Council shall provide a more formal proposed order for this removal to be signed by the court within 10 days. So that's Bankowitz. He's got to send something in. Case management conference discussed the status of the case, including the petitioner's request for a reduction or elimination of alimony and for relocation. So that request for reduction of or elimination of alimony has been out for a minute. The relocation, they expedited it because I feel like it was a notice on early March, and then late March, it was already calendared. The respondent is currently incarcerated in the Orange County Jail pending trial on a charge of second-degree murder. The court cannot hear the respondent's motion for contempt. So Sarah filed that contempt motion for regarding unpaid alimony until after a final hearing is held on the respondent's petition for reduction or elimination of alimony. See Rosenblum v. Rosenblum, Florida 1st District Court, 2015, 1st District Court of Appeals. So that v. Rosenblum reversed a trial court's contempt order because it was issued before the modification action was heard. So this judge is saying Brian has already filed, right, to have the alimony reduced or eliminated. That has to be heard first before the contempt can be heard. If the contempt is heard first, it will be reversed as it was in this case. So basically, cool your jets, ma'am. The respondent expressed frustration. Oh, and you know what this says is held on the respondent's petition for reduction. I think this should be petitioner's petition, right? Brian is the one asking for the reduction. I think that's just a typo. So Sarah expressed frustration. Surprise, surprise, surprise. At not having, do I have... Surprise. Yes, surprise, surprise. Little Miss Boone was frustrated at not having matters heard and not being adequately informed about her case. I don't know by whom. Maybe she's complaining because Bankowitz didn't serve her on that motion. I'm gonna go back now. Oh no, it did go to the defendant at the Orange County Jail, so I don't know what she's surprised about this time, but she's at not having matters heard. Well, I know before in the criminal case, whenever a attorney withdrew, Bankowitz, as a matter of fact, remember they had the JAC there because they were asking for money for a psychiatric expert because it was high profile, nobody wanted to do it, and the money was low.
State of Florida versus Sarah Boone, 2020, CF 2603, state.
Dave Cacciatore on behalf of the state.
Defendant.
Frank Bankowitz.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can I have JAC announce themselves as well?
Yes, Audrey Moore for JAC.
We have multiple matters scheduled, one of which is Mr. Bankwitz's motion to withdraw. My reading of the law is I feel like I have to address that motion first and rule on that before I can address any other motions that would be heard today. So, Mr. Bankwitz, I'll start with you. Tell me why you're moving to withdraw.
Judge, the letters that have been coming to your honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
Ms. Boone, I read your letter dated August 26, 2023, and your letter dated August 30th, 2023. And just so we're clear, I read all of the letters that you send to the court. Whether I respond or not is based on what's in the letter and whether I'm asked to actually do something that's within my purview as a judge or not. If I understand correctly, you have now decided that you think it would be best, in fact, if Mr. Bankowitz was allowed to withdraw. Is that correct?
Yes.
All right. And you understand by him withdrawing, I'll have to appoint another attorney. Do you understand that?
Yeah.
And that attorney's not standing here, so we're not going to be able to address, and I'll give the state a chance to talk to me as well. But assuming I grant this, we won't be able to address the other issues that were docketed for today, which means I'm going to have to reset your case for a later date. Do you understand that?
I'm not sure what items it is you're speaking of. I haven't received a copy yet of the letter.
So we also were having a hearing today in regards to authorization for payment for an expert that your attorney believes he needs to defend you in the issue about the compensation of that expert, which is why JAC is participating today. I don't know if your next lawyer is going to think that that expert's the right person to use, or whether they're going to go a different route after consulting with you. And even if they did, they're not standing here. And once Mr. Bankwitz is out, he's out. He can't argue the motion. So do you understand that?
I fully understand.
All right. So I'm going to grant Mr. Bankwitz's motion to withdraw. I'm going to appoint my list, Attorney Winston Hobson to represent Ms. Boone. In regards to the other matters scheduled today, I'm going to take no action on them at this time until Mr. Hobson can, well, in regards to the motion involving JAC, I'm simply going to take no action on that motion at this point in time until Mr. Hobson has a chance to review it and determine whether he wants to proceed with that motion. I will address the pretrial because today was also supposed to be pretrial.
And they couldn't hear it that day. JAC was there on the screen because they had to hear the motion for withdrawal that was submitted by Bankowitz. Once it was accepted, it became moot because what if her new attorney didn't want to use this expert? Do you know what I mean? But Sarah tried to pretend like she didn't know that was going to cause a delay. So maybe in this matter as well, which would have happened after that, right? Because first Bankowitz was granted withdrawal from the criminal case. I don't know. She's always like pushing things right to the edge. And it's like, I'm going to try this. Unfortunately, her behavior oftentimes will get her what she wants. And so she's encouraged to continue that behavior. And I think it's happened her entire life until this case. And so I think that also is a bigger sense of frustration for her that she wasn't able to talk herself out of it, you know, like after she's been doing it at that point for 42 years. The court explained that the family case is on hold pending the outcome of the respondent's criminal case. And see, because it says the court explained, I feel like it was explained previously. Nonetheless, as Ms. Boone would say, it's here now. The court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case so that circumstances are clearer. So we're going to get rid of the crystal ball that Ms. Boone is accusing everybody, and we'll just wait then. Stop rushing. We will wait. Which is bad for Sarah because, you know, she's wanting that alimony for her Zuzus and Wham Whams. And so she has to wait until that other, she really won't need, I mean, technically she would need it, right? If she had some act right in her, she would need it because it would help her get established. But she's thinking like she needs it now for her list that she's given us, a deodorant that works. And like, and also, do you guys think they're selling deodorant that doesn't work? Or is it, the jail doesn't give me like organic vibes of like they have, I don't know, Toms in there and she's giving it a little diss by saying it doesn't work. The fact that she wants this money and this man is taking care of her child, it just shows where her head and heart are. She would rather have deodorant than for her son to have all of his activities. Even in the thing when she was like, he bought a bidet. Okay, ma'am. And it just reminds me of like for my oldest daughter, I remember I got a new car and I drove it to her paternal grandmother's house. And she was like, well, you don't need child support if you can afford a new car. That's not how that works, ma'am. The child needs support. She can't eat the tires on the car. Anyway, so that circumstances are clear, the respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction and her own contempt motion, but that the court would have to consider her current status of incarceration when making determination. So I feel like there's probably a little bit of back and forth, a little bit of Sarah of like, well, I don't understand. So they told her, yes, you can file for the hearing if that's what you want to do for the final hearing. But as part of it, the alimony reduction elimination has to be heard before we can hear your contempt. So if you're saying you want to have that happen, we can make both of them happen. But keep in mind, the fact that you're in jail is going to be considered. So either you can wait until your case is settled, or you can file it now knowing I'm factoring in your incarceration because you're presently incarcerated, right? Basically, if she forced it, then she was going to get no money, and I shouldn't say, and she was going to, the relocation, because they're not talking about it here, but she was going to get no money because you see that was October 2023 and nothing has been filed or pushed. So the respondent was advised to ensure that any motions filed conform to the rules of procedure, general practice, and judicial administration, which I feel like that was, oh no, maybe she wasn't. No, she wasn't pro se yet in the other case. This includes utilizing proper captions, titles, and certificates of service. That was the 16th day of October in 2023. Mr. Bankowitz finally got around to sending this order in November. Judge Michael Dean signed it on the 17th day of November. So like a month and a day after he was officially removed. So that was it for 2023. We have a couple things for 2024, and I'm imagining something will kick up maybe in January, February, like 30 days after her sentence, and they'll do it on the current state, not on the wish list of an appeal that I'm sure she'll be filing. Okay, so March 5th. 2024, this is filed in the Circuit Court of the Ninth Judicial, and it was copied by the clerk's office, sort of askew. I didn't do that. This is from Sarah, pro se respondent. I don't know why she doesn't do just respondent. It's for sympathy, because she doesn't say Brian C. Boone and then put how he's represented petitioner, but she makes sure to put in that she is working as her own attorney. Per the Florida Family Law Rule of Procedures, Rule 12-200, Case Management, scheduler hear motions related to admission or exclusion of evidence. So this is in regard, her open items are the money, the alimony, and the relocation. 12-200 Case Management, oh, this is another section. Consider any agreements, objections, or form of production of electronically stored information. Comes now Sarah K. Boone, pro se respondent, submits her request to the court for her aforementioned motion to be approved, generated by the court and received by pro se respondent to submit to instructing previewed corporal and sergeant of the Orange County Corrections Department to receive admissible evidence against Brian C. Boone. What? Her request to the court for the aforementioned motion to be approved, generated by the court, meaning she will not be writing the order. The court needs to write the order. And received by pro se respondent to submit to, instructing previewed corporal and sergeant. Is there only one corporal and only one sergeant? I'm serious. I don't know. Anyway, in the form of, so I guess she's saying this corporal and sergeant are meant to gather these, and she needs the court to direct them to do so. If I misinterpreted that, listen, you let me know. Correct me, as Mr. J would say. Correct me then. I love me some Mr. J. Electronically stored information on tablets and all messages sent from pro se respondent to petitioner. How would that have anything to do with the alimony or the relocation of the child? What? And I don't think the court, I think that's FOIA. You could just ask the jail. Telephonic recorded calls made to petitioner from pro se respondent. Again, it's the jail or the sheriff, not the court. Unless she thinks this is like a subpoena ducas tecum, but it's not. Okay, from the following companies who supply service for the tablet and telephones. 1A, Smart Communications, messages on tablet. And you would think there'd be a 1B here, but no, we go right to 2. Well, actually, we go to 2A. Not sure what happened to B. Global Tel-Link recorded phone calls. In preparation for a proposed case management conference to be requested. Conference hasn't been requested, but this is in preparation for a proposed futuristically requested. These messages and phone calls are necessary to be received prior for the pro se respondent to properly conduct, uphold, and apply to her defense for topics included to be addressed. How would she hear those calls, though? Are they meant to give her, like, oh, do they make Walkman? Don't laugh at me. What do they make? MP3 player? Would they give her that so she could hear the phone calls? But the jail would have those. I don't know why she's asking. But also, what possibly could be on those? She's so vindictive. It has nothing to do with what she's already filed. She's trying to like badmouth him or about things her son has said, which the judge can do nothing about. Because what could you have talked about in 2023, 2024 on the phone with him? Well, hell, since you've been in prison or jail. Sorry, I know, guys. Jail. Maybe he said something nasty to you, but it should have nothing to do with if he can relocate. Because the relocation has zero impact on you while you are in jail, because he visits you via video visit from the comfort of his home, and he calls, or you call him. So he could be anywhere and do that. I know you're hung up on the 50 miles, but girl, you don't even have a car. Nor do you need one. Sarah K. Boone, pro se respondent, has attempted private cooperative resolution with Brian C. Boone. So in opposite land, that means she's been singing the blues to Brian. Brian C. Boone, petitioner, numerous times prior to this motion and request, and ongoing now for more than 4 years during her temporary incarceration. So not more than 4 years. She's writing this in March of 2024, March 5th. She was incarcerated February 25th. No, I guess technically it's exactly 4 years. 4 years and I don't know, 10 days. I guess technically we'll give it to her. It's more than 4 years. After repeated unsuccessful resolution and relief being sought to date by pro se respondent from petitioner and the disobedient, unlawful, inappropriate actions, statements, and comments still occurring by petitioner against pro se respondent, clarification, remedy, proper solidification are requested. Proper solidification? Try fiber. Get more fiber in your diet. Are requested to avoid further confusion and increased difficulty. Increase? Should it maybe ongoing difficulty? Why would it increase without action? Is there more that you're not telling us, or you're saying it for the drama? Difficulty for pro se respondent Sarah K. Boone being inflicted deliberately and unnecessarily by petitioner. So he is inflicting deliberately and unnecessarily confusion and increasing difficulty. Examples, please, ma'am. I love it that she was like, I'm going to say horrible things about people with absolutely no proof. Just take me at my word while I'm waiting to be convicted of murder. This is especially important to pro se respondent to be clarified and ordered immediately, as there is no scheduled trial date in her criminal case where all factors regarding her livelihood and welfare now and futuristically with her son also are being based on presently and ongoing. Yep. So you can't rush one to get to the other. And it doesn't make sense. If you know you're waiting on the other child that doesn't have a date, why are you bothering? Like, you're clear on what was said. You're clear on what process we're following. You just don't like it. All parties, including, excuse me, all parties, including the judge, petitioner, and the attorney for petitioner, have futuristically predicted and conceived this trial will and is going to happen. Ma'am, the trial is going to happen. Do you think you just get to sit in jail indefinitely, firing lawyers and coming up with cockamamie stories and begging to get your hands on your phone? There is no exact or specific date, no exact, no specific. That is a distinction without a difference, of said trial and the ongoing avoidance, lies, self-appointment, and hindrances by petitioner in everything pro se respondent is still trying to achieve, complete, order, obtain, and schedule should not be lawfully continued, will not be tolerated by pro se respondent any longer and ongoing until the unknown conclusion of her criminal case. What, ma'am? Ongoing avoidance, lies, self-appointment, and hindrances by petitioner. So what did Brian self-appoint himself to be? What hindrances specifically has he, other than telling you he's moving? I don't know what he's hindering you from. Avoidance, ongoing avoidance, because you keep bothering him about a hot meal that clearly he is not sending you. Take a hint. So basically, you're blaming the judge. Look what you're making me do. I have to harass him and call him because you won't give me a date. But he doesn't have to give you a date. He's not in charge of that. Whenever that date comes, and it will come, then we'll figure out the rest of this. So basically, he's telling you he doesn't feel like you deserve alimony while you're in jail. If he felt otherwise, he would make the ruling now. That's why he's telling you, if you want to press forward, schedule the meeting. Oh, but maybe that's why she's asking for this. I can't schedule that until I have this. But also then she just gets to vent. Best possible and all available resources should be lawfully allowed, enforced, and utilized by the pro se respondent, regardless of the unknown outcome. And in the meantime of. So she's saying it doesn't matter of the outcome while she's waiting. In the meantime, she wants something to be done. She doesn't want to just be sitting around begging for hot meals. Still active marital agreements and rights for this case are presently in full effect for both parties. Pro se respondent is attempting greatly to use the agreements and rights effectively, but is unable to due to petitioner not allowing, ignoring, or abiding by. Yeah, he's not sending you any more money. He said you owe him $20,000. So take a hint. She will argue with the stop sign. Stop sign says stop. She thought of 99 reasons why she didn't want to stop, didn't think it was right, came back to the stop sign. Stop sign still said what? Stop. Wherefore, Sarah K. Boone, pro se respondent, respectfully requests that this honorable court please grant this motion and enter its order to provide court orders, parentheses, to obtain, and these are all caps, and preserve evidence for pro se respondent to provide court to be used forthcoming in this case. Thank you, Sarah Boone. Certificate of service via U.S. mail to the parties listed in the service list. So Judge Michael Dean and Joshua Martell. Okay. Our last thing filed, the last thing from the court, I believe. Order denying motion for court orders. This cause having come before this court on respondent's motion for court order to obtain and preserve evidence for pro se respondent. Lord. Hereafter motion, and the court having reviewed the motion and the court file hereby finds and orders as follows. The motion lacks a specific legal basis for the relief requested. Right, I didn't see any samples. She gave the rules of procedure, but she didn't cite any case law. As per Florida Family Rule of Procedure 12.100B, a motion must stay. Oh, they quoted the family procedure back to her. Girl, why you reading? You skipped the first one. Or I guess the second one. A motion must state with particularity the grounds upon which it is based and clearly set forth the relief or order sought. So you don't get to just rant about it. Oh, the chicken was pink in the middle, therefore it's not cooked. Focused. What happened? What law says that shouldn't have happened? And what cases can you show that agree with what you're saying? Respondent only cites 12-200, which is not a legal basis. The relief requested. Consequently, in accordance with Florida Family Rule of Procedure 12 4.100b, the motion is hereby denied. Order in Orlando, Orange County, 4th day of March, 2024. So, and a copy went to Brian Boone, Sarah K. Boone, attorneys of record via e-service. In her quest to be her own attorney, she's shooting herself in the foot. Like, she's trying to be her own attorney, but then she's also doing the snark. You literally skipped over the first one that would have saved you the time and energy that went into filing something that was just going to be denied because it did not adhere to the rules of the court. This is June 18th, 2024. And when was it? It was actually received 6/27. This, remember, is when stuff was about to get real in the criminal case, because June 27th, she sent a letter to the court. This was, so June, let me go this way. June 28th is when the judge told her, Zadie Kranick told her, girl, you have forfeited / lost your right to court-appointed counsel. And so right before that, she had wrote the 58-page letter. So maybe this is why she's ramping up, because she's trying to, like, she's feeling desperate, right, about this relocation. And she's trying to figure out when is her court date. And so she's getting frustrated with the attorneys and whatnot, because so she had Bankowitz and she had Hobson. She went through Hobson in only a couple of months, like maybe 7, 8. And then she went through Cashman in 4 or 5 months. And so I think that was, yeah. So anyway, so just that perspective. She wrote it on June 18th, but it didn't get filed with the clerk until the 27th. This is Brian's attorney regarding Sarah Boone, pro se responded. It's interesting that she sent it to his attorney. Initial disclosure _ So this looks like she's given somebody a quote or a definition. A party's required provision of basic information to the opposing party. Initial disclosure is the mandated disclosure of required information by one party to the other, usually within 30 days of entry into the action and without waiting for a discovery request. So initial is literally what it sounds like at the very beginning, because it's saying within 30 days of entry into the action. She's so far beyond 30 days. She got divorced in 2017 and without waiting for a discovery request. So that would just be off the jump before we get into a request for full discovery. So she's asking for that. Attorney Martell, and no greeting like hello or dear, just write to Attorney Martell. As pro se respondent in my case, and per Federal Rule of Civil Procedure 26, initial disclosure, A, in general, I'm requesting all documents contained therein, such as the name and, if known, the address and telephone number of each individual likely to have discoverable information, along with the subjects of that information that the disclosing party may use to support its claim or defenses, unless the use would be solely for impeachment. So who would have discoverable information about why Brian should or shouldn't be able to relocate and why he should or shouldn't pay alimony, along with the subject of that information? So interesting. Okay, a copy or a description by category and location of all documents, electronically stored information, and tangible things that the disclosing party has in its possession. Do you guys think maybe no, because she didn't have any money, traded favors to get someone else to write this? This doesn't seem like the handwriting on her other ones. Or maybe she's just frantically writing. But like the M's are different. The C, look at the C right here. It looks different. And it's someone who's writing from a book or something, right? They're transcribing this. Anyway, she's asking for a bunch of stuff that whoever it is, they're not even reading it. In general, a party must make the initial disclosure within 14 days after the party's Rule 26F conference. They've already had that. This is not a new case. Please note, I'm requesting 3 copies each of the following in addition to the initial disclosure, if not already included. and specifically from the documents delivered to me via service of process. Supplemental petition for modification of final judgment, not filed to date. I was never provided a copy of this as stated in the supplemental petition for modification, joint stipulation for modification, signed by no part. So somebody must be on the clerk of court website, writing these down for her. Petitioners verify petition to relocate, pages 5, including certificate of service with my delivery address. Again, incorrect. Yeah, somebody's on the website. Please ensure the correct copy of this is sent, which include your predictions of my release from prison, page 2. You must include the opposing party in your correspondence to the court. Emails received without the opposing party included will not be addressed. This statement was made to you by the judicial assistant Henrietta Coffey of Judge Michael Dean, 22723, to ensure my rightful inclusion in my case. Please ensure my address is correct, as incorrectly stated on both summons I received and am requesting documents from, in addition to the initial disclosure. My temporary address has also been incorrect on numerous documents you have filed in my case, such as the notice for trial I never received and could not properly prepare for. Trial by ambush is unfair and happened more than once. This is important. Here is my correct address. Again, this is important. I am trying to prepare for this case properly, fairly, more efficiently, expeditiously, and economically. Your cooperation will only add to this even greater. Your understanding of my lawful inclusion and advanced knowledge of your client's evidence will assist me. I don't know why she put evidence in quotation, and then it has her signature, and it looks like she used an envelope for a straight edge because the top of this part is missing. Did you guys ever do that in high school, like to make sure your lines were straight when you didn't have line paper? Because she's writing on the back of it, and it looks like, anyway. Okay, and then the copy of letter request sent to the Honorable Judge Michael Dean. All of that is on there. Yeah, the judge never responded. I don't think, well, not that he should have. I don't know what she was expecting there. Now I want to go back because I'm like, did we go over? So on March 29th, Brian, Sarah, and Brian's attorney are there. They both testified. They were sworn in and testified. And the court ruled petitioner's motion for temporary relocation is granted. Mr. Martel will prepare the order canceling the 413 case management. And then they said the respondent can reschedule hearing if needed. And then the court recessed. And then that's when she went nutty. But I think it's out of pure control. It can't be anything but control. What is the point of like having him tethered to you and you can't actually physically see him, and it's causing him mental and emotional turmoil? Do you know? Like, why don't you let him go so he can be happy, so he can focus on his studies? And it's not. Yeah, her logic it's all over the place. On the one hand, she's like she should be have basically input into like moral things, which I'm wondering if maybe he said something about her being immoral, being a murderer. I don't know, but it was something related to like morality, that she should be able to have input. Well, you could technically have it. Well, let me say it like this. Maybe have influence over him instead of just trying to have control, right? If he trusts you, you guys have an open relationship, you'll be able to talk to him about things and let him decide, but he doesn't have to do what you say. So if you feel like that's part of motherhood, that children are supposed to just do what they're told, that is incorrect, ma'am. So yeah, maybe that's it. Like she wants to force him to have to listen to her. She wasn't going to be ready for teenage years at either rate. She wasn't going to be ready. I mean, unless she was going to start physically attacking him, because if he didn't want to do something, you weren't going to be able to, you know what I mean? Like, you're setting yourself up for a bad situation when you are teaching children that because I'm bigger, stronger, or whatever, you have to do what I say. Because one day they might be bigger, stronger, or whatever than you are. So are you going to just have to do what they say? Be careful what you wish for. All right, everybody. Thank you for hanging out with me. I don't know. I wasn't ready. I wasn't ready for that, but it's very interesting. I may want to go lay like a timeline of the family stuff. I mean, I'm not, for myself, I can't even promise to make a video, but you know what I mean? Like what was happening in the family court that incited something in the criminal case? Because I'm thinking that's why she got erratic toward the end when she went through all those lawyers was when all this family. Now, Padilla was already gone. Padilla was gone in 2022. So right before court, right before her trial. I don't know. She was delaying it for a long time for some reason or another. Maybe when she was like, if it's really going to happen, she thought like, oh, if it drags on long enough, we all know statute of limitations for murder is forever. There is no limit, you know? Anyway, I'm rambling. Thank you for hanging out with me. Hello, my true crime lovelies. How are you? So, back to Sarah Boone. She has filed a motion to withdraw, but it's a motion to withdraw her motion. Seems like her friends in the bushes told her we found all the lies. And she's filed a new motion. So let's get into it. All right, let's get into it. First, the shout out to Lazy Gamer. He sent me a note and I actually didn't see it until I saw his video, like, oh, he's looking for me. But there is, I want to go over this document because he figured out that, remember I was like, one of those dates she made up, well, two of them, one she moved up and then the other one I didn't see at all. Well, it turns out there are minutes for September 19th. It just wasn't in 2020. That's why we couldn't find it. It was in 2022. And it's a little juicy. So let's just quickly go through it. This was a hearing. They were, what happened is Brian's attorney moved to, for a trial date to address the motion for, to eliminate or reduce child support. And so that was what this was about. So the court ruling, the court will take no action on the notice for trial filed by Mr. Martel. Mr. Mendoza is the one who appeared that day on behalf of Mr. Martel for petitioner. This is what I want to show you guys, though. Mr. Mendoza will provide an order to the court regarding any child support being vacated temporarily. This will be solely based on Miss Boone's incarceration. And then she completed her change of address form in the open court. So what does that mean? It means Sarah already knows she is not eligible for child support. They already told her that. It's temporarily stayed while she's incarcerated. Nothing has changed. Well, actually, something has changed. She's still incarcerated, but as far as changes related to her getting closer to being home, that has not changed. Now she is, in fact, a convicted murderer. Now she is, in fact, in prison for the rest of her life. So her new motion is rubbish, as we already knew, but let's see. Let's see what her friends in the bushes told her, shall we? I'm going to flip myself here. Okay. In the Circuit Court of the Ninth Judicial Circuit in and for Orange County. So respondent, Sarah Boone, motion to withdraw March 20th, 2025. Previously submitted motion by pro se respondent, Sarah K. Boone. Comes now, pro se respondent, Sarah K. Boone respectfully moves this honorable court to withdraw her motion previously filed on March 20th, 2025 due to unforeseen disconnect and constraints of being incarcerated, causing aforementioned motion to be prematurely submitted and filed. That makes no sense. That's a bunch of word salad. I sent it too early. That's what it should say. Having nothing to do with being incarcerated. The motion contains inaccuracies, oh, we know, girl, that need to be corrected. In the respondent's continued efforts to simplify the process of review on the court's behalf, her continued efforts. Please disregard the former and observe as the respondent's continued good faith and hard-fought efforts to finally be heard in this case. Please review the following replacement motion titled Motion to be Heard during Case Management Conference on Wednesday, March 26, 2025, and requested relief to be ordered by court from petitioner Brian C. Boone to pro se respondent Sarah K. Boone per FLRP Rule 12.110. Thank you for your patience, understanding, and judicial review. And then she's putting the other attorney on the service list. Great. Now let's see what foolishness she's gotten into. This one is half the number of pages for the motion. So 7. We had 14 plus exhibits last time. All right. I'm going to go right into background and procedural history. 1, on June 15th, court entered a final judgment. We got that. February 25th, respondent was incarcerated. We got that. So that's the same as before. Case management conference on September 19th, 2020. So that's the one we just myth busted, right? Because we know it was 2022. And it didn't address, well, I guess it did address what she called noncompliance, but the court clearly said that there was no child support due until she's no longer incarcerated. The court verbally instructed petitioner to resume payments and adhere to the parenting plan. We just read that. It's not in the minutes. Why would they do it and not put it in the minutes? It's her word against the court's at this point. Petitioner ignored the court's instructions. He didn't because there were no such instructions, failed to facilitate visitation and communication, and continued noncompliance with financial obligations. So she's still lying. She wrote a new one, but she's still lying. So we know 4 and 5 are false. On April 12th, 2022, petitioner filed a supplemental petition for modification of final judgment. Oh, so she got that right. They are listening to us in the bushes. Can you guys tell her to knock it off and let her son and his father live their life? She should not be taking money from them. She has a job now. I just saw on that other report, which I'll be sending out later. She is what is it? Something to do with education, an education clerk. I'll have that for you guys later tonight. Anyway, on April 12th, not the Bushes people, the lovelies. On April 12th, 2022, petitioner filed a supplemental petition for modification. So we know that's right. We went over that this weekend. If you missed that video, please check it out because I brought all the receipts. 7, despite no court ruling on this petition, petitioner continued making no payments and denied respondent virtual visitation and regular communication with the minor child. So there was no court ruling because they're waiting until after her criminal case is involved. And the judge said he can't be held in contempt while this is pending. So he did not need to make any more payments. On April 11th, 2023, respondent filed a motion for contempt. So she got that right. It was a whole year later, where in her last filing, she put that it was the day before, making it like Brian was retaliating against her. On April 18th, petitioner filed a motion for continuance, arguing a pending modification petition as well as respondent's incarceration constituted a change in circumstances. And also his loss of job and his wanting to move closer to family. Like she's hiding these things that give legitimacy to his request. Do you know? I don't know why. On April 19th, happy birthday, Mom, 2023, the court granted petitioner's motion for continuance. Yes. Petitioner failed to pay court-ordered alimony. Failure to pay has left respondent without the financial means to retain counsel or afford basic communication items, essential hygiene items. Nobody cares if you are funky or not, Sarah, especially not this judge. Food to maintain blood sugar levels, medical bills, clothing, and other necessities needed in order to live appropriately while incarcerated at the Department of Corrections. So I'm not buying the food sugar, the blood sugar. Like the prison is not going to let you die from low blood sugar. So somebody, that is not Brian's problem. I'm rolling them too far up. Sorry, guys. On March 12th, respondent received a court notice, March 12th, 2025, requiring her to appear for a case management conference on March 26. Sealing family court case. Respondent's criminal case has received national and global media attention as a result. This family law case is covered extensively on social media. Is it me? Extensively? Me and Lazy Gamer? I haven't seen it on court TV. Respondent requests that court seal all files to protect minor child's safety, mental well-being, and possible harassment. You know how you avoid harassment? Stop harassing him. So, and even I would say the most inflammatory thing, dear Sarah and her bitches in the bushes, is those text messages. Those text messages are damning. Way more than anything in these files. Request for mediation. Respondent previously agreed to mediation, which was initiated and granted by the court. That is a lie. They requested mediation in the actual divorce part, but in 2022, she refused. That's the letter, if you guys remember from the family court letter. She might have cancer. She doesn't know when she can go. What does that mean? She wouldn't give a date. And she had a list of questions that they needed to answer prior to engaging with her. Respondent wrote letters to petitioner's attorney requesting information, scheduling dates, and explaining that she had a serious medical condition, parentheses, cancer. Why the extra words? Why not just explain you had cancer? And an impending criminal case, and was cooperative and adamant about scheduling. No, she was not. Go back to video number 2 in Boone v. Boone. She received no response from petitioner's attorney. The letter that she wrote was anything but accommodating at all. She just refused, and she went on with a story about her problems, which nobody cares about. People with cancer go to court all the time. Petitioner told court, and if she would have just given some dates, and then if push came to shove, she could have moved them. She was also asking him for legal advice in that letter, like how would it get rescheduled? Ma'am, call the court or call the jailhouse lawyer. Like inmate, not the real jailhouse lawyer, because we know he does not like you. Petitioner told court that respondent was not participating in mediation, and court subsequently canceled mediation. The court never scheduled mediation. That's not how that works. The attorney was going to be scheduling with you, but you were not participating. We all read the letter. Only in your mind, Sarah, was that participation. While respondent's health is still not stable, her criminal case is resolved, and respondent respectfully requests mediation be resumed. Mediation is extremely important to respondent because she don't want to pay them attorney's fees. We're past mediation, honey. Unless you wrote him a letter and said, here's what you'll concede to, but he doesn't owe you any child support for sure. And I would fight you tooth and nail for alimony, especially all the hell you put them through. Reconsideration of contempt continuance. Petitioner's reliance on Rosenblum v. Rosenblum is misplaced. Noncompliance with court orders is enforceable unless financial incapacity is proven. That is not true. Like that specific case, there was a court who ordered the father to pay for the alimony while it was pending, and that was overturned by the appellate court. They're right there. Florida First District Court of Appeals 2015. So under Department of Revenue v. Jackson, support obligations remain enforceable until legally modified. It is enforceable, but he does not have to pay, and he cannot be held in contempt until until that motion is heard. It's the desperation for me. Petitioner has failed to present any evidence of financial hardship during respondent's incarceration, rendering his noncompliance unjustified to date. It's on record that he was unemployed. He filed the new financials that he had lost his job, probably because of Sarah and him being all over the news, because his employer was in a different state, right? And thank you all for explaining that he could have been in his pajamas that day, February 25th, 2020. Duly noted. Petitioner's actions violate due process and obstruct respondent's access to justice. No, because he did not act alone in not paying that. The court explicitly said, you don't have to do anything until we hear this, and we're not going to hear this until after the criminal case is sorted out. So basically, she's telling the court, you're facilitating him breaking the law, which is balls of a burglar to tell that to a judge. Enforcement of parenting plan and parental alienation relief. Petitioner willfully denies respondent contact with the minor child and excludes her from all decision making in, about, or for his life. You don't need to be included. You didn't want them to move. They've already moved. You had some cockamamie excuse that they stay there, even though you have no family there, they have no family there, and you are not physically seeing him. You could do a video visit from Mars, Australia, as you like to say. So petitioner lies incessantly, threatens to hang up, tells her to shut up, laughs at her, berates her, and gives her silent treatment, wasting invaluable minutes on the telephone. Stop calling him. That's all in your control. Stop calling the petitioner. The minor child is 14 years old. He knows how to work a phone. Petitioner engages in parental alienation, referring to respondent as a killer and a murderer. Those are now factually correct. You are adjudicated a murderer. You are doing life in prison for murdering. You did kill your boyfriend. Those are all accurate descriptions. So what about it? And other emotionally distressing comments in the child's presence, causing minor child to repeat these terms, causing psychological harm to both respondent and minor child. You need to see a therapist if that's causing you harm when people are telling you facts. Florida law, Hunter v. Hunter, Florida 3rd District Court of Appeals, 1989, and Perez v. Perez affirms that incarceration alone does not terminate parental rights. I'm going to look this up tonight, guys, because I haven't researched them, but I've heard she is applying this. But before I put that out there as facts, I got to come with the receipts. Respondent requests the court enforce the existing parenting plan to the petitioner. She's not following by that. We know that from her text when she's like, man up, just tell me if you don't want to talk to me. Establish a schedule for regular virtual contact and engage in all forms of communication needed between respondent and minor child. So who engaged? You want the judge to order the child? Because that is not Brian's responsibility. Engage in all forms. No. Require petitioner to complete an extended co-parenting course on parental alienation, in addition to the already completed online course taken pre-divorce. What about you, ma'am? What about you? Enforcement of alimony obligation. The final judgment mandates petitioner pay $1,000 per month for 84 months to respondent. Petitioner has failed to pay since February 25th, 2020, resulting in $61,000 in arrears. Under Florida law, compliance with the alimony obligation is required unless a party demonstrates financial hardship. Again, he had no job. That is when he filed in 2022 after he lost his job. It's in the court documents. If I know it, you should know it, ma'am. You were at the hearing. Petitioner has not presented any evidence of financial hardship to the court during respondent's incarceration. That is false. Respondent requests the court enforce the alimony order and compel petitioner to fulfill obligations, reducing alimony arrearages by any funds petitioner contributed to respondent during this time frame of her incarceration. Oh, so she's going to give him credit. She is acknowledging that he has given her funds while she's been incarcerated, funds he did not have to give her. Now she wants to give him credit for that against the alimony arrearages. So kind. Oh my God. Respondent requests court to enforce petitioner to provide a current financial affidavit and bank statements confirming income since respondent's incarceration, February 25th, 2020 to the present day. So that ain't nothing but some tax returns. But I hope we don't even have to go there. I hope it doesn't even result in a change in financial circumstances, but rather a change in her freedom in those circumstances. Modification of child support. Respondent requests the court eliminate future child support obligations, allowing petitioner to retain funds for the minor child's expenses. Okay, I'm going to give you in the bushes a point because you clearly got the message to her. And thank goodness. This is the right thing to do for her child. Any funds held in the Florida disbursement unit should be returned to petitioner to be used for the minor child. And these funds uses are to be mutually agreed upon between petitioner and respondent, how and for the proper support of minor child. No, you don't get a say. He doesn't want the fish soap. Property recovery. Respondent lawfully owns personal property, including clothing, furniture, multi-generational heirlooms that you claimed were destroyed by your deceased boyfriend, antiques, jewelry, and also a 2011 Kia Sorento. Petitioner willfully assumed control of these assets and agreed to safekeep and maintain them at no cost. Why would he do that? Why would you ask him to do that while he's a single parent taking care of your shared child? After numerous requests from the respondent, petitioner has failed to return them to the respondent's family and friends. Respondent has heard unverified claims that the vehicle was scrapped and items in a storage locker were sold at auction. That, I don't know who made that claim, but if you guys know, leave it in the comments. I'm curious as to what creator found that. Respondent requests an accounting of personal property whereabouts, including vehicle and items in the storage unit. That has absolutely nothing to do with family court or the judge. Nothing. Your assets, what you guys agreed to, was that in a marital document? Is there a signed contract saying, like, ma'am, desperate, extension of pretrial discovery lines, so discovery deadlines. Okay. She wants an extension. Now she wants more time to not be paid. Respondent avidly and eagerly seeks appointment of counsel to prepare for her defense and simplify timeline. Simplify. An extension will afford her the time needed to secure legal aid while waiting for expectation of pretrial discovery. I doubt they're going to give legal aid, free legal aid to a murderer. Just saying. Requested relief, wherefore, pro se respondent respectfully requests this court seal all family law case files and protection of the minor child, resume mediation proceedings as originally agreed upon by petitioner and respondent, reconsider the motion for contempt continuance to finalize monetary obligations. No, they're not gonna. You don't get to hold off on the final decision and then jump forward your motion for contempt. The motion for contempt is not valid until his motion for elimination or reduction of child support is heard. Rosenblum v. Rosenblum. Enforce the parenting plan to the petitioner, which includes respondent in all decision making. No, ma'am, you left somebody in a suitcase. You don't get to make decisions for anybody else. You barely making them for yourself. Bad ones. That's why you're doing life. Require petitioner, I mean, it's bad decision after bad decision, not take the plea deal, take the stand. Put all those photographs in. You have not personified good decision making. Enforce petitioner's alimony obligation and order all payment of net arrearages. Not going to do that till after his motion to reduce or eliminate is heard. Modify child support obligations as requested, especially the collaboration between petitioner and respondent. He was already told he didn't have to worry about child support back in September of 2022. So you trying to give him a solid so that you can have a collaboration is pitiful. Order the petitioner to inform respondent of all her personal properties whereabouts as described above. Add a scope for the family court. Add a scope. Extend pretrial discovery deadlines to ensure fair participation in proceedings by pro se respondent. Mind you, there is not even a trial date. So she's like, extend the discovery. Ma'am, when's the trial date? Well, hopefully she'll argue this orally on Wednesday. Grant any other relief this court deems just and proper. She sent that to that attorney. I suspect we should be seeing something from Brian's attorney, a response to all the foolishness. So, and if you wonder why I'm fully back, I did not realize, I put this in over the camera and it wasn't completely clear. I thought it was something with my background, but it was something on there. So hopefully you can see me and hear me and let me know what you think. I'm glad she changed the thing about the child support. Do you think she should get some alimony? I know some of you guys are like, maybe $100. I'm saying, why? Why should he have to give her anything? She unalived someone. Like, consequences. All right, I'll talk to you guys down below. Later. Toodles.